Ready to go. The Hatch. The Hatch has joined. The Hatch has joined the stream, folks. William Hatchett, personal injury lawyer, to the stars. Still trying to get set up here. Will, appreciate you tuning in, though, buddy. Let me know. Comment in the chat if you can actually hear me and see me. I am still trying to get this set up. First time live streaming, Will, but let me know if you can hear or see me. Just comment in the chat if you don't mind, buddy. Thanks. Gus McNucci can hear and see. Will Hatch can hear and see. Can't hear the Senate. Yeah, they have not started on audio yet, I don't think. All right, folks. I will be right back. Just getting started here this morning. Still trying to figure out this audio, trying to figure out this video, trying to figure out why I don't have a real shirt on. Going to go live on Instagram here in a minute to follow along. Thank you to everyone who's joined in so far. Drop a comment in the chat box so I know that you're here. Our corrupt, disgusting Senate's about to start here any minute now. Nolan Ryan here, the very famous baseball player.
Good morning. Senate Committee on State Affairs will come to order.
Oh, here's the corruption. Here we go. Now we can get started. This guy's a real piece of shit. So this guy on the right here at the table with the tie and jacket on is leader of state affairs. He really controls all the bills that go through the Senate.
Is the case right here, especially this time of session. Members of the committee are on multiple committees. And those that are not on multiple committees meeting now have bills in other committees that are meeting now.
Comment below if you can hear the Senate audio with my audio. I'm still trying to understand what people can hear. Hopefully you can hear me over this turd.
Thankful for everyone's participation.
And we'll get started here in a second. I will be right back.
Senator Cook and Senator Parker have bills on related topics, so it is our intent to allow the authors to lay out each bill and do invited testimony, and so the topic I'm referring to is e-cigarettes broadly, and so there'd be Senate Bill 1313, 1314, 1316, and 1698. So if you're here to testify on those bills, if you're invited testimony, you'll be called up as the bills are laid out. Then after all those bills are before us, again, we'll open up the floor for public testimony. and let us know which bill or bills you're testifying on, and we'll just move through the agenda. There's one bill today that we expect to have a lot of witnesses on, invited and public, and that is Senate Bill 30, Senator Schwartner's bill. And so that bill will be heard at the end of our agenda. We're going to move through as quickly as we can. We hope to begin that bill before the Senate comes in this afternoon, but we may or may not, but we'll get to it as quickly as we can. But it'll be our plan now, subject to change. Our plan now is to have SB 30 the last one on today's agenda. Sometimes these things change based on availability of members and witnesses, et cetera. So with that, the chair now lays out Senate Bill 1313 and recognizes its author, her colleague Senator Cook, to explain the measure. Good morning.
Good morning. Happy Monday, Chairman and member. Honored to be here with y'all bright and early. Thank you for the opportunity to lay out SB 1313. During the interim, a group of concerned parents reached out to my office when they heard that a smoke shop was opening 2 doors from their children's elementary school. Every day, when the parents drop their children off at school or walk them to the school's entrance, they must pass by a smoke shop retailing harmful tobacco and e-cigarette products. Naturally, the children became curious about these products being sold to smoke shop, especially when these smoke shops use lucrative advertising techniques targeting students, considering that e-cigarettes remain the most commonly used tobacco product among minors. Upon further investigation, our office recognized a trend across Texas, especially in cities like Houston, where smoke shops open and operate near schools. Smoke shops use fictional characters and cartoon-like images in their store logos and advertisements to lure students into their stores. We actually heard from a couple of parents that their kiddos were saying, "That looks so fun, can we go in there after school?" No, please. SB 1313 aims to address these concerning marketing trends by prohibiting smoke shops from employing deceptive marketing techniques to entice minors to purchase and consume harmful tobacco and e-cigarette products. SB 1313 prohibits retailers from using visuals appealing to minors in their shelf logos, signage, or other design mark. Any violation of this section is a Class B misdemeanor.
All right.
And some, it
We are
ensures
live.
physical and mental well-being
We're
of
ready.
future
We're going
generations.
live on the
We do have
Instagram.com.
a committee substitute for this one as well that is ready, and it
Thanks
just
for your
incorporates
patience,
language
folks.
recommendations from the comptroller's office to clear up ambiguity and make enforcement more realistic. If you have
Looks
any
like we're getting
questions, I'll be
started
happy to
here.
answer them, and thank you so much.
Thank you, Senator. And Senator Safran sends up the committee substitute, which the author has explained to us.
They are not talking about the tort reform bill quite yet.
Very well.
We should be getting a text message.
Your invited witnesses, and then we'll
Can't hear her. Well, that's a problem.
the rest of your bills as well.
Perfect. And their testimony may relate to the other 2 bills as well. Okay.
Very good. Thank you. We'll open up testimony on Senate Bill 1313, and the chair calls
We are
Mehdi
talking about
Rice
Senate Bill
and
1313.
Lila
The goal of the channel
Rice.
reason for the live stream today is to try to get the public informed about the latest
Have a seat there next to
corporate
Senator
bailout
Cook. Make
by the
yourselves
insurance
comfortable.
companies. Live on Instagram and YouTube right now from the Texas Senate. And what this is it is a bill for them to murder you with no consequences. Well, not really. But the Senate Bill 30 is the latest insurance scam to pass more and more tort reform to shield their
Whoever, when you're
profits
ready, whoever wants to go
prevent you
first,
from
tell us your
recovering.
name, introduce yourself,
your
and give us your
injuries.
testimony. Welcome.
Now,
We're
we're
glad
going to
you're
be
here.
in and out
Hello, my
of
name is
the
Lila Rais, and I am
Senate
here to
committee
speak in
hearing
support
today.
of
Kinda
Senate
jumping
Bills
back and forth.
1313, 1314, and
right now,
1316 with
obviously,
my
this little
dad.
kid is not a senator,
Smoke
so I've
shops
noticed
should
that
not be so close to
they
my
have done to
school.
prop this kid
The
up.
cartoons and bright signs on
Seems
this
like a good
shop
kid,
look
though. I
fun,
bet this kid
and it is
hates tort reform.
confusing
Look at his
because
face.
what
He
they're
hates it.
selling isn't
His
for
sister
kids,
hates it. These
even
two
though it
people
looks
hate
like it is.
And
My
what we'll
dad
do
and
today
other
is kind of
parents
break
have
down the
worked hard
bill
with
before we
Senator
get
Cook to
started.
write these bills, and I
Why
am
I think
grateful
it's
you're
going to
hearing
pass,
them.
why I think parts of it will
Thank you for your
fail,
consideration.
and what we can all do.
Thank you for your testimony.
stop
It's
this
good to have you
bullshit.
here. Thank you. Welcome. Introduce yourself. Go ahead.
Get this area cleaned up.
Thanks so
here.
much for having us. Hello, my name is Mehdi Reyes, and I'm speaking in support of Senate Bills 1313, 1314, and 1316.
This is a great
Every
peek
morning,
into the
my
legislature.
daughters and
Let's
I
actually
walk
see
to
what they're
school,
talking
and
about.
before
Senate
school, we
Bill
visit the school's playground.
13,
Last year, a
13, as we
smoke
get
and vape
warmed
shop
up
called
here.
Bahama Mama opened 30 feet away from the kids' playground.
Mama.
In fact, the smoking deck of the smoke shop is just across the fence from the playground, and smoke wafts over into the
So
playground
this
where kids
bill-
as young as 4 years old play. The advertisements and signage of this shop does not look
prohibits
geared towards
advertising of
adults,
e-cigarettes.
but
So,
intentionally
not a bad
children
bill. I'm
and
probably
young
in
people.
favor of this.
It feels
Creates it a
like
criminal
deliberate
offense to prohibit
stimulation
signs,
to draw
logos,
children in. My
or
youngest
marketing of
started to
cigarettes,
ask if we could
e-cigarettes, or
go
other
in
tobacco
there because it
products.
looked fun.
So don't really have a problem with that bill at all. And the reason that they bring this up, and the reason he probably has his son and daughter here, which is really cool to see, is that he doesn't like that you can advertise e-cigarettes near his kid's playground. I completely agree. I don't want that. So what you do in the Texas legislature is you have the ability, either as a member of the legislature or the public, you can go down and actually give live testimony. I don't know if this guy is the bill's sponsor. Thanks to everyone joining us here on Instagram. Follow on YouTube to get live stream of the Senate. It's on mute right now, but we're following along. As I was saying, though, what's great about our Texas House and Senate is that they do actually offer a live stream and allows the public to view this stuff, view the bills that are being debated that actually affect all of our lives, whether you realize it or not. It kind of gives you a peek into how the sausage is made. And once they start talking about the new tort reform bill, which is SB 30/House Bill 4806, I'll do a deep dive into how that affects you, how could it affects the public, how could it affect your personal injury case. And so let's go ahead and pull up a copy of the bill. And if you have any questions, like I said, this is my first time doing a live stream. I don't even know if anybody can hear me. I think my dear friends Nolan and Steve have commented they could. I got the Senate committee on mute right now.
This is one of the most incredible things I've ever pulled out.
And I lost my train of thought. Oh, as I was saying, this is our first time doing this, but very excited. Hopefully, this will bring more attention to the new tort reform bill, or even just a peek into the work at our legislature. Even if you're saying, well, who gives a shit about some tort reform bill for personal injury lawyers, at least you might get a peek today of how your local legislature works, because it's so important, and 99% of people don't even know that they have the ability to testify in favor or against bills, don't even know that they can watch bills being debated. So hopefully that gives everybody a sneak peek into that. Let's see what this lady's talking about.
And I said, then why do these not teenagers, but why do these minors who know that it's illegal to buy tobacco products buy them anyway? And he said to me, and I will never forget, Mr. Chairman, it was in this building in my office.
I don't
He
think
said to
she
me,
is smoking
because if you get
e-cigs.
caught,
She's got
nobody
great
does
hair, though.
anything about it, and we all know it, and that's why no one respects the government. I came back and changed my bill.
If I may offer,
might be
one
the
of the
bill
bills that
author.
is in this package that has not yet received a
Every
hearing is one to
bill,
prohibit
regardless of
minors
who's
from going
really
into
funding
these
it
shops,
or
period. So it
who
brings everything up to
has
alcohol
written it
par.
has to be
And then you actually do have to
introduced
break an
by a member of
existing
the
law
Senate
in order to
or
still
the
get your
House.
hands on it.
It's introduced in the
my
Senate.
opinion, like from
Usually
a
they're
public health
parallel,
perspective, the further
bills.
upstream
So,
you go,
like
the
today,
more
we'll
effective
talk
your
about SB
intervention
30,
is.
which
You're
is
kind of
House
closer
Bill
to the fulcrum.
4806.
So
It's the exact
if
same
we
bill.
were able to
It's just
pass all of
introduced in
these, and then a
both
student still had to use a
legislatures.
fake
And today it'll be
ID to
heard
go and
in the
purchase, then
Senate
you're
by
kind
the
of
State
capturing it
Affairs.
on both sides.
Well, I went back and changed my bill and got the support, and the governor changed, it was Ann Richards,
Committee,
she
I
changed
don't
her
know why.
position, the
Somebody
Lieutenant
does
Governor
know why
Bob
it's
Bullock.
before
We
the
all
State
changed our
Affairs instead of
position
the
based on that one minor.
Senate Judiciary
and what he
Committee.
said.
I'd like to know.
Yeah,
I'm
we
pretty
talked traditional
curious.
ones after that, but that's what he said. Nobody does anything to us, who cares? And so the penalty was, of course, community service. So it was just lesson learned, something constructive.
If you're on YouTube,
Not
please
jail time.
join us, or if you're on Instagram,
Indeed.
right here.
Senator Paxton, you're
Please
recognized.
join us
Thank you,
on my
Mr.
YouTube
Chairman.
channel.
I had a
at
question
your
for Senator
Dallas
Zaffarini.
Lawyer,
The
where we have our
acoustics in
live stream.
here
We've got a bunch of people
terrible.
in the chat right
What
now.
was the reason that
just getting warmed up.
the
They
minor
are
gave
not
you for
talking
why they
about
did
the
not They and
Tort
the
reform
two
bill
friends
yet.
did
He
not.
said that 3 of the 10 did
But
not
like I've
smoke or
said
drink. And I said, and
little
why
bit
don't
earlier,
those 3 smoke or
we are
drink?
just getting
And he
warmed up.
said, because we're athletes.
Because
Oh,
we're
Adam Holden,
athletes. Okay.
Sam Jarvis,
The
Kevin
word just
Edwards,
kind of
everybody's
reverberated.
on
It was hard to
Instagram. It's good to
understand
see you
because
guys.
we're
Thanks for
athletes.
tuning in.
Well,
So let's
and we
talk
all
a
know
little
that,
bit now
a lot of this starts
about
at home, right?
the bill
That's good peer pressure
that's being
and
heard
good adult
today.
influences teaching those kids that,
Yes.
you need.
Let me switch over. To the text of the bill so everybody can take a look at what we're talking about here. This, you can actually look up any bill you want that's currently in the legislature. This is Senate Bill 30. This is the tort reform bill. The reason we are all here today. And I've taken us off of the live stream so we can take a look at the text of the bill. There's a bunch of different parts. I don't know if you can see the bill. Hopefully this is coming through. I don't really know, but we'll keep talking. So, Senate Bill 30. The first part of the bill is interesting. It talks about affidavits, controverting affidavits, which in a personal injury case, really just a bunch of talk about how you get your medical bills admitted during or before trial. So I'm really not too worried about this. What they're trying to do on this portion of Senate Bill 30 is really just make it harder for personal injury lawyers to recover any medical bills in your personal injury case. What they want to do is they want to make it extreme. By they, I mean the tort reformers and the insurance industry, is just make it ridiculously expensive for you to bring your case to court. Because if it's more expensive to bring your case to court, it's more likely you'll settle for cheap and the insurance companies can take more and more profit. Or it's more likely that you maybe won't hire an attorney, or it's not as profitable for attorneys to bring your personal injury case. That's the whole point of this first section of the bill. It doesn't prevent you from introducing your medical bills and records, doesn't do that. What it is going to do, though, is it allows the defense, once they file their controverting, by controverting what they mean is they dispute that your medical bills and records, mostly your bills, were reasonable and necessary, and allows the defense to say, hey, we dispute the amount of these bills. Now, plaintiff, you got to bring all your doctors to testify to trial, or you need to go take all their depositions. Well, that's crazy expensive and super, super boring. If you served on a jury before, the last thing that you want to watch is a bunch of
Need to
deposition
take care of your
tapes.
body. It's your body.
It sucks.
For Cook.
Thank you, Mr. Chairman and members. Thank you for the opportunity to
Checking-
lay
hold
out
on,
SB
checking in on the
1316, which
We're
closes
still
an
talking about 1316. Okay. So, like I was saying, though, this first part of the bill is really just talking about affidavits, counter affidavits, timelines for serving counter affidavits. And then we get to a very interesting part of the bill. Thank you to everyone on Instagram. Hey, Instagram. How my folks doing on YouTube? When is the Adam Holden with a great question? When is the audience question portion of the presentation? Well, Adam, I know that you're on Instagram watching live. Would love to have you join in. I think on YouTube, I can have you join in, or I could have you Zoom in, I think. Like I said, I apologize to everyone. I don't have a lot of experience with this, but I'm so pissed off about this stupid ass bill that I wanted to hop on YouTube, because I think YouTube is the most effective way to get this information out, get it to the public. Let's get people talking, and let's get people opposed to it, especially my friends on the defense side of the V, such as Adam Holden, a great defense lawyer, because it's going to put them out of jobs too. And most defense lawyers, I think Adam will agree with me here, really are not trying to limit plaintiffs' recovery. They want to pay plaintiffs, they want to ensure that they get a just recovery, a fair recovery. And this bill actually goes so far as to let's just eliminate the defense lawyers because we won't need them if your damages are not recoverable or they're capped. I think most insurance defense lawyers or defense lawyers will, I think, eventually oppose this bill. But again, YouTube is a great way to get this out in the public. Let's get people talking. But I don't know, Adam, if you're still with me on the Instagram, I think I can add you. I think you dropped off though. Just sent you an invite on the Instagram. Let's see if that works. I don't know if it will. Adam comments, this bill hurts both sides. And he's exactly right. Why does it hurt both sides? Because it also limits what evidence the defense lawyer can bring in a trial. We'll get to that here in a second. As we're talking about the controverting affidavit section, thank you, Jack, for the comment. Appreciate you, buddy. Jack Kelly, very famous consumer lawyer here in Dallas, Texas, currently fighting a bunch of cases on behalf or against Toyota for some doors that won't lock and can allow you to be killed. So, Jack Kelly, look him up, great guy. But let's go back to the section on controverting affidavits. On controverting affidavits, we've gone through what the deadlines were, what's the purpose of them. I hope that was about as clear as mud. And now we get to the charges. And this is a very, very interesting part of the bill. In personal injury litigation, let's say you get in a car wreck. You go to the doctor. The doctor treats you at the ER. The bill comes out to $5,000. Well, the defense might say, or hire an expert to say, hey, that's really not worth $5,000. The hospital charged too much. We see that all the time. If you've had a baby, you get that bill in the mail, you're like, what the hell? You're charging me $5,000 for an IV? No, I'm not paying that. And you dispute it. It's the same thing in a personal injury case. Some providers or hospitals might overcharge in this example of $5,000. The defense says, hey, this bill shouldn't be $5,000. It should really be like $3,000. What this bill does, Senate Bill 30, the latest tort reform scam, says, hey, if you have a charge that is not reasonable or excessive, we need to come up with a number or come up with a way to show, well, how does this compare to other hospitals in the state? If we're just going with my example of the $5,000 hospital bill. Well, we're going to come up with a database that no one gets to see, is not live yet. No one has no idea how this thing works. And the defense can say, look, this amount is not in line with the public because according to this database down in Austin at the University of Texas, it's not within 150% of the median amount paid by other facilities or providers. The way I read the bill is that it's essentially saying, look, the insurance company should only have to pay for medical bills that are about the same rate as Medicare or Medicaid. And this screws over everybody. It screws over your case because the plaintiff, you're not at fault for what the hospital charged. You don't get to control what the price is of an X-ray or an MRI. But instead, we're getting some back and forth here with Nolan McConville and Adam Holden. Great comment by Nolan McConville. Hey, appreciate you acknowledging that this hurts the defense bar. And see, everybody says plaintiffs' lawyers and defense lawyers hate each other. For the most part, that's not true. I've had cases where I love the defense lawyer. Great friends. Some of my best friends are defense lawyers. And Nolan and Adam in the chat showing, hey, look, we can both have our fights, still get along, and still fight against what goes against the public. So let's go back to this 18001 stuff, or I guess here, which will be 180011, which will essentially cap the amounts that the plaintiff's lawyer can bring into evidence as to what your medical bills are, even though it's not your fault. Here's the biggest problem with this bill, is this section of the bill, let me say. This section of the bill is that it's really going to kill rural hospitals. There are hospitals, you go into East Texas, far West Texas, that are low population, maybe one doctor, and now the Texas legislature is saying, Doc, we don't care what you charge. You're now capped at 150% of whatever other facilities in this database charge in a personal injury case. Well, the doctor has no input on that. None of these doctors right now even know this exists. So what happens is it's really, oh, wait a second. Somebody's getting some weed out on the Texas State Legislature. We got to switch over. Hold on, folks. We got to switch over. Wait a minute. Homegirl pulling out some weed gummies.
Colorfulness of
Oh,
this.
absolutely. And you'll turn it on, when you'll turn it on, and then you'll see the screen, looks like a little video screen. I mean,
Wow,
and then
really?
you'll see the smells. I mean, you'll smell strawberries and bubble gum and,
Strawberries. I like
all kinds of
strawberries.
stuff. I mean,
Well,
it's,
Pineapple punch.
there you go.
That's,
There you
I
go.
know
That
that's
one's
what
pineapple punch.
Senator
I know we
Dean
got some
Zaffarini goes
strawberry
for all the
and
time.
bubble gum.
She's always after the pineapple.
You got cherry,
Pineapple. Ooh,
Dean
Zaffarini
Zaffarini.
likes that pineapple
So,
punch.
look, that's the issue.
Okay.
I know it's tough to be in business. We recognize that this directory
It looks like what
takes
they're
away
debating,
the
which they
challenges
always do
for
on
a
these tobacco
retailer.
bills is,
They'll be very clearly
hey,
go to a directory and understand
this
what's
is targeting
appropriate, what's
kids.
not for their
Actually, in a
shelves.
case with
But we've
Jack
got to
Kelly,
protect our
who
children. We've got to take
commented
this
earlier,
seriously.
Well,
along with
I would
Austin
like to
Smith and Bruce
applaud
Steckler,
the fantastic marketing
about
that
this
this
exact marketing.
is.
They
This
are
is a great
targeting
example
kids.
of marketing. The problem is,
That's exactly
it is marketing
what
to
they're freaking
children.
doing.
And I
They
don't
make it
applaud
strawberry
that.
cheesecake
That's-
flavor, so
that's
little
the
kids
wrong way
go
to
and
go. So
smoke that
thank you,
shit
Senator Parker.
or eat it like
and
she's
illegal
showing.
in China. A lot of the packaging will say that as well.
Wow.
But it's okay to flood our market here with it. So just to be very clear.
Thank
Great point by this guy. I like his time.
Thanks, sir.
Great point by this guy that, yeah, China's flooding our
Thank you,
market
Mr. Chairman.
with
Senator Parker, did you at all track, or would
these,
you consider tracking the restrictions for
horrible flavors of
exposing
products
minors
that
to
just
tobacco
get the
products?
kids addicted because they're
Yes.
because that's the goal.
I mean,
You want
I think
if you're a
I think
tobacco
that's
company,
important.
you want these
Again,
kids addicted as
we should be
early
protecting our
and
minor
often
children.
as
That's the
possible because
focus
then they're
of
going
But
to
I
be
think if
smoking.
we
They're
track
going to be a
that,
customer
the
for life.
restrictions that we have now.
So
for
let's
minor-
cut this off. Let's get back to the oh so exciting portion of the bill, and I think I lost it. That is not good. Now I can't get back to the text of the bill. Well, let's do this. Can't get back to the text of the bill, but I'll read it along as everybody here follows along. If you're on Instagram, please join us over on YouTube. Adam Holden's over there calling people out, yelling, screaming at plaintiffs' lawyers how they should all shut down their businesses. So please tune in over there. YouTube channel is your YOUR Dallas Lawyer. Check us out over there. We're back talking about the counter affidavit section. Like I was saying, this is going to be a huge problem for our small rural hospitals in West and East Texas because it's big government coming in saying, hey, we don't like the prices that people are recovering here on these personal injury suits. So we're going to screw over the doctor, even though they don't know this bill is happening, and cap what amounts they can charge for treating a personal injury client. Now, if you've ever been in a personal injury case, you've ever been in a car wreck, and you try to go to your PCP, at least I deal with this a lot of PCPs won't even treat a car wreck client because they don't want to get involved with the lack of payment by insurance companies. Doctors know if I treat a car wreck client, it's going to take forever for me to get paid. So they just don't treat anybody who's been a victim of a personal injury case. So you have this huge conflict. Well, not only now, we already have doctors who won't treat you if you're a personal injury victim. Then if they do, they're capped at 150% reimbursement. So not only does the victim, who has no control over what the facility charges, get screwed, the doctor then gets screwed because they're not going to get paid as much. And they didn't have the ability to negotiate what amounts they would get paid. Instead, they're going to institute this University of Texas database that isn't live and no one has even seen. I mean, it's just nuts. But not shocking by our corrupt Texas legislature. Comment by Monica Lytle. Don't know who that is. She sounds cute, but not good. Wow, not good. That's exactly right, Monica. Thanks for joining us today. Look at Adam and Nolan in the chat agreeing. Nice to see both sides. Nice to see you here, Mr. McConville. We are all about providing and bringing the community together. You gotta love people from both sides coming together to say, hey, this tort reform is bullshit. So, if there's any questions, please drop a comment on YouTube, drop a comment on Instagram. Let us know what you think. It's going to be a very long day. I need to drop the live stream. Nolan McConville text messaging me. Oh, I can hear you. Thanks, Nolan. I appreciate that, buddy. We're going to be going all day today because we're not stopping. We're not letting them pass this bullshit, or at least we're going to have our voices heard. And at the end of the day, maybe try to inform the public as to what's happening. Because if you're not educated, you can't know, you can't fight. Need to do some updates here. Let's update the Facebook. Let's update the LinkedIn. If you're following me on LinkedIn, you know how passionate I am and how annoying I am about tort reform. And I'm not going to apologize for it because it's bullshit. Please feel free to share this live stream with friends, family. Let them know that we're talking about this bill, or say, hey, Jim's crazy. I don't know what he's whining about, but this is kind of cool to see how the sausage is made in the Texas legislature. Hell, you even get to see some cool fashion. Look at this guy's tie. That's a good looking tie. Comment below if you've even been to the Capitol. I've been once. I went with a guy named Austin Smith. His dad took us when we were kids, and it is really cool. Look at this. This guy's got cufflinks, fashion forward. Head of State Affairs, this guy right here. Got an intern picking a booger. Not a good look, buddy. But that's okay. The other thing I want to spend some time talking about today is, well, what's the goal? What is the goal of the bill? And why is it being sold to the public as lowering, as they always do, lowering insurance premiums? If you're like me, your insurance premiums have gone up and up and up every single year for car insurance, home insurance, property insurance. Sorry, the ADD kicked in. Had to post the link to facebook.com. Hell of a website. To get more people joining in. Thank you, Jack Kelly, for the comment. I appreciate you, my friend. So the idea or the narrative that's being passed with tort reform is that if we pass this tort reform and end nuclear verdicts, we'll get to that here in a moment, your insurance premiums will go down. They'll get lower because if we're not having to pay claims, especially the frivolous claims that lawyers such as myself, Jack Kelly, Noel McConville, Steve Chapa all file. We love filing frivolous claims because you always get paid on the frivolous ones. If we get rid of those claims, or really all claims, then the insurance company can lower the price of our products. You get to keep more money in your pocket. We want to dive in today. Is that true? Has it ever worked? Because it sounds logical, doesn't it? It sounds like if the insurance company doesn't have to pay out on claims, they can lower their price. Shocker, it's bullshit. It's bullshit, it's bullshit, it's bullshit. Doesn't happen. I think YouTube might get a little perturbed at me for cussing so much, so I'm gonna stop that. Especially if people got this on in their car, got the kids listening in. I'll try to limit that if I can. And the truth is, it's never lowered premiums. It's never worked. No state that has passed tort reform has actually resulted in lower premiums. We'll go through some examples today. We'll go through what's just happened in Georgia. We'll go through what's happened in Louisiana, one of the most popular pro-tort reform states in the Union. They've done it in California, Iowa, Missouri, Oklahoma. It hasn't worked. And what the insurance company says is, well, that's because we either haven't had enough time or you didn't let us push enough tort reform in order for it to work. Updating the LinkedIn, letting people know, hey, tune in, join Jack, Monica, Adam, Nolan, Steve, join us for the live stream. I need to figure out a way that I could live stream on YouTube, Facebook, and Instagram all at the same time. If you know how to do that, or if you have any tips at all, like, hey, we can't even hear you, hey, you sound like an idiot, please tell me. Never done this before, but we're having fun so far. Posting to the LinkedIn.com. I really hope that some of the insurance adjusters on LinkedIn jump in to the YouTube channel so we can start screaming at them, because that would be really fun. I would get a huge kick out of that. And we need to figure out how to bring some of our folks in here to join. I wish there was a way. Coastal Energy Line Group, sure, you can submit a new case. Just do it on my website, www.golflawdfw.com. Always looking to help people. If anybody knows of a way that I could merge someone into the YouTube live stream outside of, I'm thinking, Zoom, please let me know. Would love to have some people join in so I'm not just yapping to myself all day. And it's going to be a long one. Let's check in on our Senate, State Senate. Let's see what they're talking about.
I will note the FDA does have a very easily searchable and accessible database of the 34 products that have received authorization.
Oh,
we strongly encourage
the
this body to
FDA.
look at
Hey,
proven,
let's talk about one of the
effective
most
policies to reduce
corrupt
tobacco use
freaking
and reject
agencies in
Senate
the
Bill
world,
1698
the
in its current
FDA.
form.
You know what, folks? I'm going to get a little bit political today. We need to shut the FDA down. Let me run the FDA.
And
You know
we'll
why
have
the FDA
questions
is
at the end of the
corrupt?
panel
It's
for
because these
everybody, so thanks for
pharmaceutical
your testimony.
companies do
Welcome,
nothing but
introduce yourself,
bribe
tell us what bills you're here
the
on.
people
and
running the
go ahead.
FDA
Hi,
and then
committee.
hire
Can you hear
them
me? Hi, Chair
as
Hughes, Vice Chair
lobbyists
Paxton,
to
committee
make sure
members.
they're never
I'm
held accountable.
Dr. Sheila Gavala. I'm a pediatrician in Houston. I'm representing the Texas Medical Association, the Texas Pediatric Society, and the Texas Public Health Coalition. We are here in support of Senate Bill 1313, 1314, and 1316, all measures that we think will reduce e-cigarette use in youth. However, I'll spend the majority of my time discussing
Oh, she's talking
Senate
about
Bill
e-cigarette.
1698,
Okay, we're still on
which we
the
respectfully
e-cigarette
oppose.
bill 1330.
Tobacco use, including e-cigarette
Again,
use, is one of the
we
leading
don't
causes
know,
of preventable illness and
y'all,
death in
when
Texas.
they're going to talk about the
2
tort reform
million
bill. This
youth,
is
based
also a
on
strategy
2024
by
data, are addicted to
House
these
and
products.
Senate Republicans.
The staggering health costs exceeding
well,
$10 billion
it's not just them either.
annually
I mean,
represent a
Democrats do this
significant
too. What
drain
they'll
on
do
our
is when they
state's
really want
resources.
something
And these funds could be better
to-
allocated to vital services.
to pass or to get through our legislature quickly, they'll set it for hearing on a Friday, or the notice for hearing on a Friday to go forward on that following Monday, so no one knows about it. Nobody tunes in. Nobody tunes in. None of the public know about it, and most importantly, nobody in the public will show up to testify against the bill, because the less the public know, the more bills that our legislature can pass for their corporate oligarchs. Got a text message from Jack Kelly. Jack Kelly, how do I use GPT, ChatGPT? ChatGPT is pretty cool, Jack Kelly. I would definitely use it. Jack Kelly also commenting on the YouTube channel. Great content for those who are just joining. Those who are just joining, could you give us a quick recap about today's events topics? Yeah. So, Jack, what we're going to do today is we're going to do a live stream of the Texas Senate Committee on State Affairs, which is hearing a new tort reform bill, which limits medical expenses, whole claims you're not going to be able to bring, and caps, in my opinion, caps damages. The legislature is going to go through all that. So we're going to break that down bit by bit. We're going to go through the bill itself. We were doing that a little bit earlier. Then I couldn't figure out how to do share screen because your boy's struggling. So that's what we're mainly talking about. But we're also providing a look into the background of the legislature. Most people, like I didn't even know you could watch this stuff. Now I'm kind of weirdly obsessed with it, that you could go in and watch your legislature. You can watch what bills they're passing, watch how the sausage is made, which provides you as the public the ability to let your local representatives know, hey, I don't like this, or hey, I do like this. Say you're watching this today, you're like, hey, this bill sounds badass. I think that my family's life is worth 250 grand, no more. Then you need to call your state senators and House reps for your area. I'll show you how to look those up so you'll know who to contact, or the members of the committee, and say, hey, I want to vote for this bill, or I want you to vote on my behalf for or against this bill. So that's a little bit about what we're going into, Jack. What they're talking about right now is Bill 1313, which has to do with e-cigarettes. We talked a little bit about that earlier. And it seems to me
hazardous chemicals. To
they're
your
really
question,
focusing
it also
on
lists the ingredients, the environmental assessments,
how do
those
we
things. Those are things that we need in Texas.
limit the advertising related to e-cigarettes or tobacco
their
products
way into
because
the American Legislative Exchange Council.
They're targeting
and
kids.
to quote them
Shocker,
directly,
they're targeting kids because kids
prohibitive policies,
will smoke
including
longer
bans on
and
flavored
use their products
tobacco,
longer. The
meant
longer
to
somebody
protect children
uses
and
your
teens,
product,
create so much unintended consequences,
the
illicit
longer
markets, and burdens
you
on
can make
law
money off of
enforcement.
them.
It's a burden on the criminal justice system, said Martin King, Altria's senator director. If that's how they feel, why are they pushing a ban in Texas? In other words, they do that because it's better for their bottom dollar. I like responsible harm reduction. We don't want this in the hands of kids at all. So, including
Good point.
every state that
Another
has done
comment by
anything
Jack
like this
Kelly.
has seen a
Thank you,
20% increase in
Keeping it
the black
100.
market. However,
kids
we can
say.
do better. We can have a
Thanks for
Texas
watching on Instagram. I
that is
can't tell
tied to
who's
an STN number. That means they've done the science.
with us
So
on
I do
Instagram.
advocate. I'm
But I
voting.
appreciate
I'm
you
on
if you are.
this bill.
Give Trevor Brown a
because I've
wave,
been
give
working
Nick a
with
wave,
Brennan
give Charles a
to
wave.
talk about how we can change this to be a Texas first, and that's really my goal. Texas first. So that's SB 1698.
You know how I
you wanna do
can
questions?
see you.
Yeah.
No, go ahead.
Okay.
Give us your position on all the bills, and we'll see about
Let
the
me
questions
know
at the
or
end.
comment on
SB
Instagram.
1313. We are in support of SB 1313 with the AVM.
How we
But,
can do that.
however, there's some reasons why I love the bill. One, it doesn't say
Oh, comment
what
from
type of
Jack.
retail
Hard to hear
establishment.
you when the
So
stream
you don't
audio
have an
is on.
exclusion for any type of tobacco establishment. You have all
Let me
establishments.
turn that down then, Jack. Let me know if that is any better.
We do feel that there's a packaging bill that we helped push with
That is one thing I don't know how. There is a desktop
a
audio
lot of that in it, but Senator Perry's bill,
feature,
SB
but I don't
2024,
know
goes
how to lower that audio while I'm still able to hear it. If anybody has any knowledge on how this live stream stuff worked, let me know. I lost our live YouTube chat. You know, we're talking a lot about how the sausage is made here in the legislature. Well, we're seeing how the sausage is made here on YouTube. Jack Kelly, do you think the public perception of tort reform is accurate? I think the thing about the public perception is that most people in the public do not know that tort reform was even passed in the state that they live in. Why? Because it's not a sexy topic. And most people don't think, hey, I'm never going to be in an injury suit. I'm never going to have to sue someone for an accident. So they say, well, or they just don't think about it. I mean, it's pretty rare for 99% of the people, it's pretty rare to get involved in an accident or in a car crash or in a slip and fall or to have your water poisoned by PFAS. So it really just goes unrecognized. I also blame the personal injury lawyers for this. We have done a terrible job of educating the public on what laws are being passed and how your rights are effective. I think with a new, younger generation of attorneys, we're doing a better job through social media, through YouTube, through TV, on educating the public as to what's going on behind the scenes by the corporate oligarchs that are the insurance companies. So the public perception, and another thing about the public perception is Jack asks here on YouTube is that most of the public sees personal injury lawyers as greedy scumbags. They see us as ambulance chasers, again, because we've done a terrible job as to marketing the job that we do to help protect the public, or we get a big recovery and what do? We brag about it. We show off our money, none of which helps the public. So a lot of the public perception, maybe it's inaccurate, maybe it's not, but ultimately the problem is that it's on both sides of the aisle. The insurance company is always going to be pro-tort reform, and they're going to convince the public of tort reform. The biggest example of that would be the hot coffee case, the McDonald's cup of coffee case, where the insurance companies went on probably the most successful PR campaign in the history of public relations or marketing to pass tort reform, which is they spent billions and billions of dollars to convince the public that the hot coffee case was frivolous. They sold it as, well, if you spill a cup of coffee on yourself, it's your fault. They took that and said, all right, we're going to take this case with this little old lady who had third-degree burns and skin grafts as a way to socialize our losses. Because keep in mind, that's what the insurance company is trying to do by passing tort reform. If we don't have to pay injured parties or our own insureds, we take in more money and those losses are borne on the public. If a hospital bill is not paid back, who pays for it? Us, the taxpayers. So when the public hears about tort reform, they say, yeah, it sounds good to me. I see all these personal injury billboards bragging about the millions and millions of dollars these people are making, and I don't think it's fair. I got hurt. I didn't get $1 million, which is it's very easy to relate to. We all have friends and family that we have met and they have gotten into an accident and they didn't get anything. Either they got a lot and didn't deserve it. They got in a minor accident, got a bunch of money, hurts the public perception. Alternatively, someone gets in an accident, they get a ton of money. Well, then you're like, well, they got a ton of money for something that was minor, or they didn't get enough. They didn't get any money for an accident that was major. So both sides of it is what leads credence to the public perception of tort reform, 99% of which is about education and a lack of education. And number 3, big media has done a horrible job of telling the truth on this. As Jack mentioned here on YouTube, there was a recent Starbucks case where the victim was awarded $50 million. And as soon as I saw the verdict by Nick Rowley, I said the media is going to publish this, completely, they're going to butcher this case, just like they did the hot coffee case. And what did they do? Like they always do, they butchered the case. They sold it as a lottery, that the young man who had his penis completely like burnt off, horrible case, got a runaway jury verdict, or what we'll refer to throughout the day as a nuclear verdict, and we'll get into why that is also complete BS. Let me check in here with our legislature, see what we're talking about, see if we're still on House Bill 1313.
Holly Veal, Scott Rand. Oh, that's okay. Hold tight. We'll call you on the next one. Sorry about that. We want to get everybody we could. Thank you very much. We'll start over here on.
But I hope that answers your question, Jacqueline.
Right. And so on the
At
end of the
least,
table, get close to the
is the
microphone.
public perception
Yes,
of
sir.
tort reform
Introduce yourself.
accurate?
Okay, go ahead.
And I think the number one culprit is us.
And members of the Senate State Affairs Committee. My name is Scott Rand, and I'm here on behalf of Rand Oil Company from Beaumont in support of the Senate Bill 1698.
1698. All right, now they've moved on to a different bill. We're not talking about the tobacco bill. Let's see what this one's about.
Retail stores in the Beaumont area. My family's been in business.
Senate Bill 1698. Let's see what this is about.
We employ approximately 40 people. And we're proud supporters of our local communities. Vapor is the second largest tobacco category.
This is also about tobacco.
In a state of disarray.
You see, it might be House Bill
Because it's been flooded
1618.
Chinese national tobacco monopoly, illegal.
I can't find it.
And that puts a tremendous burden on small business or even larger store chains.
He's talking about tobacco. I don't think it's 1618. I don't think I heard that correctly. Comment on YouTube or Instagram. If you're on Instagram, join us over on YouTube, talking about tort reform today. Live coverage of Senate Bill 30, House Bill 4806, which is another attempt by the insurance companies to value your life as less than what it's worth, or your family's lives.
Understanding of what is and what isn't legal.
But I'm not sure what
We're just kind of,
bill this guy's talking about.
I don't think that the vapor, this list will in any way curtail the consumer's choice for these products. There's over 350.
Sounds like he might be in favor of the bill.
They just wouldn't have access to the illegal Chinese.
Sounds like he might be in favor of the bill. So, talking about China.
Imported illegally. They're not subject to any kind of
1698. Thank you. Senate Bill 1698. Let's take a look. Jack Kelly, Clutch, product liability lawyer of the Stars. Let's go back to one of Jack's other questions. Do you feel there are misconceptions about tort reform's impact? Hell yeah. It's BS. Here's the real thing behind tort reform. It's never going to lower your premiums. It's never happened. And when they pass tort reform, they never hear from the insurance companies as to how the insurance companies will say, hey, this is going to lower premiums, because it doesn't. It doesn't lower premiums because it's never worked. In today's bill, Senate Bill 30, there's not one word about insurance. If it's truly meant to lower insurance premiums, why don't they discuss in the bill insurance premiums, such as if the bill says this bill will cap all damages at $250,000 as a measure to lower insurance premiums, it would give the insurance companies a direct tie to that specific provision, and it would allow the public to say, hey, you pass this bill which says our claims are limited at $250,000 as a measure to lower the premiums. Well, the premiums haven't come down, so you're violating the statute. That would be a check on the insurance companies, but they don't do that. They don't even mention anything about insurance in the bill. And why is that? because it's all a ruse and a disguise in an effort, a genius effort, to be honest, by the insurance companies to put all the onus on the plaintiff's lawyers because everyone hates us anyways. So if you pass a bill that's anti-plaintiff's lawyers, it's going to be much more popular in the public than a insurance reform. It's just not as sexy. Hey, we want to reform insurance. I'm already falling asleep just thinking about it. So is everybody in the chat. So I think the impact is just awful. I mean, if you even Google things such as, does tort reform, look, it auto-completes, does tort reform reduce healthcare costs? The evidence is mixed. Some studies show no significant impacts because there's no studies on it. If you go, when we watch today, I'm really interested to hear if a single member of the insurance industry testifies for or against the bill, because there's no stats that are ever introduced in these tort reform bills showing, hey, this is how it's going to lower premiums. Hey, this is how we're going to use our savings. This is why premiums are increasing. One thing we'll go through today is I've downloaded some of the fiscal reports from the insurance companies directly, such as State Farm, where what do they say? Do they blame personal injury litigation for the rise of premiums? Nope. If you read their financial statements, their quarterly reports, the number one problem or the number one reason premiums are going up is losses on the property side from natural disasters. We've all seen or heard on the news about the hurricanes, the tornadoes. We're going through some mass devastation on home properties, commercial properties because of extreme weather events. So, because the insurance companies are losing money related to coverage over property damage caused by weather events, they're going on the auto side and saying, well, look, shit, now we're only making money on auto, we're losing money on property. Well, how do we make more money on auto without paying out more on property? Or we're losing so much on property that we just can't afford to pay out more. Well, let's just raise the rates on auto to offset the losses we are having on the property side because of these extreme weather events. It's really, to be honest, it's fraud. But one of the reasons we're here today is the public doesn't know about it. And the insurance companies are worth billions of dollars and they can lie to you without any consequences. Think about it this way, folks. If the insurance companies say, hey, premiums are rising, we are going to pass tort reform to lower your insurance premiums, and it does pass, there's nothing requiring the insurance companies to actually lower the premiums. There's no part of the statute, there's no part of the law, and because the public doesn't know about the laws or that the reforms are being passed, there's no incentive for the insurance company to actually do it. I mean, we all remember COVID, right? Nobody was driving during COVID. Did any of us get money back from when we weren't driving? Comment in the chat if you got money back from your insurance company for not driving during COVID, but still paying for your car insurance. I didn't. What's also unique about insurance is you're forced to buy it. It's the only product where the government could come in and say, hey, if you don't buy this, you don't get to drive your car. If you don't buy it, you don't get to qualify for a mortgage or own your home. It's the perfect product because not only are you required to buy it, they can also then use the profits, the insurance companies, use the profits, go to the legislature and say, make us even more money by giving us less incentives to pay out on claims. Let me check in real quick. Nolan McConville, I actually did. That's interesting. Okay, Nolan, well, can you comment for us in the chat on how much you got back during COVID? I certainly didn't. I have USAA. My wife has Progressive, or did during COVID. I think I still had USAA. And I didn't get any money back. So interesting that Nolan McConville in the chat did get money back. Let's see what they're saying over in our Senate.
Who smuggle their products into this country
This unregulated market causes several serious.
Sounds like they're still talking about tobacco marketing. Bill 1698, which is regulation of e-cigarettes. Okay. So they're still talking about that. We're going to mute them. We'll keep it live, but we're going to mute them. Nolan, I got about 140 bucks. That's awesome. Now, did you only get that payment once, or did you get it all throughout COVID? Did you get 140 bucks a month for not driving? And what was your insurance company? I would love to look into that. And if you also had a similar experience like Nolan, comment on Instagram or YouTube. I think we might shut out the Instagram. It doesn't seem like we're getting a lot of traction. I don't think there's anybody even on Instagram from what I can tell. One time, no one got a one-time payment. Wow. Wow, how generous by the auto insurance industry. Nolan makes his payments for 12 straight months during COVID. He's not driving. Maybe he was driving a little bit, knowing Nolan the way I do. Maybe he was driving a little bit, and we'll cut you a check for 140 bucks. Meanwhile, you've been paying premiums to them for what? A decade? It's crazy. All right, I need to take a short break here. I think we'll cut off Instagram for now. Oh, Farshad, thank you, buddy. I appreciate the comment here on Instagram. And I need to go. I didn't realize I'd be talking this much. I might run out of things to say. So we got to figure out a way to get somebody else up in here. Maybe we can have Jack Kelly, see if he's actually in my office or at our building. Maybe he could come in, pull up a chair. We could talk through this, see what he thinks about it, see what current cases he's got going on. Maybe take some live calls. Could we do that? Could we take a live call? We'll think through that. Thanks for tuning in, everybody. I'm going to take a short break, answer some text messages. Yeah, man, we ain't going nowhere on the Instagram.com. We out this piece. Ending our Instagram. But we're going on YouTube all day. We're staying live all day. Doing our thing. Appreciate everybody's comments, everybody tuning in. Let's see what we are, how we're looking on YouTube. Got 7 viewers on YouTube. That's great. Love that. I hope we didn't lose Steve Chapa. Very famous criminal defense lawyer here in the Dallas area. If you've ever been arrested, you need to call Steve Chapa. CHAPA. I'm going to drop his state bar info in the chat because I know there's some certain people in this chat who might have some felonies on their record. Probably need to reach out to Steve. Give him a call. Maybe he'll get you off probation. Let's see what this big hoss has to say.
Legislative advocacy for Hispanic businesses throughout the state of Texas. The reason I'm here today is we're actually supporting this bill, and that I've learned over the years that common sense is sometimes not that common.
Common sense ain't that common. I hear that. I'm going to shoot up a poll. Starting a poll. Don't know how that works. All right, let's take a short break, and we will be back.
kidding me?
Thanks for being here. Anyone else wishing to testify on or against Senate Bill 1313, Senate Bill 1314, Senate Bill 1316, Senate Bill 1698? So should I close testimony and then recognize you, Senator, or do you want to talk before we close
I just want
testimony?
to comment for a moment.
Okay, let me close testimony, then I'll recognize you. Public testimony on Senate Bill 1313 is closed. Public testimony on Senate Bill 1314 is closed. Public testimony on Senate Bill 1316 is now closed. Public testimony on Senate Bill 1698 is now closed. Senator Parker, you're recognized.
Thank you, Mr. Chair, members. I want to thank you all for allowing me to come before you this morning and lay out the bill. Just a couple of thoughts. First of all, I appreciate everyone that provided testimony today. It's such a crucial part of this process to get feedback, whether or not people support it or not, and I'm most grateful for that. But just a couple of thoughts. First and foremost, the federal list clearly is not working. That's what we're seeing. They're overwhelmed. They're not working. This is why we need a Texas-specific list. We've heard commentary that other states have put in place a list that wasn't successful. With all due respect, they're not Texas. We do things professionally, we do it right, and it'll be a first-class directory. And then, I want to come back and just focus on what this discussion is all about. It's about protecting our children. This is about the marketing to minors and all of the children that are being hospitalized in the state and this country every year. And far worse, there are deaths that occur because of these products as well over the years. So I just think it's very important that we recognize that and understand that what we're doing specifically with 1698 is providing education and awareness to all of our retailers to make it easier to operate a business of these products that are in fact illegal and not regulated at the federal level. So with that, I conclude. Appreciate the time to come before you, Mr. Chairman, and the members of the committee this morning.
And thank you, Senator Parker. Senate Bill 1513 is left pending at this time. Senate Bill 1314, let me back up. That was Senate Bill 1313 left pending at this time. Senate Bill 1314 is left pending at this time. Senate Bill 1316 left pending at this time. And Senate Bill 1698 left pending at this time. The chair now lays out Senate Bill 1541. 1541 recognizes its author, Senator Betancourt, to explain the matter.
Thank you, Mr. Chairman and members. After a November election in even-numbered years, the Secretary of State is required to select 4 counties at random and be audited. 2 of the counties selected must have a population of less than 300,000. 2 must have a county selected must have a population of more than 300,000. And a county selected in the most recent audit cycle may not be selected in the current audit cycle. Concerns were raised that during the interim hearing by Secretary of State's office that they can do following their randomized, what they can do effectively about following their randomized post-election audits. And simply put, what Senate Bill 1541 allows the Secretary of State to continually monitor elections for the next year and coordinate with local election officials to develop a plan to help remedy any identified issues. Lastly, if the counties do not remedy the identified issues, the Office of Secretary of State can place the county under administrative oversight. We do have that capability already for Harris County. I think Christina Atkins is here from Secretary of State. If we need a resource witness, I'd be happy to answer any questions.
Thanks, Senator Betancourt. Members, the Dean of the Senate is recognized. Do you have questions? Oh, thank you, Dean. Any questions for Senator Betancourt?
Ladies and gentlemen, we will resume shortly with Jim Goff's live stream. Please stay tuned.
Bill's left pending at this time.
Thank you.
The chair now lays out Senate Bill 2420, and recognizes its author, Senator Paxton, to explain the measure.
Well, thank you, Mr. Chairman. Thank you, members. In January, the Joint Committee to Study the Effects of Media on Minors heard witness after witness describing the pervasiveness of social media in youth culture and its harmful effects on young minds. One of the things that became very clear was that what is seen cannot be unseen. As a mother of 4 and a grandmother to 5 with one more on the way, there is literally nothing more important to me.
Thank you, Emily Copeland, another fantastic trial lawyer. We're trying to fix the audio, Emily. It's hard. Jack, Kelly, and I are actually trying to fix it right now because I can't figure out how to lower their audio and raise mine, or lower my audio and raise theirs at the same time. So please be patient with us. I agree with Will Hatchett. Just start screaming. It's probably a better call. Ah! Fudge! Ooh, got my background removed. Ooh, let's do this. Let's do this. Oh, you can't see my face. We be doing a little bit of struggling. Oh, there we go. There we go. I think you can see my face now. All right, maybe that's better. All right, how are we looking, folks? How are we looking? Comment into the chat if you think this lady's jacket is badass, because I do. All right. Experiencing some technical difficulties, but we're moving, we're grooving, we're covering tort reform. We'll be back.
Some products marketed to children are addictive. such as in the bill that Senator Parker just laid out, Senate Bill 1698, regarding nicotine products. This is a precursor to substance addiction, but there are also behavioral addictions, such as screen addiction and video game addiction. There is literally a facility up north that I've learned about that provides the opportunity for youth to come to do digital detox. So, you know, to the brain, addiction is addiction. And we have to recognize that. The research says that the younger the age of first exposure, the more likely the user is to become addicted. Obviously, the younger a user is when they are addicted, the longer they're likely to stay addicted without some sort of meaningful intervention. And it follows that the longer a user is addicted, the more profitable they are to those who market addictive products to them. The big win for those who market anything to children is the potential of creating a customer for life. Senate Bill 2420 requires app stores to verify a user's age category, to obtain parental consent for minor users, and to notify users and parents of any substantial changes to the app. It prohibits app stores from enforcing contracts entered into without parental consent, and it provides an enforcement mechanism through a private cause of action and the Deceptive Trade Practices Act. It codifies some of the age appropriateness and parental consent features that many of the app stores are already publicly touting that they do, and it will better equip parents by providing additional framework, transparency, and enforcement. I do have a committee substitute, Mr. Chairman.
Screen addiction.
Senator Betancourt, since up the
Screen
committee
addic-
substitute.
Here,
Senator Jackson's
my
recognized
wife
to explain the
commented
substitute.
screen addiction because
Thank
I'm
you, Mr.
addicted
Chairman.
to
Thank
the
you, Senator
screens.
Betancourt. The committee substitute incorporates
See, folks,
stakeholder
even when you're
input
not at home, your wife is always watching.
and amends
All
the
right.
bill to closely
will
mirror
be
the App Store Accountability Act, which
right
was
back.
actually signed into law by Governor Cox in Utah just last week. Specifically, the committee substitute does the following. It titles this legislation the App Store Accountability Act. Regarding duties of app stores, it amends language to relate to how the App Store verifies the age of minors, to remove the provision requiring them to
figured out how to
request
get
the
the text of the
individual's
bill
age.
back.
And instead,
So,
it requires
you can
app
use the
stores
restroom,
to use a commercially
water, get some
reasonable
energy
method
drinks.
to verify the
Emily
age
Copeland's in
category,
the building.
which
Thank
is a
God.
factor that should simplify
Steve
implementation.
Choppa's back with us. Thank you, Steve,
The
for
bill
joining in. Martha's
requires
with us. Jack's
parental
with us. Will
consent.
Hatchett, the famous Will Hatchett.
And in
Noel
this
McConville,
section,
Jack Kelly. Everybody's
language
joining in. Everybody hates
rephrases
Tort
to
Reform. Everybody thinks
clarify
it's
to
bullcrap.
app stores that all minor
We're here.
accounts must be
We're watching. We're
affiliated
tuning in.
with a parent
More
or guardian account.
commentary shortly.
It
Be
further
right back.
requires an app store to obtain consent from the minor's parent or guardian through the parent account affiliated with the minor's account in order for the minor to either download or purchase an app. And it requires the app store to notify the app developer if a minor's parent or guardian revokes consent to ensure that the developer knows that the child shall no longer have access to the app and to deny the minor from further accessing the app on all devices on the family's network. Regarding the display of the age rating for the software application, this committee substitute removes the mandate that an app store displaying a rating, let me restate that. It removes the mandate that an app store display a rating, and it instead provides that if the app store has a rating or other type of content notice, it shall display the rating clearly, accurately, and conspicuously. Regarding protection of personal data, It removes language requiring app stores to delete personal data, as app stores may need long-term access to data for age verification purposes, and to collect and store data based on their own privacy policies. It maintains, however, that it still requires that data may only be used for age verification, obtaining parent consent, and monitoring and keeping compliance records. Regarding changes to software applications, the committee substitute clarifies that in instances when apps have a new version, parental consent is required again if it is a material modification to an app's terms of service, categories of data collected, stored, or shared, alters rating or content descriptions, adds new monetization features like advertisements, or materially changes the app's functionality or user experience. Regarding age verification, it clarifies that the app developers receive the age category information from the app stores and do not have to develop a new system to obtain that information separately. Again, this should simplify implementation. Regarding violations, it provides that app developers acting in good faith to receive age categories and verify that parental consent was obtained.
All right, we are back, folks. Comment below if you can still hear me. Got a breakfast bar. Got to keep the energy up. Gonna be a long day fighting against the insurance company globalists. I don't know if I like this background removal thing. I look kind of weird. Let's take that shit off. Trash that shit. How do we change? Oh, you can still see me. Okay, we're good, baby. We good, baby. All right. So, let's get back to breaking down the actual bill. Thank you, Will Hatchett. You know what? If we could get Will to jump into the live stream, if anybody, for the love of God, we got some smart people up in here. We got, for God's sakes, we got Steve Chapa in the chat. One of the smartest human beings in the world. There's got to be a way that we can live call, and I think it's going to be Zoom. What am I sipping on? This is 100% Colombian cocaine. Okay? Okay? Just kidding. It's called Amino Energy. For all my coffee lovers out there like Emily Copeland, Monica Goff. Maybe switch it up to a little green tea extract. All right. Okay, let's jump back into the bill. Let's get to talking. Let's get to walking. We're back here on the bill. Whoa! Whoa! This thing is way too big. Let's zoom out there. Okay. So we've gone through all right, we don't care about your grassroots crap, dude. Let's mute this fool. All right. So we're back. We're going through, actually, I probably should need to listen in. We're back. We are going through the portions of the bill. What are we mad about? What are we talking about? So we've gone through the affidavit. Now I want to dive into, well, actually, here's another funny section of the bill. Is it allows you to, for the defense, for the very first time, damn it, trying to make myself smaller. It allows the defense bar to find out the amount that the plaintiff's lawyer has charged or agreed to reduce in other cases. So, and not only this, let's apply this to everybody who could be considered a physician, a podiatrist. We get to know the reimbursements rates of podiatrists. Now, the only podiatrists I know are those disgusting ingrown toenail videos on the TikTok.com. I don't know why the Texas legislature and TLR, Tort Reform Group, wants to know so much about that, but whatever. Okay, so what I was saying was, if you're injured in a claim, you don't have health insurance, okay? You don't have health insurance because we live in a country that doesn't have universal health care, or your job doesn't provide health care, or you're a sole proprietor, you haven't paid for health care, or your spouse doesn't have a job that provides health care. This bill will now limit the ability for you to recover your medical expenses if you're treated under what's called a letter of protection. Letter of protection, also known as LOP. For all my plaintiffs' lawyers in the chat, they're very familiar with this. They're very familiar with this. They'll know what I'm talking about. But what an LOP is where the doctor can treat you for medical treatment and then put what's called a lien on your case. So let's say I get $5,000 in treatment from an LOP doctor. The LOP doctor says, hey, you pay me back out of your settlement. I get my settlement, pay him the $5,000 because he gave me great medical treatment. My case settled, and now I can pay him back because I didn't have health insurance. Well, now under this bill, not only are their reimbursement rates subject to the exact same that the rural hospitals we were talking about earlier are, according to this University of Texas study, but if that attorney has worked with this provider before, the doctor I paid the $5,000 to, that's discoverable. Now we get into a whole sideshow, if you say, of, hey, your lawyer refers you to a doctor. Now we get to know everything about this plaintiff's lawyer, their relationship with their doctor. So, and why do they want to do this? Because they believe, the tort reform, the insurance globalists, believe that if the jury hears that you were referred to a doctor by a lawyer, your medical bills are not believable. They're not real. That only people who are truly injured would get real treatment at a regular doctor, even though they don't have health insurance. So stay with me here. So if the jury hears that Jim Goff referred Emily Copeland in the chat to Dr. Smith, then we can argue Dr. Smith is making all the medical treatment up, or Emily wasn't hurt. If she was really hurt, she would have gone to her other doctor, even if she didn't have health insurance. So let's think through that stupid ass logic. So now that Emily has treated through the LOP doctor, we want to know if Jim, her lawyer, has had any relationship with them. We want them to identify what their relationship is. We want to identify a third-party payer who is paying for those services. So we haven't talked about this before. So the third-party payer, that's when a funding company, I'm not going to dive into that today, but a funding company will come in and provide funding for the surgery. Meaning, hey, I can't afford to have the surgery, but I want to engage a third-party payer so the defense can know, okay, who paid for this surgery on their behalf. Not necessarily a terrible part of the bill to me. I mean, if you have a contract for a third-party funder to pay for the surgery, then it seems to me maybe that is discoverable. I guess Tobias, I don't know a whole lot about why that is a bad thing. I guess it could be because it dives into a sideshow of, okay, now we got to bring in this third party who has nothing to do with the case, who all they're doing is providing funding so that the patient can actually go have the surgery or the treatment. I need to probably think through that a little bit more, but that's what number 2 is when it says third party payer. It's really just a funding company. Disclose a written agreement. Whoops, moved the wrong thing. Disclose a written agreement under which a provider may refund, rebate, or remit the money. So that means this letter that forms the LOP basis that, hey, if you have an agreement with your lawyer and the provider, we should be able to know that so we can know that you're not really paying for your surgery or your treatment up front, but that your treating physician is taking a lien. I don't see why that's relevant. We have what's called the collateral source rule in Texas. I don't want to dive into that. Everybody will start falling asleep. Oh, Adam with a great question. What if the patient does have health insurance but chooses not to use it? This is really important and is actually in the bill. So Adam's talking about a situation where, let's say Adam got in a car wreck. He goes to the hospital, uses his insurance, but then says, oh man, my neck is still hurting, but I want to go get chiropractic treatment. And I'm going to take this example to the extreme a little bit, Adam, so bear with me. Adam goes to his chiropractor. The chiropractor says, hey, I don't take health insurance. I'm not dealing with you, with your health insurance company because you were in a car wreck. I'm never going to get paid back, if at all. Alternatively, Adam could go to the chiropractor. The chiropractor says, hey, I do take your health insurance and I will charge it. And so Adam's question is, well, seems like you're playing both sides of the fence there. If you have health insurance, but I'm not using it, why should the jury not hear about that? Because if you pay for health insurance, but you're not using it so you can then go get LOP treatment, which will dive into whether your bills are overinflated, there's actually a specific provision in the bill to deal with that. So here on Section D, Adam, is what you're asking about, which is if you have health insurance, but you treat on a letter of protection, then it is now an affirmative defense of failure to mitigate damages, which means that the plaintiff could wind up getting nothing. So let's think through that. So it's a failure to mitigate damages if I don't use my health insurance. Well, what if my health insurance, my in-network providers won't treat me as a car wreck patient? I have this happen every single week. Somebody will go to their primary care physician to say, hey, I was in a wreck, I want to get checked out. They walk into the office, the doctor says, whoa, I don't treat car wreck victims. I'm not dealing with the insurance companies, and I'm not dealing with them disputing my bills under the controverting affidavit standards set forth above. And it takes forever to get paid if you were in a car wreck and your insurance company, your health insurance company, either agrees to my bills or doesn't. That's my issue with Section D, is even people with health insurance don't get to have treatment because their physicians, in-network physicians, won't treat someone who was in an accident. Now, I know, since I know Adam, he's probably thinking, well, how often does that really happen, Jim? Come on. What you're really doing is you want to get them in with your providers so you can overinflate the medical bills for a better settlement. No, it actually happens more than you think. And if we had universal health care, this wouldn't be an issue. You really would have a much stronger argument on the defense side, or the pro-tort reformers, saying, hey, we have universal health care. You could go treat at any doctor you want, but you're not. Instead, you want to go to plaintiffs' counsel's providers. That's a little fishy. Emily with a question. Now we are going to have to get letters from their in-network physicians about that. They won't come to trial to prove that up. That's exactly right. If you've ever worked a PI case, getting a doctor to testify is like pulling their own teeth. They don't like to do it. They don't like to testify. And I can't blame them, folks. Why don't they like it? Because if I'm a doctor, what's my number one goal? Treat patients. This is for most doctors who care about their patients, love their patients. I want to treat patients. I don't want to go down to the courthouse and sit for 8 hours where I'm not going to get paid as much. It's stressful. I have to look at a jury. I have to, if I'm scared of public speaking, which most doctors are, then I have that fear. And I'm making less money. So what happens now if this section passes? We're going to have to get letters saying, hey, Emily went to BlueCrossBlueShield.com, tried to find a provider, reached out to all of them to treat me in a car wreck case or treat me after a car wreck, and they all said no. First of all, it's all hearsay. I don't even know if I could get those admitted, but it's an entire side issue. Now you're having like 2 to 3 hours of testimony at trial about why Emily, our make-believe injured victim here, went to a certain doctor at a certain time. It's a huge sideshow. Let's get to what's important. Did the defendant cause the wreck? Did the defendant cause these specific injuries or cause them to be worse? And are they liable for them? Let's get to why we're really here, because I think most defense lawyers would agree with that. You know, in my time on the defense side, we never controverted because it was a huge waste of time. If you're fighting over like whether a medical bill is $100 or $200, everybody gets bored. As a defense lawyer, I rather focus on, look, Emily's back was hurt prior to this crash. Here's all of her medical records showing she was hurt prior to this crash. Here's all of her medical records after the crash showing the exact same thing. That's where I want to spend my time on. I think what could be frustrating for defense counsel, though, which could be, well, I don't know anything about these doctors. I don't know how often people are getting sent there. I don't know what they're really charging, and I don't know what ultimately the plaintiffs actually pay them. Well, you don't really know that either on the health insurance side. We only get to see part of the health insurance bill, let's say for a classic example like a hospital. We don't get to see why the adjustments are. We get to see the amount. We don't see if they're negotiated. We don't get to see the contractual rates that they have. I mean, this will just turn into such a sideshow, which doesn't address the key issue, which, to get a little political, is universal health care. I mean, the bill really should be, if you hate LOP treatment and you think all medical bills are inflated, argue for some universal health care. That's your better argument. But now saying, look, you had health insurance and didn't use it because it turns out your doctor won't even take your health insurance, you didn't mitigate damages, therefore you should get zero? I don't think that's the way to go. I think it's a huge waste of time. Excuse me. Oh, getting a text message from Andre the lawyer. Very famous lawyer here in Dallas. He's wondering, have they started covering SB 30 yet? Let's check in and see what they're talking about. Let's see if they're talking about our tort.
Social media just to groom our children. The grooming stages have escalated, and they have escalated from when I was out there. It's no longer face-to-face, let me sit you down, or here, do you need something to eat, or can I give you something to drink? Because the predators use women, mother figures, to groom our children. And once they befriend you, or befriend our children, guess what happens? They have them. They have them. And so with me, they knew that I needed that love and an acceptance.
It sounds like they're really talking about some kind of abuse bill, targeting through social media. This lady's awesome. It takes some real courage to get in front of the legislature, in front of the public, testify about Miss Fitzpatrick, the horrible thing she's been through.
Chairman Hughes, thank you for sharing your story. And congratulations on your overcoming. You're an inspiration and an encouragement, and you're taking a tragedy and you're investing that.
All right, I don't think they're talking about our bill. To address Andre the lawyer's question, let's jump back into the bill we were just talking about. We're talking about OOP, talking about medical bills. I hope that answered your question, Adam. I know it was probably a little long-winded, kind of all over the place. I know Adam does defense work, and he's one of the defense lawyers, the kind of guy that'll beat you up in your case, take you to the mat, kill you, slit your throat, but grab a beer with you afterward. One of these lawyers that I think is truly on both sides of the issue because he sees it on both sides and he wants what's best, not only for people, but for his practice and to help protect his insurance clients. And there's nothing wrong with that. Adam's got to make a living too. That's what we got to balance here, folks, is our system so unfair to the defense that they can't present a fair case? We have to balance that. We can't have a system where it's 100% pro plaintiff, all evidence comes in that's good for the plaintiff, no matter what. You have to have a balance. Because keep in mind, the defendant is presumed innocent. Adam represents a car wreck client. He has no burden to prove that his client caused the wreck. I have to prove it as the plaintiff's counsel. I have to prove up all the medical bills. I have to prove that the crash caused all the injuries to our fake victim, in this case, Emily. So sometimes I hear a lot of plaintiff's lawyers say, oh, all defense lawyers are evil. Well, they're really not. Remember, the defense lawyers are the ones who are paying us. And most defense lawyers in my practice are wanting to do the right thing. I have found some true believers that every personal injury case is BS, but a lot of them are trying to do the best they can, trying to do their job, trying to make sure that righteous cases are getting paid outside the courthouse.
Yes, one of the examples, like I was explaining, is an app called Exposed 2, rated for ages 12 plus, and here's what the user does on the app. Quoting from the App Store, it lets users play in normal, spicy.
Sorry, I'm texting E10 Tepperman, I think is going to join us on the live stream here. We're going to have another co-host, so that'll be good. I'm sure everybody's sick of seeing my fat face. He's going to come down, bring some lunch, talk a little tort reform with us. He is a personal injury lawyer out of Denton. I don't know if you've ever been to Denton, but it sucks. So good for him for staying alive out there. Him and Grace Weatherly, the only two lawyers in Denton that seem to enjoy life. All right, I did answer the question quite well. Okay, great. I'm glad I was able to answer some of it. Another thing is, we've got to see how this plays out today. I mean, we're going to hear from the legislature, the bill sponsors. We're going to hear what their intent was. They might also drop some of this portion. They might have the bill amended. But one other issue I have, just focusing here on letters of protection, is you now as a plaintiff's counsel have to provide as evidence in your case there's a portion in here talking about, right, here we go. You have to disclose any unwritten agreement you have with the provider. I don't even know how you would do that. Like, what does that mean? Like, if I had a phone call, and that's discoverable. Am I now testifying? Because now that makes me a witness. Do I have to take the witness stand and say, hey, I've used this provider, I've sent people to this provider before, this is what it's settled for, this is what was paid? I mean, if you go down to C, you even have to list out an anonymized list of persons referred by the attorney. Well, in 2 years, do you know how much time that would take me? Well, not me. I don't have that many cases, but I have to go through every single one of my past cases for the past 2 years now and keep a list, which is stupid. Keep a list and then provide a list of here is all the Jane Does, their treatment, what treatment they got, what their amount was, and then here's the date and amount of each payment that was made in the past 2 years. What does that have anything to do with this case? Why would a jury even give a crap about hearing all that? And does it come into evidence? How do I truly keep the list anonymous? I mean, couldn't a plaintiff's lawyer just take a fake list and say, hey, I paid 100% back on all these bills because it's anonymous? How is the defense ever going to prove that the list is correct? Are they going to get to depose the plaintiff's lawyer saying, okay, let's go through this list. Who was the client? Because then it's not anonymous anymore. Okay, what was the amount? What were the injuries? Where was the crash? I mean, am I now going to get deposed in every single case? Hold on, I got to eat this real quick. I'm starving, y'all.
And I also appreciate,
I mean,
in your testimony, you said very specifically,
it's such a stupid sideshow. I don't see this part passing. I don't think the defense lawyers even want to deal with this. Will Hatch, Denton is better than Oklahoma. That's true. That's true. Oklahoma's terrible. Well, Adam Holden in the chat is from Oklahoma. I got some family in Oklahoma, so he's out of the Tulsa area. Not the prettiest town, but we're glad to have him. All right. So I think, here's another stupid provision. Other aspects, we're here under what has to be disclosed. Okay. And another thing that has to be disclosed is any other financial relationships between the attorney and what is that? Comment in the chat, my defense lawyers. What does that mean? Help me understand that. I don't know what that means. Does not affect burden of proof. Yeah, right. All right. Now we get into what's admissible, what's not. The following matters are admissible by any other parties. Okay. The healthcare expenses, so like Adam was addressing earlier, what if I have health insurance? Or what amount was paid in the bill. But wait, whether the claimant seeks to recover healthcare expenses or not. So let's say my bills are $2,500. I'll give a classic example. I dealt with this 2 years ago. Client was Norton, Mr. Norton. Mr. Norton was riding his bicycle over on White Rock Lake. Wait a second, did I hear him talking Tort for me in the Senate? Nope, talking about doom scrolling. We good, baby. So, Mr. Norton was riding his bike around White Rock Lake, gets run over by an Uber driver. He had maybe $2,500 in medical bills, less than $5K. They were real low. Why? Because he had 4 broken ribs. What's the medical treatment for broken ribs? Rest, ice. So there wasn't anything for him to do. He had to just go home, let his ribs heal. Well, that's a case where his pain is clearly greater than the $2,500 or whatever it was that he suffered in medical bills, which the defense will say, look, his damage is only $2,500. Everything else, don't pay him for it. Now, let's say that case had gone to trial. Now the defense, if I say, look, Mark, don't bring let's not worry about these healthcare bills. It's $2,500. Your insurance covered it. Let's just go to trial because you're not being offered what's fair for what you went through for your broken ribs. Say, okay, we're not going to go after bills. They're too little anyway. It's just a distraction, especially given all the controverting affidavit crap we've seen in this bill already. Well, now, under 41-107-2, the defense may offer into evidence, well, it's actually any party. I don't know why you would as a plaintiff, but it's admissible in evidence by either party, the amount of medical bills, even if you're not seeking to recover them. How is that relevant to anything? These are bills that are not going to be part of the trial. They're not part of damages. They're not part of the plaintiff's evidence. They're not part of the burden of proof. They're not even seeking to get the money back. Let's bring them all in anyway. The truth is, the reason that the defense bar, well, it's actually not, I keep saying that, it's not the defense lawyers that want this. It's the insurance companies. The insurance companies want to bring this in because they want to say, look, you need to award so little in non-economic damages because their medical bills were low, as if there's a correlation. And why is that? Because the rational person thinks there is. Average Joe on the street says if your medical bill is $2,500, you're not hurt. Therefore, we should never give someone $10,000 for 5 broken ribs because their hospital bill was only $2,500. Everything must be made up. That's the rationale. That's why the corporate oligarchs want and have drafted and included this provision. Hatch saying, sorry, Adam, I was trying to stand up for our people in Denton and inadvertently cast shade on the folks in Oklahoma. I'd love to hear from Hatch. Hatch, comment in the chat what you think about if you had a trial coming up, you're not gonna seek the medical expenses because they're too low, or they're not relevant because the client didn't treat a lot, or their injuries far exceed whatever the medical bills are. What do you think about this section? Why it's bad for the trial? Love to hear your thoughts, Hatch, on that. So, 4107, back into it. What's admissible by either party? We just talked about meds that aren't coming in, now they are. Evidence of a health benefit plan that is available to pay for past and future health care services. Insurance. The TLR wants the ability to bring up health insurance during trial. I know what everybody's thinking. Well, what's the big deal about bringing health insurance? Well, if you want to bring health insurance in, why can't I bring in insurance? You want to talk about health insurance without talking about insurance. Why can't I talk about how I'm really suing State Farm? If the defense can talk about, well, you have health insurance, why can't I say, well, the defense also has insurance. That's how they're able to pay lawyers like Adam Holden. What's the point of that? The point is they want to introduce health insurance because they want to put a plaintiff in as bad a light as they can in order to pay them less money to report more profits back to the Geico wizard. I mean, it just seems stupid. Hey, the defense can introduce evidence of health insurance, but there's a rule that the insurance industry fought and died for that we can't mention the word insurance at trial. Even if the public already knows, hey, insurance is probably covering this anyway. Let's not bring it up. The only insurance we can bring up is health insurance, a deeply complicated issue that we've talked about at length today. No, I think that part is really stupid. Then it dives into under 4, treatment guidelines and formalities approved by the workers' comp program. If the person, the plaintiff, is not injured at work, why the heck is workers' comp insurance going to come in? We're now going to have testimony. I don't even know how you would get this into evidence, which is, hey, this is what workers' comp, this is how their treatment guidelines were for an injury that we think is like your injury. It's as evidence related to the necessity, treatment guidelines, and drug formalities. Will with a great comment here. Will says, hatch. It's an odd thing for the bill to mandate. A lot of times we are not allowed anchoring for larger damages. So let me stop there on Will's comment. Anchoring is what's referred to as an advocacy technique, which is that if people hear a number, your jurors hear a number, whether it's a large number or a small number, that they're more inclined to use that number again during their deliberations when going through the damages portion of the jury verdict. Meaning, hey, we heard $1 million throughout the trial, $1 million. Well, now everybody's thinking about $1 million or they're comfortable with it. Surely they're just going to award it as whatever damages they want when they get back in the deliberation room. So that's what Will Hatch is referring to there. A lot of times we're not allowed anchoring for larger damages, and I feel this is a backdoor to anchor lower meds and prime the jury member's mind. He's absolutely right. It's an anchor for a low number that's unrelated to what the plaintiff's actually seeking. It's very different than, let's say, Hatch goes to trial on a case, the meds are $10,000. The defense says, no, they're really $6,000. Here's my doctor to testify on, this is what I would charge, it's really $6,000. Jury, if you're going to award any past medical, award $6,000. Don't give Hatch $8,000. We think $6,000 is a fair number. That's different because Hatch has clearly said, no, my client is entitled to $8,000 of the medical bills. This is completely different. Now we're bringing up past medical treatment bills that are not even being sought in the trial. I mean, can we now bring in bills from prior injuries? Can we say, well, this MRI you got in 1982 for a broken arm, that should be the amount you were today for pain and suffering? I mean, what kind of sense does that make? Let's check in with ET. Okay, we're still good. Let's check in with ET, see what time he's going to be able to hop in here with us. Let me actually take this opportunity to take a quick break, everybody. Hey, you know what? We're fighting tort reform all day. Everybody, get you a glass of water. Get you a glass of wine, maybe. You know, there's nothing like drinking on a tort reform day. Sometimes you have to because of the absurdity of this crap. But let's take a quick break. I got to get another chair for ET anyway for when he joins us to talk about this bill. Let's take a quick 5 minutes. I'll switch it over to the legislature so you can take a quick peek as to what they got going on. And we will be back.
Over there. You're good. Also looking for Johnny Campus. And after this panel, we'll be calling Curry Marshall, Andrea Sparks. I have a seat.
Oh, I just got a text from Will Moyer, very famous now plaintiff's lawyer.
Right there on the end.
About when is this bill, when are we going to hear on this bill? Maybe we can get Will Moyer to join us. I'm going to go give him a call.
And we'll start over here on my left, your right. Now, for those of you on the end of the table, you got to get close to the mic so we can hear you.
Me first.
Yes, sir. Introduce yourself. Give us your testimony.
Good morning. Thank you for having us here. My name is Johnny Campus. I'm Director of Telecom Policy for the Taxpayers Protection Alliance. On behalf of the millions of taxpayers and consumers we represent, we urge you to oppose this bill. The legislation presents deep constitutional issues from its mandate for device manufacturers or app stores to estimate or verify their users' age. Although well-intentioned, the bill would create substantial privacy risks and violate clear Supreme Court precedent with broad age limitations to users' right to access various digital services. The constitutionality of age verification legislation remains highly questionable. Supreme Court case law on this front stretches back decades. In the lower court's Net Choice versus Griffin 2023 case blocked an Arkansas bill requiring social media platforms to obtain age verification and parental consent to the potential violated the First Amendment. Similar age verification laws in other states have run into the same injunctions. Proponents of App Store age verification defend age proposals by saying they are about contract law, not speech. They also claim they're content neutral and therefore immune from constitutional challenge. Neither point withstands scrutiny. First, the claim that age verification bills are about contract law, not speech, does nothing to change the fact that it would impose a huge burden on the speech rights of adults forced to submit to age verification before accessing apps. These burdens ensure that the bill will fail if challenged in court. Second, a law imposing sufficiently large burdens on speech will be found unconstitutional, even if it is content neutral. To illustrate with an extreme example, a law that banned all online speech would certainly be found unconstitutional despite its neutrality. Further, the parental consent requirements of the bill run into constitutional issues. In Brown versus Entertainment and Merchant Association 2011, Justice Scalia wrote for the majority, "It does not follow that the state has the power to prevent children from hearing or saying anything without their parents' prior consent." The possibilities for government...
We'll come back for questions. Thanks very much. Welcome. Introduce yourself. Give us your testimony.
Thank you, Chairman Hughes, Vice Chair Paxton, members of this committee. My name is Grayson Gee with the Texas Public Policy Foundation, and I'm here to testify today in support of Senate Bill 2420, the App Store Accountability Act. We at the Texas Public Policy Foundation have long advocated for the welfare of children and the strength of the American family. As we've studied the intersection of technology and childhood, our research has exposed a concerning reality about kids and their use of technology. In today's digital landscape, our children are more vulnerable than ever. Mobile applications have become a gateway to harm, exposing minors to inappropriate content, predatory practices, and unchecked data collection. This legislation would provide a lifeline for our children's digital well-being. Senate Bill 2420 provides what parents have been desperately asking for: real, meaningful protection for their children in the digital world. It mandates robust age verification, ensuring that app stores know exactly who is using their platforms. But this bill goes further. It protects children's personal data, limiting data collection, and ensuring encryption. In an era where children's information is constantly at risk, this bill creates a shield against unethical data practices. Some may argue that this is government overreach. I argue that it's government doing its fundamental job, promoting the general welfare of its citizens. Parents shouldn't have to be cybersecurity experts to keep their kids safe. This bill bridges that gap. It provides a framework of protection, transparency, and accountability. Thank you for the opportunity to testify today, and I look forward to answering any questions you may have.
Thank you.
All right. Old young-looking Jack Kennedy there. Something about apps. Something about dangerous apps. Lord knows there's enough of them, or too many of them. Let's see what that's about.
Thank you for testimony, and I've known you for a while, but I just can't help reverting back to pronouncing your name G sometimes. There was a judge with the same spelling that used that, but thank you. I apologize.
It's all right, sir.
And I know how to pronounce your name, but I think I did it wrong. Bart, welcome. Introduce yourself. Give us your testimony.
I'll go with what you said, Mr. Chair. Bart Clellan. I like that. Happy to be here. Happy to be back home. Feels great to testify. Happy to see you, Senator Paxton, and members of the committee. I'm Bartlett Clellan. I'm general counsel for a trade association called Net Choice. You guys know us, but our mission is to make the internet safe for free enterprise and free expression. Unfortunately, I have to oppose the legislation today. We do share your goal of protecting minors and any harmful content online. I personally have been involved in this fight for over 25 years, serving on a couple different commissions, national commissions, to look exactly at the right way to accomplish this end. We do ask you, that is the committee, to oppose this legislation. The Supreme Court and other federal courts have ruled that age verification mandates
Oh shit, this is about age verification? I think this is about the pornos. I think this could be about the pornos.
mandates block access to the exercise of First Amendment rights, and that is unconstitutional. Age verification laws have recently failed in states California, Utah, Ohio, Arkansas, Mississippi, and I would not like to have Texas to be part of that list. Given that legal landscape, SB 2420's age verification, parental consent requirements, and data-related requirements will not survive judicial review. But on the chance that they would, unconstitutional age verification laws not only face those legal challenges, but do encroach upon parents' long-established prerogatives in guiding their children's upbringing and online activities. Many online platforms, as we all know, have implemented robust parental control features already, not least of which are iPhones and iPads, an area of which I am particularly interested, that I chose to protect my children, as a matter of fact. A one-size-fits-all government mandate will give users a false impression of security and will flatten the offerings for youth safety in the future. And in the end, I'm a conservative, and I believe in personal accountability.
Yeah.
Those peddling questionable content, we heard about.
Yeah, I'm a conservative, questionable content. You know what? I think we all agree with that. I think this is a bill to attack pornos. I'm not 100% sure. Hey, I drew this graphic of Thomas Jefferson riding a velociraptor. If you think it's cool, if you think we should put it on a shirt, comment down below. I think it's pretty badass. I need to change it though. All right, let's tune back in.
About some earlier today, they should be the ones called to account, not others. Thank you very much.
Thanks for your testimony. Welcome, introduce yourself, and go ahead.
Thank you. I'm Deborah Simmons, and I am for Senate Bill 2420 to require age verification for App Store downloads and purchases. In January, the Supreme Court heard oral arguments in the Free Speech Coalition case against the state of Texas. The petitioner's attorney representing the porn industry complained that Texas should have empowered and equipped parents to trust content filters rather than taking the, quote, very chilling step of requiring age verification for porn sites. The porn industry, service providers, application developers, and device companies point fingers, blaming each other, exploiting legal.
Thor will come back. Thor is my wife's hall pass. I have to make an edit to our Thomas Jefferson riding a velociraptor. I didn't even know Monica Lytle was still with us. Hey, glad to have you. We might have Austin Smith popping in here, AP 2022, AP Smith 22, former ESD lacrosse all-star, now turned litigator. He's in the office today. He might be joining us to talk about some tort reform. I think everybody here would love to hear from him. He's texting me, has SB 30 been discussed? Not yet. Talking porn right now. I really hope YouTube doesn't shut me down for some of the things I've said today, but we'll play it by ear. Seems like we got two. What we got in the. Oh, our poll. Great. Audio does not suck. All right, we can end that poll then. Thanks, guys.
Good morning. My name is Tom Mann. I'm here today representing the Computer and Communications Industry Association.
in opposition to Senate Bill 2420. CCIA is an international not-for-profit trade association representing a broad cross-section of communications and technology firms. First, we want to thank the sponsor for their openness to feedback on this bill, and we fully support your goal in protecting children online. But we'd also like to offer some thoughts today on age verification methodology. Current tools like facial age estimation are still a work in progress. The National Institute of Standards and Technology recently published a report evaluating 6 software-based age estimation and age verification tools that estimate a person's age based on the physical characteristics evident in a photo of the face. The report notes that facial age estimation accuracy is strongly influenced by algorithms, sex, image quality, region of birth, age itself, and interactions between those factors.
All right, y'all, I'm doing a design
Varying across demographics.
on our Thor graphic.
CCIA encourages lawmakers to consider the current technological limitations of providing reliably accurate age estimation tools across all demographic groups.
To try to add
Additionally, if age estimation is not used
to the live stream.
provide their license or personal information, that means collecting more personal data, which might worry families who value privacy as much as they value safety. Recent state
I
legislation
really wish I wasn't colorblind because I could see.
currently facing numerous constitutional challenges. The federal judges have placed many of those laws on hold until these challenges can be fully reviewed. For these reasons and the reasons listed in my written
I could
comments,
see better.
ask for an unfavorable report. Appreciate the opportunity to testify today.
Thanks for your testimony. Mr. Mayor, were you here for Ms. Fitzpatrick's testimony on the first panel?
I was.
Did you hear the description she read about an app that was approved for ages 12 and up on the App Store? Did that sound to you like an app that's appropriate for ages 12 and up?
No.
Not here to comment on the appropriate
Well, you are now.
individual app.
You are now. I want to know your position.
Oh man,
I wanna
shots
know
fired.
CCIA's position on whether that app available today, without this law, is appropriate for a 12-year-old.
Our position here today, with all due respect, Mr. Chair, is that the age verification technology that would be used to verify a minor's age to get into the App Store is faulty, and that's what the reports are showing right now, that it can't be accurately verified. If it can't be accurately verified through some of these different technologies, it has to be verified some other way. So what will that other way be? Our position is that whatever that other way will be will require that minor to relinquish more of their personal data.
Anti-big data. I mean, we can all get behind that.
I'd like to know, and thanks for we're listening, it's all being taken down, we want to get the details right. If you can't tell me today, I would like in writing from you.
Damn, we've been going 2 hours and 15 minutes, y'all. Thanks for staying with me. Thanks for the confidence. We appreciate it. I appreciate it.
That the witness described is appropriate for the age level that she described. Can you give that to us in writing?
We're happy to follow.
Will you give us an answer in writing on that question?
Yes, Mr. Chair.
Very good, thank you. Mr. Cleveland, I know you're a lawyer, we've known each other for a long time. We've talked about free speech a little bit. I think we all agree, but let's make sure we're clear. I hope it is not Net Choice's position that the First Amendment prevents the government from protecting children.
Protecting children. It's always to protect children.
Get that on the record.
No, that's not it at all. It's actually kind of in the reverse. The First Amendment protects everybody, and then, you know, laws with all kinds of permutations.
And do we also recognize that under the First Amendment, there is speech that is appropriate for adults, but that the government is allowed under the First Amendment to limit for children? Do we agree on that?
Absolutely. In fact, most famously, pornography, for example.
Beg your pardon?
I said most famously for pornography, for example, just one of a couple different categories.
So speech that would be allowed under the First Amendment for an adult, but for children, the rules are different.
In some cases, that is correct.
And that's because if we're going to impinge on a First Amendment right, wouldn't you say that the government has to show they have a compelling state interest and they're using the least restrictive means to achieve that interest? Is that close to the test as you understand it?
You said it well. That's close to the test as I understand. I'm not going to hold myself out as a First Amendment expert, but yes, those are some of the conditions.
Were you here for Ms. Fitzpatrick's testimony?
I'm sorry, what was it?
Were you here for Ms. Fitzpatrick's testimony, the lady that talked about her experience?
did you hear her describe an app, and she read the description of it in the App Store? We said it was for ages 12 and up. She mentioned it in her testimony, and then Senator Paxton asked her about it again, in case we didn't hear it. Did you hear that testimony? I did. Do you believe the app she described is appropriate for ages 12 and up?
As described, my answer is no. I don't know that app, though, so I can't really speak from firsthand experience.
What is the position of Net Choice on whether the app she described is appropriate for ages 12 and up?
But without absolutely confirming it, I think I can speak for them and say the same as my answer, which is as described, would not find that appropriate for 12 years old.
Like I asked Mr. Mann, I'm going to ask you to review the testimony and respond to us in writing with Net Choice's position on whether that app is appropriate for those ages.
I couldn't hear. What was the app's name? Do you guys know what it was?
Exposed to is what my notes indicate.
Sorry, exposed.
Exposed to is what my notes indicate. That's right. But again, you can go back and watch the video, and she mentioned it twice. Ms. Campus, you probably know what's coming.
Yes.
All right, guys. Sorry about that. I was a little distracted trying to make this stupid ass graphic that looks like shit, actually.
What'd you think about the app?
I gotta stop cussing. YouTube's gonna pull me down.
She read it was approved for ages 12. Did that sound right to you?
But based on what I've heard, that would say that was very questionable for minors. I would add that.
Let's do this. Let's replace it.
15-year-old son, 11-year-old daughter, and my son is autistic, so he's vulnerable. I'm very
I
much
love Thomas Jefferson. Why are we showing Thomas Jefferson? Because he stood up for the 7th Amendment. That's what we're doing today. All right, we're back to it. We're back to it. Okay, they are talking about right now not tort reform, but they're talking about
Taxpayers Protection Alliance have a position.
they are talking about the age verification process, or the age verification on pornographic websites, I think, or maybe any apps, because the design is good. It's designed. The design of target of the bill is to protect children. I think we all agree that children should be protected from porno websites. But the opposition to the bill is that, hey, this is a restriction on websites, on any websites that the government shouldn't be involved in. It's more of a libertarian approach. But still have not talked yet about SB 30. Haven't talked about our famous tort reform bill. We're going through it. I think we lost Andre the lawyer. Damn, I would have loved to have his commentary. Another Dallas personal injury lawyer. Very, very successful. Andre's always got good, unique approaches to litigation. Would have loved to have him, but I think we just lost him. Okay, so just as a quick update for everybody, this is the Goff law. Jimmy Goff, Jimbo Goff. YouTube, your Dallas lawyer, YouTube, we're here today talking about Senate Bill 30, House Bill 4806. And we're going to go through the good, the bad, the ugly, answer questions if we can, talk about the pros, the cons, the reasoning, the good, the bad, the ugly. While we're struggling, we've never done this before. I appreciate everybody's patience. Appreciate everybody in the chat sticking with us. We got about 10 viewers, it looks like. Got 3 likes. We are basically Jake Paul. If you follow Jake Paul, then you are following Goff law. Actually, we're better than Jake Paul, I think.
Welcome back. Introduce yourself. Give us your testimony.
All right, let's see.
Members, my name is Andrea Sparks, and I'm testifying in favor of SB 2420. Thank you, Senator Paxton, for filing this bill. I'm here on behalf of a nonprofit
SB 2420 is the new bill that they're talking
I
about.
co-founded called Not on Our Watch Texas. Not on Our Watch is an initiative of Texas Women in Business, and our mission is to engage women in business to educate themselves and others on protecting children from online harms.
This is still more porno bill. Mobile devices, protecting minors, protecting anyone under 16, I'm looking through the bill right now. Looks like it's related to software and data applications. Don't know anything about this bill. Might have to dive into it a little bit later. Let's go back. Let's go back to, whoa. We don't want that shit. The text of SB 30. We talked about what's coming in as evidence. Now we can get to the hot topic, the reason we're here today.
When we were growing up and playing outside, we saw one and we fretted, but the reality is,
this bill would absolve some companies from their shared responsibility to protect children.
All right, let me turn down that volume. So you know, I got to be listening to see if they're going to talk about SB 30. I can't figure out how to fix that audio though, guys. Sorry about that. Okay. All right, so standards for recovery in certain non-economic damages. All right. 41-151. This is the crap. This is where I got issues, folks. All right. The bill starts, and the bill's main focus is pain and suffering damages or mental anguish. What are those? What does that mean? Oh, shit. Need to back up out of this thing. Sorry, guys. We doing a little bit of struggling. Okay. Here we go. I hope that's better. I hope everybody can see that. All right. Pain and suffering. Let's take an example of you get in a car crash. You are burned alive. You suffer 50,000 degree burns. Your whole family's burned alive. Your whole face is burnt off. It hurts, right? Our founders in Texas said, look, under common law, you should be entitled to damages as a result of the negligence or carelessness of someone else. So if you get lit on fire, it burns, it hurts, the defendant's ultimately responsible, you should be compensated monetarily for that. Because there's no other way to do it. We can't throw companies in jail as much as they should be in jail. Oh, we got E.T. Tepperman on the way, baby. We can compensate people monetarily for that damage. Same with mental anguish. So, this bill, drafted by the folks at Texans for Lawsuit Reform, specifically by this dude, Lee Parsley, member of the Federalist Society, blah, blah, blah. This guy's the head of TLR. He's the one who's drafted this whole thing. His whole goal, on behalf of the insurance industry, on behalf of corporations across the state, especially the oil and gas companies, is juries are awarding, or there's too many settlements for pain and suffering damages, mental anguish damages. Those should be smaller. We don't like them. They should be smaller. So how do we fix that? We're going to limit the types of claims you can bring, limit how much money you can be awarded. We're going to change the evidentiary standard for allowing these claims in a trial. I've gone through this portion of the bill 20 times, and every time I read it, I learn something new. Hold on. ET's texting me about food. Jump scare. Got that right. All right. So let's start. As I said, I've read this like 20, 30 times, but every time I read it, we get somewhere new. So, damages for physical pain and suffering may be awarded only if the trier of fact is unanimous in finding that the amount will fairly and reasonably compensate the claimant for those injuries. So, let's kick off the bill with the jury has to be unanimous. Just the same way they have to be unanimous for gross negligence finding, punitive damages finding, everyone on the jury must disagree as to the amount awarded to you for pain and suffering or mental anguish damages. We've never had this before. It's completely unnecessary. All it does is it makes it harder for a plaintiff to recover these damages because if you go to trial, 12-person jury, and there's a vote 10-2, 10-2, some people on the jury, 10 people say, hey, we think these damages are appropriate, and we think that the amount we've awarded is fair. We think, let's say, $2,000. $2,000 is a fair amount for the pain and suffering that Miss Emily went through in her car wreck with Will Hatch. Now, you have 10 people who say yes to that. 2 people say, no, I don't think she should ever get money ever, or I think the amount is too high. I vote against it. I vote that it's too high. Now, because 2 people said it was too high, or 2 people said, let's say it was too low, thrown out. You don't get any of your damages for mental anguish and pain and suffering. We've never had that. Why would they do that? To make it harder to recover money for pain and suffering damages so the insurance companies, so corporations, so the oligarchs can make more money. But it doesn't end there. 2420 is still going. Okay, just checking in. All right. Austin Smith declining to join the live stream. I hope he's watching. I want the folks to hear from him. The guy's a great talker. I don't even know who's still with us anymore. I'm hoping. Looks like we got 9 people. All right, we're doing good. We're blowing up. We're Jake Paul. All right. The award. The award for pain and suffering. Oh, DT. DT might have joined us. Very famous personal injury. Wow. Wow. Man, that is humbling right there. DT, a great mentor to me. One of the best, most fearless trial lawyers in America. This is a guy, man, folks, if you get hurt, you want DT. You want people like DT. You want people like Emily Copeland on your side. This is a guy who says, you call up DT at 10 o'clock saying, I got a jury trial at 5 a.m., DT will be at the courthouse. I can guarantee y'all DT hates this because DT has taught me one thing, that 9 times out of 10, juries get it right. They either award too much, too little, but they usually get it right. I'm so happy to have him here. Hopefully we'll get some good input from DT. I pray he's as opposed to this bill as I am. And DT just opened up his own shop. So if you get hurt in the DFW area, please give DT a call. You'll be in good hands. All right, so back to the award for physical pain and suffering. We're 4 freaking lines into this bill. It must provide fair and reasonable compensation to a claimant for the period of time the pain, suffering, or anguish has persisted or can reasonably be expected to persist in the future. Must provide fair and reasonable. What do you think that means to the insurance companies? $5. It must be worth $5. There's no definition of what's fair and reasonable. That's what the jury's for, to determine what's fair and reasonable. Now the bill says it must be fair and reasonable according to who? Doesn't say fair and reasonable to the jury. It's really fair and reasonable to us, which we think should be 0 as the insurance industry. And it only has to be for the time period of the pain, suffering, or the anguish. That part, not shocking. Our jury charges. The other thing is our jury charges already reflect this. When you go to trial, when you're sitting in the jury box, you have instructions on the law from the judge. They already instruct you what the standard is. The lawyers will explain in the trial what's fair and reasonable. These lawyers don't just pull numbers out of a hat, or a lot of people think, or as Lee Parsley will testify in this bill, that jurors are just pulling random numbers out, or, wait a second. Money laundering. They're talking about money laundering. We good. Or that plaintiff's lawyers go in and ask for a giant number, and then every juror somehow agrees with that number. That they all just are so stupid, they just say, hey, we believe that guy. We don't care what the evidence was. We don't care we've been here for a week. Whatever Jim says at trial is probably true. Doesn't happen. What happens? I'm sure DT has had this happen, or Emily, or Will, or Adam, where they see someone ask for too much money on a small case and it backfires. Jurors, you put 24 eyes on anything, they're going to pick up on the BS. You can lose a lot of credibility asking for too much money. And that's what they think happens. That's what TLR thinks happens when these cases are going to trial. So, all right, we're under 2. Now let's go to 3. May not be used to punish or penalize the defendant, make an example, or serve a social good. That part is really just reflecting you cannot use pain and suffering damages as a punitive damage or having a punitive effect. Meaning, a plaintiff's lawyer can't say you should award $100 million for the pain and suffering and to set an example. The bill is saying, no, if you're going to punish someone, do it in punitive damages. What it doesn't talk about is this bill also sets a new standard for punitive damages, which is damn near impossible. Shock. Let's keep going. May not include amounts that are properly considered economic losses, like lost wages, loss of earning capacity, stuff like that. Nothing big there. It is, here's where we get to its reversible error. So now the statute is creating brand new rules of appellate procedure. I agree with DT, this bill is trash. They're creating new rules of appellate procedure, saying it's reversible error to do one of these 2 things. Meaning the plaintiff's lawyer can't do these 2 things. Doesn't say anything about what the defense lawyer can argue at trial. Don't forget that. We won't do anything to prevent the defense lawyer from saying something, or the corporation, or Exxon, or the pharmaceutical industry from saying something. It can only be the plaintiff's lawyers. It can only be the plaintiff's lawyers who are not allowed to say certain things at trial. So they cannot state or support an amount that has no rational connection to the case. This is coming from the Gregory opinion. The Texas Supreme Court, we'll get into their corruption here in a second. They said, legislature, we number one, don't like pain and suffering damages. They've done that for 20 years. We need a standard. We need a cap. We need some metric that has to be connected to the evidence, but we're never going to tell you what that is or how to meet it. You just have to figure it out, and then we'll reverse it anyway. Well, you sense my bias here, folks. Got a little bit of bias. But what they're really targeting here is that a plaintiff's lawyer, you might have seen this on TV, a plaintiff's lawyer can't get up at the end of a trial and say, you need to award pain and suffering in amount equal to the Mona Lisa. The Mona Lisa is $100 million, and my client has suffered at least 10 Mona Lisas worth of pain in this case from these injuries. Can't do that. Or a trial I had in, maybe it was Rockwall or Denton, where the plaintiff's lawyer got up, this is when I was on the defense side, plaintiff's lawyer got up and said, this person's life was worth the price of an egg. It was a famous bejeweled egg. Let's see if I can find it. Not a Fabergé egg. It was one of these things. The plaintiff's lawyer got up and said, this is a $5 million egg. And Joe Smith's life, all the pain he went through was worth at least $5 million. Well, the Supreme Court says that doesn't have anything to do with the evidence brought in this case. You can't use it as evidence or a number connected to pain and suffering. So that's what this gets to. What it doesn't get to is values. I understand referring to objects. Repeating metrics. I think what it's referring to is the Warner case, which was the defendant had driven 10 cents a mile, had driven 100,000 gajillion miles, award $1 million for every 10 cents. Something like that. You get it. That's a repeating metric. Or they'll drive this number of miles for the next 100 years. That's the amount you should award in mental anguish damages. They don't define what it means to have no rational connection. And it'll be interesting today what the testimony will be. Senate Bill 517 now in front. Hold on, folks. Let's check in on our legislature here. State affairs ain't breaking for lunch, that's for sure. All right, looks like we got someone on 517.
Good morning, Mr. Chairman and the rest of the committee. Thank you for having us here today. My name is Sheriff Bo Stallman. I'm from Missouri County, Texas.
That's some kind of sheriff. I don't know what he's talking about. We're good. We're not at tort reform yet. Okay, so let's get rid of the eggs. Let's get rid of the miles driven. Let's get rid of the Mona Lisas. You can't use that. We're not going to tell you what evidence does have a rational connection or what would survive on appeal. I want to jump down. I'm getting a little ahead of myself. But the only ones that really will work, this gets to the remitter language at the bottom of the bill, it's ones that went on appeal and were affirmed under comparable facts. We're okay with that. That's the new appellate standard. Is if you can find a case or judgment that was rendered and then affirmed, it has to be appealed. It can't just be you settled at the trial court after the judgment. It had to have gotten appealed and then affirmed, which is so little, so rare. It's just stupid. We're going to dive into this in a second, but let's go back up. No definition of rational evidence. Honestly, rational connection is zero. You have to keep in mind, folks, their goal is there should not be damages. They've done this. Scott Brewster went in front of the Texas Supreme Court and argued you shouldn't have mental anguish damages or pain and suffering damages because there's no amount of money that could ever compensate truly. The only thing that can compensate you for pain and suffering damages is if you find God. Why? Because we don't value human beings and we don't care what monetary value you put to them, the jurors. Remember, ultimately, it's not what the plaintiff's lawyer is putting towards these as damages. It's what they have to convince 12 people, 24 sets of eyes, to agree that this number is the right number. And then they have to write it down. This is an interesting portion. Number 2, cannot say through a person, witness, or argument. Why's my screen getting all blurry? There we go. Through attorney, witness, or other person through argument, the introduction of otherwise or evidence otherwise to characterize an award of damages for physical pain and suffering or mental or emotional pain or anguish as establishing a valuation of human life. That's about as clear as mud. I think that what they're doing there is they're saying you can't say that the award for physical pain and suffering is the equivalent of dying. Chad, help me out here. What does it mean establishing a valuation of human life? Meaning you can't put a value on if they had lived or the pain and suffering before they died? Or I don't know. That doesn't make sense. It'd be interesting if they bring this up today. Characterize an award of damages for pain and suffering as establishing a valuation of human life. I think they're saying is you can't inflate that the pain and suffering is equal to normal life or the value of their life. Like equating pain and suffering damage to if they had died, or the will to live, or what's the price on human life, meaning their pain is so high that their life isn't even livable anymore. So what's the value of a human life anyway? Except to the extent of a conflict, this section supplements court decisions and rules of procedure and evidence. This is insane. So with one bill, goodbye common law, goodbye rules of appellate procedure, goodbye rules of Texas evidence, like 403. Remember that one, guys? All my lawyers in here? This trumps all of that. Even all the prior case law. We, the insurance oligarchs, chose this language that it's our words that matter, no one else's. Don't question it. Take what you've been given. We value life. The insurance companies value life. You can't value your own. Jurors can't value your life or their own lives. We get to decide. That's what they're ultimately after. We want to value human life because we're the ones who have to cover it. Pretty disgusting. Okay, now we get to jury instructions. If you're seeking non-economic damages, the court shall provide definitions and instructions for these categories: past and future, pain and suffering, past and future mental anguish, past and future injury direct. We already do this. You already get jury instructions on these definitions. And they don't even supplement what those instructions would be. I mean, we have a thing in Texas called a Pattern Jury Instructions Committee, who for years will debate the smallest little comma in our Pattern Jury Instructions, PJC. Now, just like they said, our word trumps whatever the courts or the other rules have said, same here. Our words now trump the Pattern Jury Committee. That's how much we hate plaintiffs. Or not even hate plaintiffs, that's how much control we need. Because you are the servant, we are the master. Am I getting too preachy? Have I gotten to that point in the day yet? I'm getting too preachy. We need to update our folks over on Instagram, don't we? Let's do a little shot here. Hey y'all, we're here live streaming the new tort reform bill here over on YouTube. Come join us. We got some great folks over in the chat debating, talking pros, cons on the Senate Bill 30 today. So please join us. We'd love to hear from you. Senate Bill 30 has not come up yet. They've talked about child porn with kids, cell phone apps, blah, blah, blah. Live streaming the new tort reform bill here over on YouTube. Come join us. We got some great folks over in the chat debating, talking pros, cons on the Senate Bill 30 today. So please join us. We'd love to hear from you. Senate Bill 30 has not come up. Hey y'all, we're here live streaming the new tort reform bill here over on YouTube. Sorry guys, I am posting the live stream. We can hopefully get some more folks. Although I love having the folks we got right now.
Come join us. We got some great folks over in the chat.
All right. Got to keep the public informed. We got to keep the public informed. We got to do better. No word on ET yet. I think he's on his way. Can't wait to have him. All right. Now we have the remitter section. And remitter is when the judge has the power to lower or raise the amount of the jury verdict for certain damages. What's unique about this, no mention of raising the amount of damages. If the judge says, hey, Miss Emily's case was only, jury came back with only 2,500, I think she had at least 30,000. Can't raise it, can only lower it. On a motion, the defense has to file a motion. A trial court shall state the factual and legal support. Well, yeah, motion. You do still have to file a motion. State the legal and factual support for the amount of non-economic damages awarded to the claimant in the judgment if defendant requests remitter or non-economic damages awarded to the claimant and the award exceeds $1 million for a death case, $250 for a bodily injury case. There's also distinction here on if it's a emotional injury, which I think is really targeting maybe a sexual assault case or damage to reputation case. But essentially what 153 does is it says, Judge, you got to provide the evidence, the facts, and the law on why the damages were over $250,000 in a personal injury case. And not only in your legal support, you not only have to cite cases, but you have to go into the Court of Appeals and find judgments that were affirmed, verdicts that were affirmed. So you got to do two hurdles. You got to find a personal injury case that was affirmed on appeal. Good luck. Two, you have to find cases that even went on appeal. I mean, what if I get a verdict for $250,001 and the case isn't appealed? Then it could never have been affirmed. Maybe it was going to be affirmed. Maybe it would have given the judge more of this data to use in the final judgment, but it never got there for whatever reason. For example, in the Spectrum murder trial put on by Chris Hamilton and Ray Caralla, over $1 billion, I think it was rendered in damages in that case. And TLR has actually posted a video criticizing that verdict, saying that the plaintiff got over $1 billion, which wasn't true. What happened in that case after the verdict is it settled on appeal. Well, if that case had been affirmed on appeal, could the judges now, under this new bill, cited it as support? They don't want that. They don't want good findings for the plaintiff. So my whole point on this section is it's going to be so damn hard to find not only the judgments that were affirmed, but let's get under the second part here, which is so critical. Comparable facts. Every case is different. How the heck is a trial judge going to go find comparable amounts with comparable facts? How? People's bodies are different, people's cases are different, people's injuries are different. That's the great thing about our system is each case is unique. So let's defer to each case. It's not a widget metric system. I don't know how in practice this will work. I hope, if anything should get shut down, it's this part. I mean, it makes no sense. It puts a tremendous burden on the trial judge, and it delays the results. Clogs up the court system, costs the taxpayers more and more and more money. If you think that this section, this part of the bill is good, comment below that you love it. Comment below. DT's got to run. Hope you can jump back in, DT. I'll shoot you a text when they start covering SB 30. Thank you for tuning in, brother. Now, prejudgment interest. The prejudgment interest is really just, hey, prejudgment interest on a personal injury case. those can only be, the prejudgment interest can only start at the time the healthcare expenses are actually paid or the economic losses are suffered. Not when your pain and suffering starts, not if your bills are still due. Let's say you don't have health insurance. You go to the hospital, say, I don't have health insurance, then you're going to get a bill saying you owe $10,000. Well, that hasn't been paid yet, even up till the time of trial. So you're never going to get prejudgment interest on any of those amounts. And let's say you didn't have any economic losses, or they were too difficult to calculate. Meaning, yeah, I lost a lot of money when I couldn't go to work, but I'm a commission-based worker. I'm going to have a real hard time putting that into paper. So you know what, lawyer? I'd rather not pursue that. Well, even if you choose not to pursue it, you're waiving prejudgment interest. So why is that a big deal? Well, Jim, I don't make my money on prejudgment interest. You're right, lawyers don't. Here's what it does. It rewards delay. It rewards delay. And how do you measure are actually suffered, by the way? What the hell does that mean? Are actually suffered. What's the standard of proof of actually suffered or actually paid? How do we get that? Is that now admissible? Do I have to prove that up at trial? Let's incentivize insurance companies, corporations, pharmaceutical companies from not paying claims because you're not going to get prejudgment interest because of their delays. It's further incentive to screw you. All right, we've gone through the bill. I'm sure I missed some stuff y'all would love to hear in the chat. Hey, can you go back to this section? What did you think about blah, 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 blah. We've been going, how long have we been streaming? We've been going 3 hours, y'all. Thanks for sticking with me. I hope this hasn't been the most boring thing you've ever done. I know I sound like a crazy person. My wife, I know, has logged out because she hears this when she gets home every day. We could, if we wanted to, jump into exemplary damages. There's a couple changes on jury instructions regarding exemplaries. I haven't really focused on those because the exemplary damages are so impossible under today's case law anyway that they're not really that effective. I mean, just like in any, I think it's just redoing the numbering, if I'm reading this correctly. Net worth discovery, blah, 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 blah. Oh, I forgot about this. Jesus. Forgot about how this will affect negligent security cases. We're not going to get into that. It's too much time. In an action arising from harm resulting from assault, theft, or other criminal act, court may not award exemplary damages. So let's say I show up at your apartment, I shoot you in the face. The apartment manager knew about it for years. The apartment owner knew about it for years. I didn't put up security cameras. I didn't do anything to protect my residents. I shot you in the face. Your family cannot recover punitive damages. So what's my incentive as a criminal? Assuming I'm not in jail, probably am in jail, but let's assume I'm not. I'm going to go shoot some more people. Or I'm the apartment complex. I'm not going to protect my residents. And if I get sued for it, I'm going to cap the family's damages anyway because Jim shot him in the face, but probably didn't suffer that long. So here's $250,000. And there's no prejudgment interest. And it has to be unanimous. And what are we doing? What are we doing? Oh, forgot about this. Physical pain and suffering. What's the standard? I forgot about this. Is huge, y'all. This is huge. Let's check in on the Senate, though.
Thank you very much. Your excuse. Is there anyone else wishing to testify on or against Senate Bill 517?
Sounds like they're still on 517.
Seeing and hearing none, open testimony is closed. Bills left pending this time. Pass the gavel to Senator Shorter to handle 3 quick bills.
Chair lays out Senate Bill 1845 and recognizes Chairman Hughes to explain his bill. 1845.
All right, I don't know what these bills are about. Let's take a quick listen, though. And then we'll go back to what's the standard for pain and suffering damages.
Influence, especially from countries labeled as foreign adversaries by the federal government. Senate Bill 1845 will safeguard Texas from foreign adversary influence by strengthening oversight on lobbying activities conducted on behalf of foreign adversaries.
All lobbying efforts, not Russians. Oh, I ain't going there. I ain't going there. But, all right, with that, I'm going to leave this going. Let's listen in on what they do. I'm going to go take a break. I think ET is real close to being here. So let's keep this running, and I will be back. Thanks, everybody, for tuning in. This has been a lot of fun so far. Still have not heard anything about the tort reform bill. Oh, sorry, Emily. Yeah, that is ridiculous. Oh, and the family has mental language damages capped. That's exactly right. That's exactly right. Good point by Emily there. All right, folks, I will be right back.
Making sure that all advocacy efforts on behalf of adversarial interests are disclosed or covered. Not just disclosed, but addressed in the law. This bill would eliminate financial incentives for lobbying by prohibiting registrants from receiving direct or indirect compensation from foreign adversaries. And this targets potential conduits of influence, such as subsidiaries, officials, or political organizations under foreign adversary control. Under the bill, the Attorney General can pursue injunctive relief and civil penalties of up to $10,000 per violation, a forfeiture of illicit compensation, and cost recovery for legal actions. This bill is about fortifying our democratic processes, enhancing transparency and lobbying, and protecting public policy from foreign interests whose interests may conflict with those of Texas and our country. I yield for questions.
Thank you, Mr. Chairman. Questions of the author? Hearing none, Chair opens up public testimony and calls Michael Lucci. Anyone else wishing to testify, please come forward and have a seat. Welcome. Please state your name, position on the bill, and you have 2 minutes to testify.
Thank you, Mr. Chair. My name is Michael Lucci. I'm the founder of State Armor, and State Armor's mission is to pursue state policy solutions to global security threats. I think that the legislation this committee is considering speaks directly to those threats. I think that the key point that this legislation addresses is that we provide adversaries an asymmetrical access point to our political system that not only do we not have into their political system, their own citizens don't have that type of access point into their political system. So if an individual in the People's Republic of China or Russia or Iran wanted to advocate for changes, many good changes within those systems, they couldn't do so. They'd most likely end up in jail for doing so. On the other hand, we're allowing those adversaries defined by the federal government to access our political system, shape policymaking at the state and local level, and this gives them an asymmetrical advantage. It's a big advantage to our system overall that we are open and democratic, but when we're confronted with this sort of axis of autocracies, we have to take protective measures to make sure that they're not influencing our internal system, they're not having a vote in our internal system in a way that will damage us in the long run. I'll refer to the memo by the Director of National Intelligence from 2022. This was issued under President Biden, where it highlights specifically that the People's Republic of China has an extensive and well-developed influence operation campaign that targets state and local officials. They want to collect information, shape policymaking through the business community, and generally exploit advantages at the state and local level to turn state and local policymaking away from America's national interest, taking advantage of that seam in our system where the national security expertise is at the federal level more so than at the state level. So I'll close by saying that this legislation would kind of close that loophole that gives our adversaries an asymmetrical advantage within our system.
Thank you, sir. Members, questions of this witness? Appreciate it. Hearing that, we're going to close public testimony and leave Senate Bill 1845 pending. Chair lays out as a matter of pending business Senate Bill 1860 by Chairman Hughes. Sir, you're recognized on 1860.
Thank you, Mr. Chairman. In the 88th legislature, we passed the SCOPE Act, Securing Children Online Through Parental Empowerment, House Bill 18. And that was based on the failure of digital providers to protect the safety of Texas children. It requires internet providers to implement systems to give parents greater control over their children's online activity and to prevent obscene material from being easily accessed. As a means of achieving children's safety, both in the home and in the classroom, public and charter schools were incorporated into the demands of the Act in the Education Code. Giving parental consent to software, monitoring data collection, and having appropriate restrictions to social media are a few examples of the manner in which educational institutions must comply. Higher education entities are currently exempted. The bill before us would clarify that private schools are included under the digital and TEA requirements of the SCOPE Act. That's all this bill does, takes existing policy where we considered public and charter schools, but did not specifically include private schools. That's what this bill does.
Thank you, Senator. Members, questions of the author? Hearing none, we're going to open up public testimony. There are two people wishing to testify. The chair calls Laura Colangio and Vanessa Savage. Anyone else wishing to testify, please come forward and have a seat as well. Please state your name, position on the bill, and begin.
Good morning, Mr. Chairman and committee. My name is Laura Colangelo. I'm the Executive Director of the Texas Private Schools Association. We represent the 941 private accredited nonprofit schools in the state, enrolling approximately 308,000 students. I'm here very much in favor of SB 1860. We are grateful to you, Chairman Hughes, and everyone sitting at this table for your commitment to protecting the safety of children everywhere in classrooms and online.
This bill is about safety for children, laws protecting minors from harmful material on digital services. This might be a continuation of the prior do not know. Let's keep listening.
Thank you for your work.
Thank you. Members, questions? Hearing none, Chair Vanessa Savage? She here, Vanessa? Okay. We're going to close public testimony and leave Senate Bill 1860 pending. Chair lays out Senate Bill 2429 by Chairman Hughes. And Chairman Hughes, you're recognized on 2429.
And I thank the chair.
2429.
429 is about genetic information. Hard to imagine much.
Genetic information. 23andMe?
For every Texan. Foreign adversaries, such as the People's Republic of China, the communist regime in control of that country, have identified biotechnology dominance as a critical priority for their military and their global ambitions. Bipartisan legislation backed by leaders of the House Select Committee on the Chinese Communist Party and the Senate Homeland Security Committee was introduced in 2024 to ban China's largest genomics company from doing business in the U.S. after years of warnings from intelligence officials that Beijing is gathering genetic information about Americans. A significant factor in biotechnology, of course, is access to genomic sequencing data. Senate Bill 2429 will secure the genetic information of Texans with a focus on protecting genome sequencing data. Requires medical and research.
All right, he's talking about protecting genomes. I don't know what that shit's about. Huh. Interesting. All right, folks, we are still kicking. We are still doing our thing. If you've enjoyed your time with us today, yeah, with everybody, it includes me, includes everybody on the live stream. This prevents the selling of genetic information of Texans. I think everybody's for that. That doesn't sound too bad. All right, let's check in. Checking in with our folks. Yeah, I got a lower. Hey, F China, valid concerns. I like that. Thank you, Garrett. It just turned down the volume on. Yeah, the legislature's purposely turned down because I can't have my audio on at the same time as them. So when we've been having bills that are not the tort reform bills, what we've been doing is kind of lowering that volume. I'm keeping it on a little bit so I can at least hear what bill's on the floor right now and make sure we're not going to miss out on the tort reform discussion. But we thank you for joining us. Give us a your thoughts. Make ramble on. I got a feeling that that's a Garrett McLaren. They're your thoughts on Senate Bill 30, how you think it's going to impact us here in Texas, how it's going to impact your clients. Oh, this is not Mrs. Garrett. This is Sarah McLaren. Oh, snap. It is always good to see Miss Sarah. All right, still waiting on ET. Still kicking here. Still doing our thing. Let's get back. I don't care about biotechnology. Let's go back to the bill. All right, we're back. How are we looking? How are we looking? All right. So we were talking a little bit about what's the standard of proof on pain and suffering. How do you prove it? I know I'm capped. I know it has to be unanimous. I know I can't recover my medical bills. I know I can't do this, 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 and this. But what is the jury told on what is pain and suffering, or what are pain and suffering, physical pain and suffering? How does that define? Well, the statute does it for us here. It's associated with an injury to a part of the person's body. That kind of makes sense. You do have to have your body injured to suffer some kind of pain. Oh, I'm getting... Sorry. Okay. It's consciously felt. You have to have actively felt the pain, which I would assume the only way I see that could be, well, your nerves were so burned off, or your adrenaline was so high when your arm got chopped off, that you didn't actually feel the pain. Now, we think that you certainly medically probably felt something if your adrenaline wasn't going, but you don't have any evidence of physical pain because your nerves were fried off. Okay, so consciously felt. All right, that's your first level. And it has to be all of these. Consciously felt is significant in magnitude. Well, what does that mean? What one person finds significant, another person not. So maybe someone who had their leg chopped off doesn't think a herniated disc is enough to be considered pain and suffering. There's no definition of significant. There's no definition of in magnitude. We're just left to guess once again. So what's our guidance from that? Maybe we'll get some guidance from the legislature today, but I don't know what that means. Significant in magnitude. I think all pain and suffering, physical pain and suffering, can be significant. And let's leave that up to the jury to decide if they felt and what they heard from the plaintiff or the family and friends, if the pain was significant or what it was. Well, if it was a scale, if it was a 2 out of 10, then it's not significant and you shouldn't get high damages. You shouldn't get... Where is Matt Kita? Great point. What is pain? Another great point by Sarah. E.T. has arrived, folks. Let me go get him. But think about that. Think about what it means to be significant in magnitude and arises from an observable injury. So I need to be able to see it outside of your clothes, or is shown through objectively verifiable medical evaluation or testing. I don't know what that means. Let's go get E.T. Let's get him in here. Let's see what he thinks. We'll be right back. I want to hear what your thoughts are on this section. We've been talking about him all morning, folks. He's here. I think I'm going to have to change my camera angle. He's in the storage closet. Welcome to the storage closet, E.T.
Well, thank you for having me.
Thank you. This is the only microphone we have because we're a little broke here at Golf Ball. But he's finally joined us, folks. Good to have you, man.
Well, it's good to be here. Just a little easy drive down from Denton.
Yeah, dude. Why did you drive this far? You know why? Because he cares. I don't know if the microphone will pick up both of us, but I know it will pick up you.
Well, because I'm holding it.
That's right. I have a second mic, though. Sarah, comment in the chat if you can hear E.T. And I'm going to see if I can get the second one to work.
So actually, I need to brush up on what actually they are doing in this bill, other than trying to screw all Texans.
Jack Kelly welcomes ET. Jack, let us know in the chat if you can hear both of us now that I have this microphone on too. Jack is next door. So this bill we're covering today. Oh, did they dip out? They dipped out for lunch. God, these people do not work, ET. Do not work. So the Senate has dipped out for lunch. Senate on State Affairs is hearing the new tort reform bill. So the new tort reform is SB 30/4806, which essentially caps all damages.
In any kind of case,
Any-
it's a total cap on
Any case.
non-economics.
It has to be personal injury case.
So, of course.
Right.
Not any of their business disputes that they would
No.
have.
No.
Not insurance company to insurance company, probably.
No. And so we've been breaking down the bill little bit by little bit. The biggest parts are recovery of medical bills, meaning your paid versus incurred, your 18001 affidavits, that's all changed.
Which they're almost meaningless anyway.
That's right.
Based on various changes in case law.
That's right. You
Yeah.
now have a failure to mitigate damages if you have health insurance, but
Wow.
don't use it.
So collateral source is gone.
Right. Let me ask this. We talked about this. A defense lawyer brought up a good point. Have you ever had a client who has health insurance and their doctor won't treat them because they were in a car wreck?
All the time.
All the time, folks. So it's not just me. This is live testimony from another person.
I mean, they won't even answer the phone. They'll see your call coming, and I mean, it's ridiculous.
That's right.
Most primary care doctors don't even know what to do when there's a crash
That's it.
or a personal injury.
Thank you. So that's what we've been talking through. There's another thing on all medical expenses are only reimbursed at 150% of a new database that they're going to create down at UT.
Okay.
So essentially, your reimbursement rate is going to be Medicare rates for all LOP. All your anyone that treats on LOP is discoverable. You have to disclose your agreement. You also have to come up with an anonymous list from the past 2 years of any client you have sent to that provider. Which I don't know how
Is this going to pass? Like, is this like?
That's everybody's watching today. That's what we're trying to figure out.
I mean, that is ridiculous.
You have to send the list of the anonymous list of clients for 2 years, which you then have to go find, which would take a huge amount of time. Then you also have to state with your list the amount of medical bills and what you paid on what date.
Like in previous cases.
Yes. Yes. That's just on the LOP side. You also.
So this isn't just a partial. This is a full gutting of all personal injury litigation.
Yes.
Or not just litigation, but. So and this what you have up here. This is the proposed.
This is the language of the bill. Listen to how crazy this is. So another thing that's discoverable. Here's your section on identify your clients from the past 2 years. Name, address, and telephone of who made the referral. So now you're a fact witness, I take it. Where's the other section?
Well, keep talking. I want to know. I want to find out more. Let's talk. We should talk a little bit about who's introducing these bills too.
We will. We will. Oh, also, your treatment is now compared to workers' comp as to whether the treatment guideline was right. There's a section in here of, you have to disclose any unwritten agreement that you have with the provider.
What does that mean?
I don't know. I think it means is if I call the provider and agree on the phone, hey, will you treat the client on LOP, that you have to disclose that somehow. I would imagine it's in your initial disclosures. You have to put in there, I have oral agreement with provider. Otherwise, I don't know. And then I think you're a fact witness.
So then you would have to be disqualified.
That's a great point. I guess you would be disqualified.
So, okay, so collateral source, and for those, do we have folks on here who are non-lawyers who don't
We do.
know
We have
about, because we're talking some inside baseball.
We are talking about it. We, like Sarah McLaren, wife of a very famous, well-known Garrett McLaren, states lawyers can't be fact witnesses for their client, right? Yeah.
Right. I mean, unless, and then if you end up having to be a fact witness, you would have to be, I mean, if this is something that's going to be in front of the jury, you would have to be disqualified as counsel.
Right.
You have to withdraw.
I never thought about
or
that.
Court, I mean, yeah, so this is a way for, which is, by the way, I mean, the disciplinary rules, I think I need to
brush up
in terms of like, there's a lot of, you know the important stuff, but I think it's discouraged to try to use the rules to disqualify opposing lawyers. So
that's a good point.
maybe that's in case law. They're like, hey, you're not supposed to. When I first started practicing, and I didn't do personal injury, there was a little bit of Scientology litigation I was involved in, and that was one of their tactics, was try to figure out a way to make up a bunch of BS and say, try to disqualify.
Yeah.
Really, the only way it's appropriate is if your client, if there's a conflict of interest.
Right.
And you're an attorney, and on the other side, they go, wait a second, this guy represented my client 2 years ago, or still something like that.
Right.
Right. So yeah, I mean, I think this would make lawyers become fact witnesses. But I want to say something that I'm very excited about if this passes is that all insurance defense lawyers will be jobless.
Yes, we did talk. We've talked about that.
Yeah, I mean, it's going to be a huge, and that's fine. I mean, if we're not able to represent our clients, and their constitutional rights are taken away, then there's no reason for these insurance defense lawyers who have big offices down the street,
right,
with their names on buildings. I won't mention any of them.
Yeah, there are some very famous buildings near here.
So I hope that if they're proponents of these bills, then
well, let me tell you a little bit behind the curtain here. Is a lot of insurance defense lawyers I've talked to have said this bill sucks because it gets rid of our jobs.
Obviously.
We can't testify against the bill. Why is that? Because when I was a defense lawyer, I tried to go testify against House Bill 19, if you remember that big trucking bill that went through.
So were you still in the defense firm?
I was still at the defense firm.
Yeah.
I wasn't allowed to go because the partners told me if one of the carriers sees you on there, we're all fired. So we're going to get fired if you testify against the bill that will get rid of our own jobs.
Yeah.
That's the conflict. But I mean, the bill goes, we've gone through it a little bit. I mean, it goes into what you can argue for non-economic damages.
Oh, wow. Even that. Wow.
You can't mention inanimate objects. You can't mention like my pain and suffering is worth the price of Mona Lisa. Has to be rationally connected. One thing I wanted to ask you about.
But not above a number that was a cap 25 years ago.
Right.
That, is not worth the same as that was then.
So one thing it says is it essentially takes Chohan and puts it into a statute, saying you can't refer to objects, values, or metrics having no rational connection.
Right.
That's fine.
But Chohan
even though this supplements court decisions. But what do you think about this? It says, characterize an award of damages for pain and suffering as establishing a valuation of human life.
All right, let me read this, okay. So these are what you can't do?
Yes.
You can't characterize an award of damages for physical pain and suffering or mental or emotional pain or anguish as establishing a valuation of human life. I mean, isn't that what... So this is basically saying you can't practice law. I mean, you can't do what the purpose of these laws were designed to do.
I think it's saying you can't get up in closing and say, my client is in so much pain they can no longer really live their life.
Yeah.
And what's the value of human life? The value of human life is $1 million. Therefore, their life was taken away because they're alive but in so much pain that their life is meaningless. So how do we value human life? Well, I think it's only $1 million. Or I think it is $1 million. Or I think it's $5 million.
So you can't make that argument.
So you can't make that. I think that's what... But there's no definition. Then you get into, I don't know if you've seen this section on remitter. So they can, the defense can file a motion for remitter if the damages are over $1 million in a death case, over $250K in a PI case. But here's the part I find nuts, is the court shall in their judgment, so they have to state factually the legal and factual support for the amount of non-economic state court judges. And then they have to include references to judgments rendered in this state and affirmed on appeal.
I mean, this is. I'm surprised it's.
I can't
this
even.
Is what the final bill, and if we're going to vote on this. Like
this is not the final bill.
This isn't okay.
This is the first hearing on this bill.
Okay.
I can't name 5 cases that have been affirmed on appeal. I don't know how a state court judge will find a PI case affirmed on appeal and has to be of comparable amounts and comparable facts.
So they're trying to codify. I forget the name of that. There's some doctrine about the federal courts use it in some cases. And I forgot, like basically looking at other awards.
Yeah, it's like a comparison. It's not a comparison. It's a
which itself is kind of silly because it's like, well, this is an award, so why don't you use this one to bring those other ones up?
That's what we were. That's what I talked about. It's like if you take the Spectrum verdict, which was over $1 billion, and I get a verdict for $251,000. Why can't the trial judge say, well, this is comparable to the $1 billion?
Yeah, I should get $100 million. Why not?
Here's the unique part about this bill. It's the only remitter where you can't go up in damages. It only allows you to go down. Other states have remitter where you can go up and down. Not here.
Well, it's like additive, right? Isn't that what's called?
Yes.
Okay. So they're saying that you can't do that.
You can't do that, but you have to find a case with comparable facts, with comparable amounts, that then was affirmed. And it doesn't say on what level of appeal. Does it, if it's appealed by the 5th Court of Appeals, is that fine? Or does it have to be affirmed by the Texas Supreme Court, who's never affirmed?
They don't affirm big verdicts anyway.
They've never affirmed a plaintiff's verdict in over 25 years. So that's where we're at with this. We were going through.
So what would have happened? Like, what would Governor Abbott's settlement have been?
11. Well, it was 11 million at the time the tree fell on Hot Wheels.
So what? Yeah, what would it have been with this? I mean, because he would probably.
It would have been 250.
Right. That's it. For
never
being able to walk. He might have gotten some economic, but not. I mean, not 11 million.
No, because he was at the AG's office, so his salary would have been.
Well, he probably would have gotten none.
He probably would have gotten none because he could still work.
He's still working, but I mean, I'm talking about like life care economic.
Oh, I don't know.
Because it probably is some amount.
That's what's so hypocritical is that our own governor supports tort reform that made him a millionaire.
I mean, it probably is the reason why he was able to get into politics.
Probably. Now, I think $11 million to put me in a wheelchair is too low. Would you sign up, say, E.T., I'll give you $11 million to sit in a wheelchair?
That's 1985 money, right?
I know, but yeah. Even I wouldn't do it today for $20 million.
I wouldn't do it for anything. Like, I don't think people realize that. And that's the interesting thing about, jury trials and jurors and what they say in the jury room. And, because I just tried one 2 weeks ago in a tough county that's not a fan of economic damages. And, there was at least one person it was 11-1, right? So we won, didn't get what we wanted, but, one juror said, I wouldn't have sued if it was me. And even the defense lawyer was like, yeah, I don't know about that. But it is hard. Like, none of this is, people think that this is just really simple, right? They think that,
They always give $100 million.
Always, all the time. Runaway juries, right? I mean, if people knew, and I know that probably the people who are on this stream are friendly to our type of work and what we do and the importance of what we do. But, so many people think that, it's just easy to do this. And every time, so here's an example. In jury selection, there was a lady who raised her hand and had recently lost her daughter from an 18-wheeler crash. And, she's bringing a suit on behalf of her daughter, and her daughter had some kids. And they would have treated that person, like people think, oh, it's a death, so they wouldn't. They would treat her and those kids the same way they treated my client, who was still alive. Was hit by a car while on a bicycle. You don't realize You know, this is what the industry, the insurance industry does.
Yeah, they've convinced people of that.
You know, because let's talk about case of paralysis, right? Let's talk about the governor. You know, I'm sure he would have been happy to just go on his run and go study for the bar exam, and never would have had that happen.
Right.
You know, and because I don't think anybody wants that to happen. Like you said, how much would it cost to put me in a wheelchair? I wouldn't take any amount of money. But that's the point, right? I mean, it's kind of, I laugh because it's ridiculous. I mean, this is these.
Well, even on your verdict
bills.
last week, you now can't support an award for pain and suffering without unanimous. So even under 11-1, you still would have gotten 0.
I would have gotten zeroed out. Huh. So what states should we move to?
That's the next question.
I mean, I don't want to. Let's not get there yet.
Yeah,
right?
let's not get there yet. Let's see which.
But because it's not just about us, man. This is about the people.
That's exactly right.
It's about everybody. It's about every single one of them sitting up there in those chairs.
Right, who all have kids.
Who all have kids. It could happen to them. I mean, what's the value of not picking up your little kid anymore? Like, you're alive. You can go to work.
You can exist.
But I can't go and pick up my kid and one day, you know, you're a dad, that your kid's going to be too big for that one day.
Expanded efforts to present inflated medical bills to juries to enhance monetary awards.
Oh, here we go. Now we're on.
We're on.
Here we're on. Okay, we got to order some food while we're at it. Let me switch over to our live stream here.
Compensatory damages. For historical context, in 2003, the legislature passed HB 4, the Tort Reform Bill, which included a one-sentence statute.
So for the benefit of the audience, ET, I have to lower our volume when we want to, or I have to lower the senator's volume, or pause it when we want to comment.
However, certain personal injury attorneys are able to avoid the limitations of the current statute by colluding with cooperative help.
Colluding. We're guilty of collusion.
I mean, this whole thing is couched in us being
geniuses. We're so smart. I didn't know I was this smart.
Well, am I allowed to curse on here?
Yeah, you're. Well, I think so. We don't know. YouTube hasn't taken us off yet. So this must be the sponsor. This guy.
Do we know anything
providers
about? Let me
who overdiagnose,
got
overbill,
Wi-Fi up in here,
and overtreat.
Yeah.
So I can start looking
These
people
lawyers
up.
are able to present the artificially inflated bills to the jury, thus inflating the value of healthcare treatment, and secondarily, the value of the overall award. In addition, and further complicating personal injury cases, the compensation calculations currently in law have ambiguous and easily manipulated provisions that allow for hyperinflated, non-economic damage awards. Members, this is what is commonly referred to in the media as nuclear verdicts.
There it is.
Or jackpot justice.
Jackpot justice.
And since
It should be
2009,
SWL.
no state has experienced more nuclear verdicts at the trial court level than Texas.
Not true. Not true. We actually don't have the most nuclear verdicts. We also have never had one of these nuclear verdicts affirmed. So they've never been paid.
Right.
Love this guy's start.
Do we have a name on this guy?
These factors have led to
It should be
fundamental
the author.
unfairness in civil trials over torts and created an unstable legal environment that forces up the cost of insuring a
one of
business
these two.
beyond economic viability for some businesses. Senate Bill 30 seeks to cure ambiguities in the court procedures and the award determination process,
That's not.
restoring
Charles Schwartz
fairness
is
and
not.
transparency to the Texas civil justice system, and returning reasonable insurability to Texas businesses. The bill has 4 main goals. First, stop the manipulation and inflation of medical damages. Second, protect and encourage doctors who bill at rates within reason to treat accident victims.
It might be the sponsor.
Third,
40.
provide jurors
Yeah, I think it's
the clear definitions and instructions they need to award fair compensation for physical pain
This
and
guy
suffering
does not care about fair.
and
I
mental
mean,
or emotional
fair
pain and
compensation is
anguish.
what a jury thinks is fair compensation.
There's
Not what the legislature
There's
says.
no amount that would be fair to them. You have to understand, ET. The fair amount to the insurance company is zero. It should be zero.
Right.
That's what they're arguing. It should be zero.
Process for a trial court to review and explain in writing higher awards of non-economic.
Oh, one of the sponsors is an orthopedic surgeon.
Non-economic damages above thresholds.
Shocking.
I'll talk through the main provisions of the bill at a high level and then happy to answer any questions.
Texas
Under
Monthly
current
named him
law,
the worst legislator.
Chapter 18 of the Civil
Practice
One of the worst.
Remedies Code
in
allows
2017 and
plaintiffs to
2015.
prove the reasonableness of healthcare charges and the necessity of
Well,
services.
we find
through
us something to eat
affidavit.
here.
A defendant may contest with a counter affidavit, but is often a futile effort. Many courts in Texas strike the defendant's counter affidavits on various grounds, leaving the defendant unable to contest
the charges or medical necessity for services provided.
I've never had a counter affidavit struck. Have you? Not in a long time.
No.
Senate Bill 30 replaces language on counter affidavits with a requirement for defendants to provide, quote, notice of intent to controvert to both align the law with court rulings and
Ooh, you
give
ever had
plaintiffs
one of
fair
them?
notice of the defendant's intent to dispute.
It's good.
Additionally, because providers often refuse to treat accident victims to avoid being tied up in court, the bill provides treating doctors with protections against having to testify if service charges are
Which we're now getting rid of by gutting 18001 affidavits. You're making it more likely they have to testify, which you just said the goal is to not to have doctors have to testify.
I mean, well, 1801s, they pretty much gutted them anyway. I mean, that's what we were talking about
This
earlier.
just further enhances it.
Legislatively,
below
yeah.
a certain threshold. The threshold in the bill is 150% of the median amount paid by non-governmental payers for the same service. Additionally, plaintiffs are encouraged to access their insurance.
Yeah, just add
And
the car.
transparency is improved by requiring the jury be informed of arrangements between plaintiff lawyers and healthcare providers. The bill does not set medical billing rates or prevent a plaintiff from recovering the compensatory damages if an employee's negligence caused injury. It simply returns transparency and fairness to the amounts awarded. Also very importantly, in Chapter 41, the bill amends the definition of non-economic damages and sets out standards for recovery. Doing so will codify case law and give juries meaningful guideposts, alleviating
What he means is zero guideposts.
Zero guidepost. And against all case law, because it's I forgot to tell you this, ET. It also, you can't bring claims for loss of consortium anymore. You can't bring any claim for loss of disfigurement anymore. Both those causes of action are eliminated. So if you're a burn victim, your whole face gets burnt off, you have no claim.
It's ridiculous.
Difficulty of evaluating the subjective damage awards and preventing the awarding of exemplary/punitive awards under the guise of non-economic damages. Lastly, the bill establishes a process for a trial court to explain awards of non-economic damages. This is done through a motion for remititure by the defendant. And the judge will determine whether or not the non-economic damages exceed certain thresholds. And if so,
that's
either
one of the
reduce
sponsors.
or explain
That's a
in
motion
writing the legal
from last
and
2 years
factual
ago.
Is that
basis
him?
for a higher award.
Is that him? I can't.
I want to be
It
abundantly
looks like
clear.
him.
This bill does not establish a cap on non-economic damages.
It doesn't?
Rather, a procedure to inform what the
That's
judge believes.
their argument is that the remitter is not a cap.
So there
Even
isn't
though
a
it
hard
is.
cap, there isn't a hard cap that they're actually
The
putting in?
problem is that there's two parallel bills with this that do cap, that are strictly caps. There's no other mention. He's saying it's not in a cap, even though it is a cap the remitter is a cap. That's what it is. Because they're never going to be able to find any comparable awards or facts that have been affirmed on appeal.
Right. Can we put this up on your live stream? Like, can we put
Oh, yeah.
images up? If you want to clip it. Is that, I don't know if that's, it's hard to tell if that's him. But this is one of the sponsors. At
I
least,
think
that I
one of the
found.
sponsors that ET just found, what's his name?
Charles Schwertner,
Texas rep.
Texas rep. I don't think that's him, but he is one of the sponsors. Let's find his mugshot he got arrested on suspicion of DWI. And he also,
One of the bill's sponsors. Wow. Pot calling the kettle black. The homeboys got a D-dub. That's just, let's screw over constituents because I like to drive drunk.
I wonder if he killed somebody.
Believed to be justification.
I mean, maybe he's just trying to protect himself, so when he goes and kills somebody, you know,
It could be he got sued and is like, you know what?
In summary,
Everybody's
Senate Bill 30
suffering.
addresses the presentation of medical evidence at trial, improves transparency of court procedures, and gives enhanced guidance to jurors regarding the calculation
There's
of
also a
damages.
sexual harassment text message scandal involving this guy in 2018.
With that, Mr. Chairman, I'll be happy to answer questions. I know we have
with a graduate
members,
student of
this
University of
is
Texas.
A significant bill. And
Gross.
For that reason, there are 10 invited testimonies.
I don't know if I can read what read aloud on YouTube what this guy said to this young lady.
I do not want to get flagged on our first day going live.
And then we have
Jesus.
so individuals wishing to provide public testimony that are not invited.
Everybody who's
testimony,
listening, look up Charles Schwertner.
He's a real
one of the sponsors of this
fella.
bill. Yeah, DWI arrest, or at least suspicion of DWI in Austin in 2023.
So you've heard the intro. How many lies can you point out in just this little intro?
I mean, everything he's saying is a lie. Now, of course, we're just a bunch of personal injury lawyers, so, you know, who wants to listen to us?
He's got 5 people testifying for the bill. We'll have to see who those people are.
6-0 or so.
Dean Zafran, you're recognized.
Yes, Mr. Chairman, as we did in Business and Commerce the other day, I would like to request strict enforcement of the rules so that when the timer buzzes, the testimony stops, since we have so many witnesses and we have session at 2, I believe. No?
We have so many witnesses. We have so many people who hate this bill. We need to cut off the 5-minute timer, strictly.
We'll strongly encourage witnesses to abide by that when the time has expired. Thank you, Dean. Senator Hall, you're recognized.
Mr. Chairman, just one quick question. I had a number of folks ask me about the question of caps and whether that's constitutional or not. Do we have anybody from the AG's office here today to address that issue?
I don't believe we have a resource witness from the AG office, but the bill does not establish caps. It establishes
Also,
thresholds
for
for
I'm
which
totally cool with them supporting Israel. I'm not cool with them supporting this bill.
a trial judge would have to entertain a motion for remititure, and if the trial judge does not remit back down to the jury the award amount, then he or she would have to explain in writing, laying out the reasoning for why remititure was not granted. It would also facilitate appellate review of the trial court's decision.
It's such a difficult life being an orthopedic surgeon and
Senators, any other questions for the author before we begin testimony?
part-time politician.
Yeah.
Very well. We'll open testimony on Senate Bill 30, and as the author said, there'll be an invited testimony, both for and against. Here available for questions.
So here's a peek into the legislative process. We've seen other people testify in favor and against bills today. Now we get to see who's going to testify in favor and against of this bill.
Jack Walker.
Oh, Jack. Okay, Jack's on our side. Jack's going to be good. Jack is the president of TTLA.
Okay.
Xavier Balderas. And Jim Perdue. So panel 1 is the impartial.
Yeah, that's
another good lawyer.
Jack Walker, Xavier Balderas, Jim Perdue. And I think the witnesses know if you have written materials, we'll take those from you. You may have already provided those. Welcome to each one.
If you have written materials, we won't read them or pay attention to them because we're bought and paid for, but we will allow you to hand them to us.
One of you for
I have a question. So you said that in the insurance defense world, you couldn't go testify against these bills.
Right.
Did anybody from the insurance defense bar testify for them?
Yes. Yes. I bet we'll see somebody today who testifies for them.
I did testimony. 5 minutes are allotted, and we will try to stay with those time limits, but there will likely be questions on these bills. So we'll start over here on my left, your right, in the order we called them.
That's what's also so pathetic about, this happens at the federal level too, is that you only get 5 minutes to answer questions about a bill that will affect millions of people.
Yeah.
It's the same thing, like when we have voting rights bills, it's 5 minutes, 5 minutes. Like, can't get anything in 5 minutes. Joe Rogan gets more time with people than our legislature does.
That's true.
Ms. Parsley, welcome. Introduce yourself and give us your testimony.
Good morning, Senator Hughes, members of the committee. My name is Lee Parsley.
This is Lee Parsley. This is the most corrupt man in Texas politics. This is who drafted the bill. This is whose organization provides $23 million to our legislators on behalf of big oil, big pharma, and big insurance to make these bills go through. So if you have someone to blame, reach out to Lee on Twitter. I certainly have before.
Lee Parsley?
Lee Parsley.
Here on behalf of Texans for Lawsuit.
And kudos to Jack for sitting next to this scum of the earth and not just stabbing him with his pen. I don't know how Jack keeps his composure next to this scumbag.
Lee Parsley.
More corrupt than Paxton. Yes, Sarah, I would agree. More corrupt than Paxton.
Reform in support of Senate Bill 30. Tort reform started in Texas in 1986 with a joint committee of the House and Senate studying the liability environment and tort laws and procedures in Texas. The committees were named by the leaders of the chambers at the time, both Democrats. The committee reported to the legislature in January of 1987, offering 30 tort reform proposals, including those related to venue in injury and death cases, statutes of limitations, comparative responsibility, limits on punitive damages, numerous other things. The Texas Civil Justice League, who I think you'll hear from later today, was created in 1986 to advocate for tort reforms in the 1987 session, and many of the things recommended by the Joint Committee passed at the time. TLR was formed 8 years later and began advocacy in 1985. Through the long-term diligent efforts of TLR, TCJL, and the entire business community in Texas, we restored sound legal principles to our state's tort laws. The goal of all tort reform bills
I can't stand this dude.
has been to guarantee fairness and efficiency in the civil justice system, knowing
fairness for the insurance industry. You know what? I really don't care what this guy has to say.
and accepting.
So we're going to lower his volume to nil. E.T., what is your background? Why did you become a lawyer?
So my background, and how far back you want me to go?
It's 1989. You
88. I can go back to 88. That's as far
you
back
see
as
a
I can.
bright white light.
July 14, 1988. Saw the light.
No, let's say post undergrad.
Post-undergrad. All right, so I went to law school, formerly known as Texas Wesleyan School of Law. I was the last class to graduate before Texas A&M bought it out. They gave us two big middle fingers and said, "You're not part of our family. You're not an Aggie. You're never going to be an Aggie. You ain't getting no rent." I mean, there's a YouTube video of the provost telling us all this. This is like a few months after, I think it was September, October of 2013. So while I'm waiting for bar results, 'cause
Right.
I took the bar in
Oh my God.
July and August of, it was like July 31st through August 2nd or something of that year. And so, yeah, that was that. And there were some lawsuits and things against Texas A&M.
Wow, I did not know that.
But luckily for me, I had a job lined up. So I worked at a commercial litigation firm in San Antonio. I don't know how much I can say about what it was like working at that firm.
Was it a positive experience?
No,
or?
no,
So you didn't
absolutely.
like doing commercial lit?
It probably would have been okay if it wasn't for the type of people that I worked for. But really, I really got, after that, I worked for still a very good friend of mine. He was a solo who did plaintiff's employment. And that's really what I wanted to do. I worked for a lawyer in college who did personal injury and Social Security disability. And I don't like the idea of working for people who just pay whatever. Because they don't just pay whatever.
Yeah.
The insurance companies, in this case, are going to drive their rates down now, right? That's what we're talking about, how they're not going to have.
That's what sucks for the insurance defense lawyers that do it right. The insurance companies are just going to turn around and not pay them either.
Right.
That's the thing is although I dispute that verdicts have anything to do with premiums or rates, is even if it was correlated, they're never going to lower their prices.
Never. So, and my take on why the premiums have gone up is mostly because of collision. In that COVID era, or that, sorry, I don't know if it's a Taylor Swift reference, the COVID era, but 2020 to probably through 2023, my cases where people were making money on their cars because the property value, it was so hard to find new cars. Used cars were being sold at a premium. People are making money on cars, which never happened in the past.
Crazy.
Probably doesn't happen anymore. I bet that's probably equalized. But I think that's where a lot of the rates, because I mean, it's true that our rates have gone up substantially.
I think it's two things. I think it's the cost of property damage, rise of population. There's just more crashes because more people moved here. And then 3, they're losing so much. The insurance companies are losing all their money on the homeowner side because of extreme weather events. They're getting destroyed in property insurance. And so they're saying, how do we make that money up? We have to make it up on the auto side. So we'll raise rates to help hedge the losses that we've done on property.
That's probably, I mean, again, I've never been on the insurance side, so I don't know how they set rates.
I
but that makes sense.
only know that because I've gone and read their pro formas. I've pulled State Farm's quarterly financials, and there's not one time do they mention lawsuits. Not one time do they mention tort reform or lawsuit abuse or personal injury verdicts, nothing. It's all about climate.
Okay, so
this is our boy. I want to tune this up. I want people to hear what Jack has to say.
Sections of this bill that we will testify to today. In my time before you, I'm going to go through each section, identify the subject, and give you a brief explanation of what it contains. My colleagues will then go through in more detail, identify the issues in each section, the dangers they present, and why they won't work. So let's start with section 1. We'll call this the medical expense section. This section redefines how medical expenses are proven and valued at trial. In many cases, this is going to limit damages to 150% of a threshold. These are not market rates, they're administrative rates. This creates a cap on damages disconnected from actual medical costs. In some surgical cases, this cap would reimburse less than 50% of what the surgery costs. So if this cap are applied and you're at trial, the plaintiff is found, the defendant is found negligence, the plaintiff is found to get damages. If the cap is applied and it's 50% of the cost, the plaintiff, having won, is still going to be responsible for a large portion of the bill, even after being the victor. Now, Section 2 purports to redefine non-economic damages. This is perhaps one of the most damaging parts of the bill. What this does is completely guts non-economic damages.
Oh my God, E.T., I got to pause it because we have a good guest in the comments section. I don't know if you've seen the Michael Taqua's podcast. It is one of the best.
Okay, I need to check it out.
You got to check out his podcast. He posts. He's a PI lawyer down in, I think he's in Houston. I'm 99% sure. Where's my cup? I have his cup in here somewhere. Yeah, Mike's down in Houston. Has a great YouTube channel, has a great podcast. I wish he did more podcast episodes. He writes, insurance companies don't offer anything in a way of settlement, then throw their hands up when the good plaintiffs' lawyers win big verdicts. Yeah, Mike, I agree. Thank you for tuning in. We're live here from the Texas Senate. Jack Walker from TTLA is testifying after the corrupt piece of dog manure that is Lee Parsley. I like how Jack started his 5 minutes. He only gets 5 minutes with this giant stupid bill by focusing on the economics because he knows his audience.
Right.
He knows that all these senators, because he's in the Senate committee now, are only going to care about not his poor personal injury clients, but his money from the doctors,
So
because they got to go back to the doctors to justify it.
I just want to throw this out there. Some people might find this controversial. Houston's the best food city in Texas. If y'all don't go down there, like I love going to Houston and going off, hitting up all the various, I mean, it's endless. The amount of incredibly good, any kind of culture
I
you want.
agree. My
Some of the
wife's best
food.
friends all live in Houston. I had been to Houston before I met my wife once, maybe once, until like the airport. And then now when we go see her girlfriends, I texted someone the other day. They do have the best food.
Best food.
There's a lot more diversity. I think their Tex-Mex is even better. I feel like the Tex-Mex in Dallas is like a lot of chain stuff.
Listen, I'm not gonna. I can't eat Tex-Mex up here, right? Because I'm also, when I moved to Texas when I was in high school, so I consider myself San Antonian. That's where, my parents. I went to high school in San Antonio. Like I can't eat. I live in Denton, man. Like.
Oh, and in Denton, yeah, you ain't gonna get.
But yeah, man, Houston's got some of the best. I mean, anything you can imagine.
Yeah, we need to have Mike have us down to Houston, bring us on the pod. We can talk more tort reform, eat some good food. But I like what Jack's done so far. Let's keep going. We got food on the way. I don't know where it is.
We got more corporate Dallas food.
H-time. Yeah, he's right. Mike's right. It's H-time.
Recovery and will devastate the most vulnerable, catastrophically injured victims. Texas currently recognizes at least 6 elements of non-economic damages: pain and suffering, mental anguish, disfigurement, physical impairment, loss of consortium, loss of enjoyment of life, and these are important. These damage elements were developed at common law over time to cover the full range of human suffering that can result from these serious injuries. Senate bill guts these definitions and reduces it down to 2: physical pain and mental anguish. And then what it does is it then raises the bar. It redefines mental anguish and physical pain so narrowly that they become almost impossible to prove. This redefinition is not designed to clarify mental anguish or clarify physical pain. It's actually meant to disqualify it. The result is simple. SB 30 reduces human suffering to a checklist.
Because I mean, this is good stuff. But like, why don't people just show up with big old like foam board pictures of people's heads? People are decapitated. This is what happens in this crash. This is what disfigurement. Dog attacks where people's lips are destroyed.
Jack,
young girls with.
I'll tell you why. Jack has tried. There's 2 problems. When the bills are announced for hearing, this bill, we were told Friday at 2 o'clock that it was being set for hearing today. The reason that they do that is so people don't show up to testify and don't know about it. The other side of it is, how hard would it be for one of us to convince our clients to ride in the car with us down to Austin, to sit there? I've been live streaming since 8:30, and we just got to it at 1 o'clock. To sit there all day, majority of them might still be in pain, sit there all day, then might not even get the chance to testify. It's just impossible. They set it up so the public doesn't know. But yeah, that'd be great if we could go down there, show picture, and that's what Jack's main point to all of us in TTLA is clients' testimony is who makes the difference, not lawyers.
Not lawyers.
But the problem is that Lee, dumbwit on the left, he doesn't care. It doesn't matter what pictures you showed him, what victims he could meet with.
Right, well, because he knows.
He has his $23 million to bribe all of the members of the legislature to do his bidding.
Right, and he doesn't, I mean, either way, he knows that there's suffering. Like, some people act like they don't know.
He knows.
He knows. That this,
and he claims, well, this bill won't affect them. That's how he sells it every single session. This bill won't affect it. It's only the frivolous cases. That's right. Even though frivolous isn't mentioned in the bill.
Right. Because they don't give a shit.
Because they don't care.
Sorry, YouTube.
Yeah.
Mr. Parsley, as you thought I might, about the non-economic damage caps. This is a cap bill.
As Jack just said, this is a cap bill. Agreed.
Guarantees a right to trial by jury, not trial by formula. This remitter scheme in this bill allows a judge to override a jury's verdict based upon artificial caps and not the facts of the case. The bill doesn't just limit damages, it rewrites the jury verdict after the fact. That's not reform. That's an unconstitutional intrusion on the jury's core function. The jury is the sole fact finder. A judge has no ability to overturn it. We would ask that this bill not be passed. Thank you. I'll now answer any questions you have about any section of the bill.
Thank you for your testimony, and I'll say, unless the senator feels otherwise, we'll hear from each witness, and I'm sure we're going to have questions.
Such BS. He really only gets 5 minutes. As Monica says in the chat, how could this be limited to frivolous cases if it applies universally? Exactly. That's the point.
None of them, like, they always used frivolous,
Yes.
right? But it applies to everything, right? So
yes, and it's smart psychology because 99% of people think all lawsuits are frivolous.
Right.
Because they know someone who got money on a frivolous case.
Oh, yeah, my neighbor got $1 million and he's fine. And,
Right.
Yeah, whatever.
Right.
Right.
Balderas, welcome. Introduce yourself and give us your testimony.
Thank you, Chairman Hughes. Good morning, Chairman Hughes, or good afternoon, I guess, members of the committee. My name is Javier Balderas. I'm Associate General Counsel to CRH, who ranks 112th on the Fortune Global 500 list. We're the largest worldwide supplier of asphalt, aggregates, ready mix.
Whoa, mom and pop shop, I guess.
Yeah.
Whoa, that's a small company.
CRH's federation of companies include Texas Materials Group, Jewel, Old Castle Infrastructure.
I love that Jim Purdue's.
Old Castle Infrastructure.
I love that Jim Purdue is just like this guy.
I mean,
this guy.
Let me ask this to Mr. What's his name? Javier?
Yeah.
How many people were killed by the companies that by your company or by your conglomerate?
None. I bet he would say none. Not.
They weren't negligent.
He would either say none or he would say this doesn't affect them. That's what, you will hear this today. They will
how
say.
many people were disfigured? How many legs were blown off? How many arms were
He could
torn
pour
off
concrete into my mouth and say it was my fault.
Texas is our #1 growth target in the U.S. and has been for several years.
The growth.
It's a growth target, but also a judicial hellhole.
Interesting.
Since 2020, CRH's Texas companies have invested over $2.8 billion in acquisitions and over $430 million in capital expenditures. CRH's Texas companies are involved in large highway and infrastructure projects throughout the state, including construction of the $17 billion semiconductor plant in Taylor, Texas.
Texas
courts and current legislation have created a fertile ground for lawsuit abuse. Today, Texas is considered among the worst states in which to litigate, with Harris County one of the worst counties in the nation when it comes to jury.
I think that's a shout out to H-Town.
Another shout out. You know what? It is talk law. Mike, this is your fault. Getting all these big verdicts down there, buddy.
In excess of $2 million in 25.
Oh, $2 million is nuclear.
Performance predictability and the current Texas legislative landscape is riddled with those variables.
We just want to kill people and get away with it. What's wrong with that? It's what you might as well say.
Purdue Pharmaceutical to kill people.
Increase the number of claims that go into the lawsuit stage. Prior to 2020 in Texas, and by the way, I should have.
Oh, tell us. Okay, ET, talk about that. One thing I don't think that people know is how many of your cases do you try to settle pre-litigation without filing a lawsuit? Where they actually offer fair money.
No, I mean, I almost don't try to settle cases pre-litigation.
Why is it? Why, in your experience, do you think you have to file a lawsuit?
Because they never offer. I mean, however they're designed in the insurance, getting their authority and their reserves and all that. I mean, they're designed to not have the authority to pay. If it's a policy, let's say a policy limits case, obviously. They're just not going to offer that.
And even policy limits, when you talk about policy limits, even as cases worth as little as $30,000.
$30,000, right? And that should, most cases, if there's serious injury, should be a $30,000, like pay the policy limit.
Right, but they don't do that. That's why there are so many claims, is because they're so bad at their jobs before the lawsuit is filed, but we get blamed for it. Mike brings up a great point. By the way, this guy ends up saying he's thinking about leaving to California. Good luck with that.
He said, did he just say, I haven't been listening to half of what he's saying, so.
We know what he's saying. We know the bullshit he's putting out, but we got to toggle our volume here so we can comment on it while other people. hold on. We can turn it back up here. I just got to pause.
Or outside haulers. When they can't afford astronomical insurance costs, it drives those owner-operators out of business.
I'm clipping out Jim Purdue's reactions and how he's not vomiting on this guy because shout out to Jim Purdue. I'm loving his face right now.
And that's the same factor that's happening with small businesses, even that don't have trucking components,
CRH does
that
not
have
give a
just general liability.
damn about a small business. I mean, they want to put small
No,
business.
why would
they're-
you start with we're a Fortune 10 company?
They're basically the Walmart of construction,
That's right.
right? I mean, maybe they'll roll up some mom and pops,
Maybe.
put them out of business.
Policies.
They can't actually, you're wrong. They can't be a monopoly because their insurance is too high.
Ah,
That's the
damn it.
problem, buddy.
It's driving those small businesses out. And this has put severe strains on the already strained trucker shortage and small suppliers.
Well, that's because
It
they're
also
not
is gonna-
qualified to drive.
Wrong. Wrong. Lies. All right, Mike Tacklaw. 70% try to settle, 3% they offer real money. 3%.
I mean, I've got one right now that I'm just going to fuck because the lady has a 76-year-old lady, fully retracted rotator cuff tear. They won't operate on her because she's too old. So they offered $7,500.
That's what I love. I can't, Sarah, I can't put on closed captioning. The Texas legislature, again, makes watching these hearings so damn hard. They're hard to find, and then they don't do closed captions if you're hard of hearing. If they really wanted to get rid of personal injury lawyers, they'd settle everything pre-suit. We have nothing to do.
Yeah.
It's going to have an effect on those DBE businesses that need that extra business. So due to the volatility of the Texas landscape, we're having to make pragmatic decisions as to new M&A opportunities, capital and capital expenditures. CRH and its subsidiaries now increasingly look at opportunities in other states where litigation risks bring less volatility. 5 years ago, it would have been unheard of to look at California and Washington and Colorado as more attractive areas to be able to grow CRH's businesses. And today, we're having to make those hard looks at other states that have traditionally been more volatile. Right now, Texas has that volatility first place. For Harris County alone, we've had to pass on what would be otherwise attractive acquisitions because those risks are far too high. That same risk assessment is occurring throughout countless other companies. Due to the volatility, the Texas legislature now faces a true crossing the Rubicon moment, reining in nuclear verdicts to prevent disastrous effects on Texas businesses, both large and small. CRH urges this body to pass SB 30 to make Texas a place where business can flourish. Thank you.
I mean, even the look on his face makes it
Ms.
look like
Baldress.
he knows
Mr. Purdue,
he's
welcome.
crap.
Introduce yourself. Give us your
Smirk.
testimony.
Mr. Chairman, members of the committee, my name is Jim Purdue Jr. I'm a lawyer in Houston, Texas. I've been practicing some 31 years. I was the past president of the Texas Trial Lawyers Association. I had the pleasure of appearing in front of many of you in the 2021 session. Thank you for having me back. Let me begin by saying, with the fundamental proposition, I think there are people on either side of this bill who can be described as well-intentioned. I don't think that some of the observations regarding medical billing evidence you're going to hear from me on today anyway, but I understand some of those concerns. I understand that industry brings to this body concerns regarding certain aspects, but we have heard anecdotal stories regarding an insurance marketplace across all lines of insurance, depending on which committees you're serving on this session, in both houses regarding the affordability and access issues for insurance across all lines, because it's a nationwide issue. Nothing in this bill specific to my comments today regarding the redefinition of non-economic damages has anywhere ever affected insurance availability or insurance affordability. What this bill represents in Section 3, it's really Section 2 of the areas to discuss today, but Section 3 of the bill itself, is an effort to use a few definitions within Chapter 41 of the Texas Civil Practice and Remedies Code, which was drafted, I will say, in 2003 as part of HB 4 by TLR in part of the big bill. So the definition of non-economic damages that exists in Chapter 41, 11 of non-economic damages was written by TLR in 2003. What is occurring in the bill today is to take the list of non-economic damages that have been recognized in the Anglo-American jurisprudence system of common law from the time that the Magna Carta moved through civil law in...
That's one thing about Jim. Jim is a huge history buff on the Seventh Amendment. Jim could literally talk to you about the Seventh Amendment and its historical basis for like 5 hours.
Talk about the Declaration of Independence,
Yes.
too, which is kind of where the precursor of that was. That's
right.
The king was denying us the right to trial by jury, and that's what they're doing now.
Europe and came over to our
That's
American
right.
history. The definition of damages when it comes to civil accountability, which evolves because that's what the common law does, but that tradition which has been honored of the courts looking at those things, changing the definitions, writing those definitions through case law, and putting the parameters on them, have led to, as Mr. Walker said, essentially 6 areas of non-economic damages which have been recognized and I will say have been validated by the Texas Supreme Court and a unanimous 9 Republican-member Texas Supreme Court over and over again. And in fact, one of the redefinitions would repeal a Texas Supreme Court opinion written by Justice Priscilla Owen, who went on to become chief of the Fifth Circuit Court of Appeals, joined by Chief Justice Hecht, joined by Chief Justice Phillips, that tried to give common law parameters to these definitions of non-economic damages. And this bill repeals that case by the Texas Supreme Court from 2003 and redefines, fundamentally redefines, the way we look at and understand non-economic damages to be. And then, Mr. Chairman, in the redefinition,
You know what I'm more concerned about is this guy who is sitting behind Jim Purdue. I don't know what his role is. I like his mustache.
I was going to say, but like, look at the mustache thing going on here. There's a bunch of mustaches.
He does not look happy. And his shirt is a little big around the neck. It's bothering me.
because of the way they've redefined 2 areas of non-economic damages, that the world of non-economic damages that recognizes human pain and suffering and loss of a loved one and the care and support they provide, and physical impairment for someone who is an amputee, who you may hear from today, and recognize the change that affects in their life, and the mental anguish that is associated with burying a child or suffering an injury for which there is no recovery. Those things have been recognized for over 100 years in the state of Texas as elements of damages that are subject to recovery.
I would be,
this is a question
I would not
of,
be very good
they keep suggesting that there is essentially an attempt to...
I would turn to the guy from CRH, and I would be like, how many kids are buried because of your company?
That's why I'm not there. My whole idea was to go today, but my wife was like, if you go in there, knowing the way I am, and if you follow me on LinkedIn, you know how pissed off this makes me, that I would just start screaming at everybody and revealing how this is all a giant bribery scam.
I mean, we would watch you probably get tased.
Yeah, I would probably end up arrested. Like, I would just start screaming because it's so corrupt. It's so obviously corrupt. So my thought was, well, look, I'll broadcast it to YouTube because the video is hard to find itself. Maybe people will watch it even just not for my commentary, but just to see it. And maybe I can reach more people through social media than... that's my old law school roommate right next to him, Mr. Scott. That's hilarious.
Really?
Yeah.
Is this the DWI guy?
I think that's him.
And the guy who was sending text messages about effing, I want to F you or whatever to a...
To minors?
Well, I don't think she was a minor, but she was
Yeah,
inappropriate.
that's Andrew Scott.
We're chasing dollars that are not real in the sense that, and it goes to the heart of redefining compensation. compensation base, if you will, and what we're gonna base it on, but if, and maybe y'all know, I don't care if any one of you can answer it, if you don't know, let the medical professionals tell us, but there's the master billing code, and then there's what you pay code, right?
Well, we already have that. We already know that shit.
And chooses not to disclose, be it hospitals, insurance, or otherwise. So if Charles Perry's heart attack cost me 180 grand on paper, but ultimately all parties involved in fixing my heart attack that day was 21,000. The question of the day is, do you take the 180 to the jury, or do you take the 21 to the jury? Anybody know or want to answer?
So tell us about why that's already been answered.
And I'm not, because that law change happened before we were even probably out of high school.
Yeah, you
Right,
can't
paid versus
introduce
incurred.
the higher amount.
Right. Right, and that's not, what he's missing is the issue is, all right, if an LOP provider is charging this large
Right.
amount.
That's
right?
but he doesn't know the nuance.
Yeah. Oh, I see. He's asking him a question. Okay, I wasn't.
Under this bill, if you were uninsured or it was not covered, it would be tied to under the bill, it's tied to a database that is actually not available to determine what the billing would be because it's not funded and it's not around. Or I've been told it would be tied to 150% of workers' compensation. Either way, it would not be tied to the actual value of the service that you received.
Well, I think,
Senator Perry, can I?
yes. Go ahead, Lee.
Your question was, which one of those is the medical billing tied to? And the answer is neither of them. So the way this works in litigation is that you go into a plaintiff's attorney's office, many of them, not all of them, and they send you to their favorite treating chiropractors, physicians for various things. And those people bill whatever number they want to put down on a sheet of paper, having nothing to do with what you just described. They bill whatever number they want to put down on a sheet of paper, and that is sent to the jury as if it's legitimate medical bills. It is not tied to any of those things you described. So the reason I agree
Stream
with
team, we are going to eat some
Jack
lunch, but we're going
said
to keep
is
the live
if
stream
you send
alive.
it
We're going to
to
turn our mics and
medical
videos
care
off so you don't
payment
hear us
for
chomping.
payment,
But we'll be back.
And Blue Cross and whomever pays it, then the jury hears the amount that Blue Cross or whomever the insurance company, they'll hear that amount that was paid. But the lawyers who do this kind of work tell their clients, do not use your health insurance because it limits your recovery in trial. It both limits your medical recovery and it limits your non-economic damages. Do not whip out your insurance card, period. Go to my person and don't use insurance because my person's going to write down a number that is 5, 8, 10, maybe 20 times what Blue Cross Blue Shield would pay for that service. And that's the number we're going to give to the jury. And that's what this bill is about. When I say it's fraud, it is made up medical damages for the purpose of inflating damages at trial. It just is, and it happens every day all across Texas, and it has to stop. That's what this bill is about.
So to be clear, there's no standard today that when you go to court that it is based on actual cost. It's just whatever the medical profession sends in for their documentation. It's not questioned. It's not looked at as reasonableness. It's not tied to anything in the market.
It's subject to cross-examination at trial, but it is not tied to anything.
As a practicing lawyer, Senator Perry, I would tell you how it works. Currently under the system, there is an affidavit system, and it's 18001 in this bill. And as it currently stands, if you have a bill, you get an affidavit from the medical provider. They swear out that that's reasonable and necessary, and you submit that to the defendant. If the defendant takes issue with it, they have an opportunity to file a counter affidavit and say, no, we disagree with that. So it is, and this is what we think the bill should be. Okay, so it's not what's ever put down goes automatically to the jury. That's not how it works in any sense.
Well, it does. You're entitled to present it to the jury, Jack, and you do present it to the jury. It's subject to cross-examination, but it is presented to the jury. There's nothing that stops it. So this bill ties it to paid claims. That's the purpose of this bill. It ties it to paid claims for the first time, which it is not today.
Here's where you're mistaken. When you file that counter affidavit, my affidavit is gone. It is no longer good, okay? I then have to go bring medical evidence into the courtroom of whatever bill I'm going to do. So it doesn't come in. It's not even subject to cross-examination. You have to go in and get it put in some.
So I'm listening to you guys, and y'all can debate each other outside the hallways.
Fine.
So to be clear, and I'm trying, this is an important nuance to this conversation. There's really, and the bill seeks to establish a standard. What I heard both of you say, for different reasons, there is no standard. Is that true? There's no, it don't even start with master billing, which is, don't get me started on that. There's no standard. It's whatever the physician signs off that this is what it's going to take, regardless of what practices and actual payments for that same issue at the end of the day through a negotiated contract insurance companies make with hospitals and physicians. There's none of that objective point to say that neck injury cost $173,000 and that's universal amongst 20 providers. There's nothing you can point to that is claims paid in the industry. Y'all are saying, one says it's whatever it wants to be, and you say we get a doctor to sign off on it, and it could be 4 times what the average payment is for that, correct?
Yes.
Okay, thank you.
Senator Shorter, go ahead.
I think that's an extremely important point for the members to understand. As a practicing orthopedic surgeon, the current ruling standard is paid or incurred charges for the injured individual. But because plaintiff firms do not utilize health insurance and actually instruct their injured clients not to utilize health insurance, and in addition utilize a network that they themselves kind of control, everything is incurred. And so the incurred charges in your case, you said a heart attack, but it'd be more likely like an injured something, might be $100,000, whereas health insurance might reimburse $5,000 or $6,000 for those same things. But what is considered in the deliberation of the court is the $100,000 number, not the $5,000 or $6,000 number that would be paid by a third-party health insurance.
I think it's really important that we understand that nuance. And now we'll go the other side. I'm not speaking to the other economic damage conversations that you raised in both of y'all. I'm saying specifically to the medical charge, the amount of money that if it wasn't for injury and in a lawsuit, that injured person's insurance would be expected to pay, or if they're non-insured would be expected to pay, which usually there's a significant cash discount or workout, right? So that's an important piece of this piece of legislation, that had it been tied to the negotiated contracts across the country for hospitals and medical providers, there's a pretty significant, like I say, they charged me 180, they ended up taking 21 as providers. That's kind of normal throughout the hospital industry.
The differential could be even greater than that in cases of personal injury cases.
Yeah, so I appreciate that.
I, again, want to reemphasize the current standard utilized in law is paid or incurred when it comes to medical. Is that correct, Mr. Walker?
That is correct.
That's correct.
Mr. Parsley. And therefore, the changing in this legislation is one in which it ties to either what was paid, or you can go above 100, or what is actually not incurred, but 150% of a threshold. You can bill what you want, but if it's above 150% of a threshold, then you have to legitimize it by putting yourself at risk as a provider to come before the court and make it legitimate as far as the cost of those services. That's what the bill currently does in its written form. Mr. Parsley, you agree with that?
Well, for incurred bills, for paid bills, the law will be the same. It's been since 2003. The jury hears the amount paid. For incurred but unpaid bills, this piece of legislation would base those on a market rate. That is, you would look at the database, you would draw from it the average amount paid for that service during the month that it was provided to the person, in the area it was provided to the person, and you would take the average of the amount paid by private payers, so not the government payers, but private payers for that service, and then you would multiply it times 150%, and that would be the limit on the damages that you could get, 150% of the private payer's average amount for that service. That's what this bill provides, so that it is not just an unlimited amount potentially awardable in litigation that is not related to the market.
Mr. Walker, go ahead. What Mr. Parsley and I had a conversation about this a few days ago. The issue with the bill is the database that's contained in the bill does not exist for the purpose of which it's stated in the bill. There are databases out there that do take non-governmental negotiated rates and find averages that can be used. This one doesn't exist for that purpose.
And if I can ask a mechanical question to follow up on this, we're talking about paid or incurred. So for those bills that are incurred but not yet paid, and Mr. Parsley, you talked about situations where the lawyer and the physician have a relationship and health insurance is not used. For the disclosure part of the bill about referrals and things like that, is that so that there can be a determination made as to whether the plaintiff has a relationship with the lawyer and the physician, or is that what that's about? And does that have any effect on this? For example, if someone didn't go to the doctor through their lawyer and doesn't have health insurance, but they've incurred this bill, are they affected by this too? Or is that what and I don't know the answer, it's a legitimate question mechanically, or is that what those disclosures are for, to figure out which category this person falls into?
Thank you, Senator. Let me address that.
That was a terrible question, but you know what I'm trying to ask, I think.
I think so. Let me address that a couple of ways. It is based on the Florida legislation. Florida has done this in 2023 because this problem is not limited to Texas. So Florida makes the same disclosures and makes the things admissible into evidence. So the agreement between the lawyer and the healthcare providers is disclosed and admissible in Florida, and as is the relationship. So if it's a referral network, the lawyers refers to the providers, then that's admissible in Florida. It's discoverable and admissible. So they passed that in 2023, and they did a similar thing in terms of their medical damages based on Medicare and Medicaid rates instead of a private payer system. And so it is, we believe that, frankly, jurors need better information. They just need to know what's going on in the context of this case that's come to them. And I think it is relevant to jurors to know that this lawyer and the healthcare provider work together all the time, and the medical bills may reflect that. And so that's, I think, why Florida did it and why it's in this bill as well, is that the jurors need to understand the full context in which this case is in front of them.
Oh, Senator Perry, go ahead.
You finished?
Well, thank you. So, and I think I see what you're saying. And so, and I don't know how the Florida bill works, in a situation like that, if if the disclosures, there's no evidence that there's a relationship between the lawyer and the doctor, and the person doesn't have health insurance, but they've incurred these bills, would the formula still apply to them, or is there how does that work?
Yeah,
my situation being a plaintiff is uninsured, person's uninsured, and they owe this medical bill not to a physician who has a relationship with their lawyer, but someone who's uninsured, so they didn't choose not to use their insurance, they don't have any, right, and they have this bill that they owe. What would, and I don't know the answer, how does that flow through?
I think if I'm understanding the question, the answer is that if the person is injured, they're uninsured, they go see a lawyer, the lawyer has nothing to do with their medical treatments, they just go to a doctor, they receive medical treatments, then there's nothing really for the jury to hear, and certainly nothing that's negative about, I'm sorry.
It's for private payer.
Go ahead.
It's a private payer issue, correct?
Right. Well, that's what I'm curious about. Just from the discussion here, I just had that question.
So I'm still not sure I quite answered the question, but I think the thing is, there's nothing really, the jury could hear that this person went and received medical treatment from someone who was unrelated, that was referred to them by their sister and somebody that's treated them for decades or whatever. And the jury could hear that under this bill, and I think that the jury would be heartened by that. And then on the other side of that, if the person is uninsured and went to see a lawyer and the lawyer referred them to a series of people over time with whom the lawyer has worked for years and has a fairly close financial relationship, the jury's going to hear that too, and the jury may not be heartened by that. But either way, I think the information to the jury is potentially meaningful.
Senator Perry, go ahead.
So I think the question, if I'm, don't want to put words in your mouth, for those that don't have insurance that are injured in the court, does the chart for the insured average claims paid, once it's determined what that chart is, apply the same as if it would if you're a private payer? Is that what you're asking? Yes, sir. So basically, if I'm injured, no insurance, and I go out and have the same procedure, same surgery, is the chart that serves as the database going to be the same standard for the 150% metric under a private payer? I paid for those services personally, or I need to personally because I'm uninsured. Is that database going to reflect the same metric?
If you paid for the services under this bill, if you paid for the services, then the jury will hear the amount you paid. Okay. It won't be the 150% metric.
Well,
so it's
incurred.
only incurred and unpaid.
Is the same chart going to apply to both a private and an insured?
It is.
Yes.
Okay. Secondly, my question was, you, Mr. Walker, made in your layout, and I want to make sure that I was clear on it. You kind of went to possibly HIPAA violations, kind of in your layout. Now, to be clear, the actual medical procedures and the nuances and the intricacies of that person's treatment that could be you said personal, I think, what was the word. Yeah. That's not what the jury's going to see. It's going to be comparing it to the database for a, quote, diagnosed or procedure that's standardly.
Are you talking about the database, whatever
Yeah.
it may be?
You said something in your layout that you gave me the impression that Charles Perry has an injury. It's got really weird stuff applied to it, and the diagnosis, and that all of that was going to come out in public record.
Okay. Well, I don't know if I said that, and I'm under which context. There's two contexts I talked about. One of them was under the disclosures, okay, and that was if I were to make referrals to local doctors, then I have to give up the amount that I've paid to those physicians. I mean, to those physicians in the disclosures. It's as I understand, it's not going to be the medical records. It's just going to be the amounts paid. So that's not. It could be there could be HIPAA issues there because of names and that sort of thing. I did not hit on that, and that wasn't the purpose.
So to be clear, we're not asking a physician or provider that you have that arranged with or not from violating HIPAA by having to disclose stuff in that trial process.
No, but one of the things in that disclosure, I called it a bizarre part of the bill because of this. One of the disclosures is you have to give up all of the medical records that you've had with someone for however long you've treated with them. If you treated with your physician for 40 years, okay, under this bill, if you're in a car wreck and you hurt your back, all of the records from that physician, no matter what they're related to and no matter how far back they go to the defendant. Here's the other issue though. Because they're in that disclosure requirement, they automatically come into evidence. One of the main concerns we have about this disclosure requirements, and with all due respect, whether or not that Mr. Parsley thinks something's relevant and the jury could do it, would like it, or not relevant, that's the job of the judge. And this bill takes all of that away. All of this information we're talking about is a directly gateway into evidence. And so it takes away the judge's ability to look at it and see if it's relevant. Look and see, well, did this patient, how did they get?
All right, y'all, we are back. E.T. taking a short break. He'll be back with us. Hope you're enjoying this so far. Back from lunch here. Still hearing the corrupt. I hope you're seeing some of the freaking hypocrisy from these god-awful tort reformers. Lee Parsley, Jack Walker is who we're still listening to right now. The GOAT, the man. Jim Perdue, the GOAT, the man. Two great guys who actually care about human beings, unlike Lee Parsley, and this joke of a senator who's also asking the stupidest questions because he's not a lawyer, doesn't understand what's going on. Well, we're back here. We're tuning in.
To the doctor and do this. It just comes in automatically.
I appreciate that clarification. Okay. Thank you.
Senators, are any other questions for the witnesses on this panel? Dean Zaffarini, you're recognized.
Thank you, Mr. Chairman.
Yeah, well, we
Mr.
never
Parsley, you referred in your testimony to cheating by trial lawyers. Is that something that you,
I didn't hear. He said cheating by trial lawyers.
Yeah, I didn't hear him talk about it. Let's see what he's got to
did you
say.
have anecdotal evidence? Is that something that's, has it happened, perhaps occasionally or rarely, or are you saying that that's prevalent?
I think that you'll hear a number of witnesses come today who will talk to you about their experience in litigation, and they will tell you what they have seen, and I think that it will qualify as the actual evidence you are looking for.
No, I don't. I don't
Basically
have.
what I'm
no,
saying
I
is
don't.
no.
I don't. No,
But it sounds cool.
Or about what I refer to as cheating
everybody
by the
hates
trial
lawyers.
lawyers. I think that it has become rampant in this industry right now, that for cases, the run-of-the-mill cases, I'm not talking about the catastrophic injuries, but the run-of-the-mill fender
I'm
benders.
talking about the ones that the guy
The
uses
lawyers
now
are feeding the
causes
clients
all
into
time
the
in this
system
company.
of healthcare providers who treat them. And the
I'm not talking about Concrete Boy killing people, but
Those frivolous
those
lawsuits.
frivolous cases,
Decapitations and
yeah,
amputations.
burns. Unless they're plaintiff's lawyers, don't listen to them or their clients. Whatever you do.
If I could respond, Dean, because I think the point that just made was really important. I think the point that Marshall Parsley just made in response to your question is really important. There's a proposition that this bill is designed not to affect those who are catastrophic injured, not to limit the rights of recovery of people who have given money to lost their children, not to take away the rights of people who, from the women we heard earlier today, who survived sex trafficking, and the liability that may exist there. Unfortunately, in the effort to capture this issue of medical expenses, they have combined it with the definition of limiting damages on exactly those kinds of cases. If they were looking at the lawsuit industry and trying to talk about people gaming the system, then there would be absolutely no reason to have these redefinitions of non-economic damages and caps the way it's written. Those go to the heart of the people who are most injured, the most catastrophically injured. And if we could have that disconnect.
Right. If you wanted to target the bad actors, draft a bill about it.
Yeah, and you know what? Those guys get caught.
Yeah.
You know, like, there are people who abuse things, but there are rules to, and most of the time, guys who do that don't last that long.
Or the judges can sanction you for it.
Right.
We already have the rules for if you file a frivolous case, the judge can sanction you in order to pay the defendant's attorney's fees.
Well, the problem is that Parsley, every case is frivolous.
That's right.
You ask Parsley.
That's
right?
what I've been saying.
That's what we.
That's
Exactly.
what I've been saying for about 20 years.
We could have a conversation. But this bill in its heart is designed to go to exactly those kinds of cases and not the small cases.
Thank you. Mr. Walker, in your testimony, you referred to Section 3 as bizarre.
Yes.
And you said that it mandates no judicial oversight and it applies only to plaintiffs. Could you expand on that, please?
Yes, so the disclosure requirements, I can go through and look at what it requires, but as I stated, it requires that you produce all of your medical records and your invoices. You produce all LOPs, all agreements, all third-party agreements, which is really not a problem. But when you get to the attorney referral information, it gets a little bit dicey because of what I talked about. But I want to talk to you about other things. It requires and it admits your health insurance information, your health insurance policy. We have a rule in evidence called I just drew a blank on it. Collateral source rule that for years insurance doesn't come into the case because it can prejudice the jury. Now it's automatically admitted. It also admits workers' comp treatment guidelines and drug formularies. Has nothing to do with the case. But all of this information, all of this bizarre disclosure that you have to give from the plaintiff side comes into evidence, nothing from the defense side, okay? And there's no gatekeeping. The judge has no right to say, wait a minute, that's not relevant. That's prejudicial, which is the job of the judge. That's taken away from the judge in this. Okay, it's to tilt the table in favor of the defendant. The defendant didn't have to do anything. They just produce it all and put it all into evidence.
And this is to anyone who would like to answer. How does the redefinition of mental anguish impact the process?
I'm going to let that's
Mr.
Perdue.
Impact the process?
Impact the process.
Yes.
So what the redefinition of mental or emotional pain does is capture language that does not exist in current common law because it elevates it and it makes it a conjunctive. So you take the sex trafficking victim, you take a rape victim, you take somebody who has, for example, according to this definition, if a medical mistake leads somebody to come out of surgery a C5 quadriplegic. This redefinition, Senator, of mental or emotional pain raises that bar to one that acts as a redefinition to make it a cap. So you have to, if somebody who overcomes a horrific injury and returns to their daily routine, because we honor victims who try to get better, by achieving that under this definition, they cannot make a claim for mental anguish. Because they haven't suffered a disruption to their daily routine. That is not current law. And then you have to have mental anguish arise because they're trying to conflate, they're trying to collapse these elements of damages. It has to which is the loving relationship between a husband and wife or a parent and a child, loss of companionship in society, which is really a wrongful death damage, or the loss of enjoyment of life. So they're pigeonholing the idea of the mental suffering of somebody who's a sexual assault survivor,
Thomas Jefferson,
or somebody who has left an impairment where they'll never be able to walk
everybody
again,
hear us?
and say if you don't have these characteristics of mental anguish,
Shout out to
you
Austin
have no
Smith.
compensable mental anguish.
Well, we had the audio too high. Let us know in the chat if you can hear us now. We did not know our mics both died.
Your audio's all the way up. Should it be that high?
Oh, shit. Let us know if you can hear us.
Thank you again.
I'd like to speak to that just a little bit.
Mr. Parsley is going to speak.
Disruption in a person's daily routine is straight out of Texas Supreme Court opinions. So you've just been told that it doesn't exist. In fact, it's straight out of Texas Supreme Court opinions. We'll be happy to send you the citations for that. If the disjunctive part of this, the definition.
Let us know in the chat if you can hear us. We don't know if you're still in the chat.
Do we have anybody? Do we have viewers?
I think if my wife is not in the chat, we'll be fine with it actually, because she hears this all day anyway, so she's fine.
I feel like she's got more important things to do than listen to talk all day.
Yeah, she does. She really does. It would actually be worse if she's tuned into this. I don't even know if our stream is still going. Fuck. No! Fuck. No, we're good.
We're back?
4 hours, and that's how long I've been talking about this. 4 hours and 40.
Do you just sit? Do you just stream all day?
You know, it says it rises from
I've never done this before.
Okay,
I've never streamed before in my life.
Look, I've got
loss of
Facebook
consortium,
radio,
loss
so
of
I've never-
companionship in society, loss of enjoyment of life, or other similar mental or emotional injury. So it leaves open.
Let me go ask Jack if it's still working. Keep talking. Just start rambling.
Just ramble, just
Yeah.
about anything. Well, I'm Mr. Parsley. I put my glasses on to look more official and smart.
Say something, E.T.
Talking to me? Can you hear? Can you hear me?
Say something, E.T.
Talking to me?
Yeah, there. Okay, we're good.
Can you hear? Can you hear me?
Oh man, that audio sounds really good.
This is not a bar. It's a recovery. Can you hear me? Was it coming through loud and clear?
It
over
was
there?
coming in loud and clear.
Let me tell you what. This is just not
You
a
know,
bar.
you know
it's
what's
a
not,
recovery.
you know what's not fair to the public?
What's that?
Is we have one of the greatest litigators in probably Texas history, Austin Smith, who I graduated with, just down the hall. Wouldn't you love to hear his commentary on this?
I would love to hear his commentary.
Just hopefully he'll come by.
Is he going to come by and
Just a
grace
few-
us with his presence?
Just a few steps away.
Well, Jack Walker is.
Oh, they're talking about tweaking the.
database it refers to right now is not yet functional. The legislature is considering funding that database so that it will be functional.
Oh, it's talking about the database isn't life.
That fills in the gap between now and when that database becomes functional, and it needs to be based on the actual.
I feel like, maybe I'm wrong. Maybe I'm wrong. I feel like our folks down there, Jim Purdue, what's the other guy's? The president of
Jim
TTLA, I
Walker.
should probably know his name since I'm a TTLA member. I feel like they just need to come out and say, look, this is they're trying to make this the end of personal injury litigation. I mean, this is, what's what they want to do?
I've thought about that. Here's why that doesn't work. Because Lee Parsley has the best counter to that, which is to say, no.
This is just
We
for the
just
bad
want
ones.
to get rid of the frivolous cases. I do not want to get rid of personal injury. And then if Jack says, well, it's more nuanced to that because he really does, they tune out.
Right.
And he does. That's the other problem is Jack and Jim don't have enough time to get into. Here is why it will get rid of the personal injury space, and here's why your constituents are all going to call you and be pissed. But they don't give them enough time.
So,
When
You know?
I mean, I feel like there's got to be a better way to message this. Maybe whoever the Republicans pay gajillions of dollars to like do their messaging for everything, we should pay them to figure out how to,
The problem is Lee's budget is 26 million. TTLA's budget is like tiny. It's a
we're the
joke.
big advertisers. We're the
We
big
don't
guys.
have the money to give the big advertisers. Oh,
No,
you're
I'm
talking
talking
about
about the personal injury
I
lawyers.
talk about that all the time.
Where are they?
Where's Thomas J. Henry?
Thomas
Where's
J.
Jim
Henry? I
Adler?
make $1 billion. I'm not trying to put a target on my head here, but
And not to call anybody out. We're not degrading people who have been successful, certainly in our industry.
but they need to help out.
But they're not helping.
They need to put their money where their mouth is.
And they're bragging about these wins, which gives ammo to Lee to say, look at how ridiculous these payments are.
Especially the wins that they never collect on.
Right.
Default judgment, gajillion dollars.
Right.
I don't know if that's a real number, but gajillion.
Yeah,
but-
gajillion. Or 1 billion was his billboard
But
saying.
where are these guys? I mean, we're Jim Adler too, and I know some folks over there, and some really great lawyers who work there. But where's?
But those guys, and they have time. They're not practicing law. They're just CEOs.
Well,
They
the
have
big
time
guys.
to go down there. That's what makes. Take your private jet.
Well, maybe not. Maybe they're not the ones who should be sitting there in the hearings themselves. But I'm talking about at least supporting the fight.
At least supporting, yeah.
You know.
Well, the other thing you'll hear from a lot of people is, no, those guys support. But then you dig deeper, you say, well, how much? $5,000.
That's not. I mean,
it's like
that would be a lot for me and you.
Yeah.
But not for somebody. If they make. I mean, I can't imagine what their income is.
Oh, it's outrageous.
It's a lot.
It takes the decision
Um.
of the jury.
Yeah, I mean, yeah. Where's Nick Rowley? Right? He's
This is why Nick doesn't try cases in Texas.
That's just completely unconstitutional.
right.
Can I speak to that just for a second? This bill was built around a concept called remittiture. I went and looked.
The first references to remittiture in Texas statutes and the civil justice system was in the codification of 1856.
Yeah, that's the thing. I mean, remittiture is a thing.
It is a process that exists in Texas and it exists across.
It's a process, but it's never been used as leverage to abuse the system.
Across the courts across the United States, including the federal court system, where a judge, having heard the same evidence as the jury, can say at the end of the trial, if the jury's returned its verdict, the number seems manifestly too large to me, and it needs to be lowered. That's called remittiture. It is a judge looking at the evidence over the jury's shoulder and having a different view of it. And it has existed in Texas since 1856. So Connecticut does exactly what this bill does. Connecticut says in its statutes, if a verdict is over $1 million for non-economic damages, the judge shall consider remittiture if it's manifestly unjust. So it is not even.
They have to do it because they also say if the guy, there's another portion of the bill that says if something is not followed in this bill, it's automatic reversible error. They changed the rules of appellate procedure in this bill.
I mean, and I can't believe that all lawyers of all walks of life and judges aren't going in there and testifying against
Because they don't have time. First of all, they don't know it exists.
Well, it's true.
I bet if you talk to 100 lawyers, 99 of them don't know this is happening right now.
I bet most personal injury lawyers probably don't know.
Probably don't. Most judges don't know. And they don't have time. You know why? The judge is like, oh, well, I'm down here trying cases, E.T. I can't make it to Austin because I got a hearing this afternoon.
Yeah, because then
That's
Lee
their
Parsley
whole-
will start complaining about them not doing their job.
Right.
If they're coming down there and
That's the whole point. He knows that. And that's why he tells the legislators, you want my bribe, you want my money, you'll have this heard Monday at 9 when no one's watching.
So what dirt do we have on Lee Parsley?
I can't imagine what this creep has in his closet in his giant mansion. But Lee Parsley is just a character. All he is to put a face to the oligarchs. Because remember, it's on the other reason is the people that give money to Lee, he's the one who has to go out there and get publicly shamed to the extent he does by us. But none of them are ever heard of.
Is that all? You see, I don't know enough about the legislative process. And,
It's all public. All the money that TTLA takes in is all public.
So all the money he takes, what is it? Texas for lawsuit reform?
Yeah, so you can see like their salary expenditures. I can't remember what his salary was last time when I looked it up. But then he also puts some of the money in their super PAC, which super PAC has certain contributions that can remain anonymous.
Justice for the people, baby.
For the people. For the
New
frivolous
to
cases.
us, this idea, and it is not unconstitutional, anything we've done since 1856.
May I respond?
Purdue shaking his head.
This use of the term remittiture is not using the term as it is meant. It bastardizes the term of remittiture because remittiture is something that does exist in common law, and so does something called additure. Remittiture and additure exist in law, and they allow a judge to look at a jury verdict and go, you know what? You asked for $3,000 in medical bills, and they gave you $45,000. Okay, there's no evidence to support that. So if you take this up, you're going to get reversed. So here's what I'll do for you. You can accept the $3,000 you argued for, or I'll give you a new trial. But the judge cannot come in and say it's going to be $3,000 because that's the sole province of the jury. So any invasion where the judge comes in and says, I'm going to put my judgment in for the jury is unconstitutional because the Texas Constitution guarantees a right to trial by jury and guarantees that the juries are the sole finders of the fact. So that's not how remittiture is. The only thing that remittiture and additure is, the judge has the hammer of a new trial and can say, if you don't do this, I'm granting a new trial, you're doing it again. But they do not come in and rewrite it. That is not what a remittiture is.
How would the provisions in this bill regarding non-economic damages impact damages for, say, a brain injury or another lifelong debilitating illness?
So I'm going to let Jim, that's kind of Jim's territory. You want to handle that again?
I will. So in the conflation, Dean, of the way they define non-economic damages, because they've eradicated the area of physical impairment, and conflated then, they've just essentially combined loss of function, comfort, and society with
right.
mental.
And he's also about to talk about how in the bill it has to be a visible injury,
So,
external visible.
so brain injury would not be.
Right.
Okay.
That's
so
the whole point. That they're also trying to get rid of all TBI cases.
Because, yeah, I mean, TBIs don't always show up on MRIs. Often they
I
don't.
can't see your brain. I don't know if you can see my brain, but I can't
What about a
see.
fractured spine?
I can't see through.
What about a fractured arm?
You know, my buddy Clark, what's his name? Clark Kent, I think has that ability, but he's the only guy I know. He's the only guy I know that can see through somebody's body. It's just
mental anguish. The Texas Supreme Court has recognized that those are separate elements. So if you have a brain damaged child,
this crypt keeper lawyer guy really should not compare to states like Connecticut. Agreed, Sarah.
Who suffers an hypoxic injury at birth and is left for a life of daily care and impaired. That child's anguish is one aspect of the damages as it exists, but the impairment to the child's function has always been something that the common law has recognized is a non-economic damage that should be compensated if there was culpability, because you have taken a value of human life that we recognize in law. And the Texas Supreme Court has recognized that those are separate. Texas Supreme Court has said that pain and anguish is separate from physical impairment, is separate from loss of comfort in society when you bury a loved one. This bill says that's no longer true. This bill says that mental anguish is all of those things, and physical pain is limited to these things and nothing else. And so it changes fundamentally the non-economic damages for a brain damaged person.
So is there any provision or any allowance for a lifetime of care or inflation over a lifetime of care as a result of an injury?
Well, so now you're talking about future economic damages, that is the medical expenses
Yeah, it doesn't
necessary to
affect
take
that.
care of a brain injured person, right?
And that's where our governor would say,
There's a section on that, and of course, one of the oddities is this bill mandates that future medical care now gets turned into the reimbursement rate on insurance that is presumed to exist for the rest of the lifetime of that beneficiary for what it would have paid the year before the injury happened. So you have a 2-year-old child who is left an invalid and brain damage for the rest of their life for 70 years. The future medical expenses is essentially calculated as the health insurance reimbursement for whatever that necessary medical care is as of the year before the injury happened for the next 70 years, assuming that child has maintained equitability to insurance and is not left on the Medicaid rolls of the state because of poverty.
Thank you so much.
Well, future damages are a unique challenge in themselves, future medical damages.
So like Lee just gets to talk whenever he wants. Have you noticed
he
that?
just jumps in, yeah.
He just gets to jump in whenever he wants and doesn't have to be asked a question. Why is that?
Well, because it's...
Because he's bribing all these people. God.
We don't know that for sure.
He is.
Do we know
He
that
is.
for sure?
You know what? I'm gonna do a separate video on how a dollar goes into TLR and goes out to the very committees that they're sitting before.
Okay, let's do it.
It's
I'll
just,
Because
I'd love for you to join me
in the
on
future.
that.
It could go 50 years in the future or longer. And so how do you figure
Let's
out
see if the
what
viewers
that
want me
number
back.
is?
They
You
will.
have to
They don't
figure
have a
out
choice.
what
All
healthcare
nine,
cases are
all
for
nine,
the
6
period
people
of time.
currently
And
don't have a choice.
what that amount of money would be to pay for those, and then you factor in some inflation, and then you have to discount it back to where you started, in a sense. So what this bill says is you look at that lifetime of care and you price everything based on what today's amount is times 150%, but you award them for their whatever care there is for their entire amount of time. This bill doesn't change that fact. What it doesn't allow is for the numbers to be unconnected to anything. It connects the numbers to 150% of amounts actually paid. So again, it's an attempt to, in a good attempt, it's the right way to do it, to connect the numbers for future medical to something that's in the market today, so that it's not just a number that the witness made up because that's the best they could do. So it's an attempt to connect to the market, and I think you have to, in fairness, for everybody involved in litigation, have some market-based element even to future medical damages.
Thank you so much. An analysis that I read about this bill says that it does not cap any damages and it does not set medical billing rates. Do you agree with that?
That's absolutely true. And let me answer those. First of all, we've talked about the cap on damages. It's not a cap. It's a process called remittiture, and the trial judge, if the trial judge says, I'm not going to order remittiture, then the trial judge must write down why he or she believes the number is the correct number. And so it's either you order remittiture or you give an explanation. So that's not a cap, and as I said, Connecticut's doing it today. Hard caps exist all over the United States, and hard caps exist in Texas in medical liability cases, for example. We have caps that are just it. This is it. This is the number. That's all you get for non-economic damages, and they're all over the United States. But this is an attempt to go in the middle. You've got a problem here I believe you'll hear about today, and you could do hard caps. You could just say, here are your caps on non-economic damages. You could say, we're going to do nothing about the problem, or you can try this process about remittiture where it's somewhere in the middle. And that's what it is this bill attempts to do, is to try to find some middle ground between hard caps and nothing. And then on caps on medical damages, it allows a doctor the opportunity to say, I'm going to submit an affidavit at 150% of the all payers claims database, and then I'm done with this lawsuit. I don't have to be a witness at this lawsuit. I just can walk away and go back to my medical practice. But the doctor does not have to do that. And the doctor can come to trial and testify to any amount he or she wants as reasonable and necessary medical expenses. This bill does not limit their testimony. So therefore, I do not believe it sets medical billing at all. What it does say is at the end of the day, the judge must apply this 150% number to whatever the damages submitted by the doctor are and believed by the jury.
Thank you, Mr. Walker. Mr. Perdue, do you agree that this bill does not cap any damages and does not set medical billing rates?
Well, it does both.
It does both?
Yes, it caps damages for the reasons that I testified before, because the jury is the sole renderer of the verdict, and this bill allows a judge to go in behind the jury and actually lower the verdict, and that's unconstitutional, and that is a cap. Okay. The second part is it
It's exhausting, man. All right, well, folks, the legislature was sick of being exposed and cut the feed to the state Senate. They cut the feed. You know, we've been here streaming for almost 5.5 hours, and then all of a sudden, the Texas Senate has cut the live broadcast of the hearing on tort reform. If this isn't corruption, collusion, I don't know what is. We don't have specific evidence to prove that it was this YouTube channel, but I would suspect that someone went down to the floor of the Texas Senate and said, these two guys are spitting straight fire against you. Shut it down now, like John Taffer on Bar Rescue. E.T., what are your thoughts? It's disheartening. We were just getting going.
Yeah, I mean, I was really interested to hear what people had to say about this. I mean, especially, you know, our guys. And you guys and,
or the public that's supposed to show up. Or the witnesses.
And the clients, right?
Yeah.
I think Jim Perdue had at least one client who was going to be there. I mean, is this
That's the floor. You can see live video feed of the floor of the Texas House, but the Senate State Affairs, the video's gone. So,
I mean, they probably don't want people.
They don't want people to know.
They don't want people to know what's going on.
This is fucking blatant corruption.
It's closed door government, man. Well, while we are here, do you want to put up all the contributors to Texas lawsuit?
Yeah, let's do that. Let's dive into, you know, a lot of people have been commenting saying you two are just conspiracy theorists. You have no evidence to back this up. You guys are full of crap. Well, you know what? We'll bring it to the people. While the corrupt legislature doesn't want you to see this, we do. We think you should see it. Texans for lawsuit reform.
We have a viewer who says that we sound far away. Hold on, let me see. Is my I don't know. Is it? Are we
You're
looking at
on.
the mix there? My mic is on.
You're on.
What about now? Still on.
Chat, let us know. Steve, Batman's on there. Steve Batman. All right, let's take a look at the amount of money. What we've been talking, a lot of stuff has been said about the bribes being taken in, but it's a fact.
Let's go up. Let's look at this graph real quick. And if you look at the spike of those are the expenditures.
Yeah, that's money going out. 26 million cash on hand. 26 million.
Almost 18 million going out in, what, 2024?
Why doesn't the insurance company use this to pay claims?
Yeah.
Like, there's the media thing you were talking about. Why don't we have the same media?
So, these are the expenditures. I got you.
Yeah, why don't we have the same media companies as they do? It's because, that's the media company they're using. They're also investing $3.2 million for what? To enrich themselves. So they've taken $7 million and put it in an investment account. Who is Richard Weekley? Who's this turd?
So he is a co-founder of Texans for Lawsuit Reform. I just looked him up.
There's Elon Musk. $1 million from Elon Musk. And why do you think Elon suddenly
is interested in lawsuit reform? Could it be that they got hit by Nick Rowley a couple years ago?
No, they got hit by Bill Ogden a couple years ago in the Alex Jones case.
Oh.
And the guys over at Farrar and Ball. And now Elon, well, let me back up. Did Elon get hit by a big verdict? Elon is being sued by the same guy who brought the Alex Jones cases for defamation against Elon, and he thinks the case should be thrown out. He's been public on that on Twitter. Mark Bankston is the plaintiff's lawyer. $1 million. You know what you could do with $1 million? You could like feed a lot of families.
Yeah. Well, so Tesla, by the way, there was a big verdict against them in Detroit, I think.
Nick Riley did get a big verdict
He
against
did.
Tesla. That's right.
He did. And my understanding is that for certain amounts of, whatever the settlement is over a certain amount of money, Elon has
to approve it.
And he did not approve a settlement in that case.
Right.
And they got a big verdict. Another Nick Riley. So, all
That's
right,
100% right.
So, but you know, the other thing here, Jim, if you want to scroll down a little bit, I don't want to mess with your mouse here. I mean, who are all these people that just have 6 figures of cash to give out?
Rich white folk.
Yeah, probably.
That's what it is, dude. I mean, it's sad, but this ain't your average mom and pop shop. People just.
Because look at, I mean, it's crazy to see the big $1 million, multi-million-dollar donations, but look at the like $500,000 a doctor.
Let's see who that is.
Yeah, let's look her up.
My God.
Oh, wait, is she the one who owns the? Is she own the Mavs? Is that her family or is that someone else? Hold on.
Israeli billionaire. Adelson.
Go to the wiki. Yeah, new Mavs owner. She's the Mavericks owner, the one who traded Luka away. And I'm not a Mavs fan. I'm
this
not,
lady,
you
dude.
know, I'm a San Antonio guy, but you know, I get it.
Damn.
How much did she give? Was it $500,000?
500.
Cheap.
That's nothing. That's
nothing.
That's a write-off. Let's see who this Sharon person is. Cheryl. 15 million to SMU, a joke of a school.
Oil guy.
Oil tycoon.
Wait, there was a federal antitrust lawsuit involved?
Oh, here we go. They got sued. So
Let's
now
look at about their political contributions too, or at least it says it in the thing there.
founder of a giant energy company. Huh. 15 million's a lot. Stephen Wynn, isn't that the hotel guy?
Yeah, he's a Houston guy.
Yeah.
Doesn't he own the Rockets, I think?
Oh.
So we got all the sports team owners. Because you know that if they're giving big money, it's got to be good for the people, right?
Dude, everyone knows that you protect the people by not allowing the rich people to be sued.
Obviously.
Adelson? Yeah, Snake is right. It's just...
Spend all this money so they could, and that's why they traded Luka away, you know?
Yeah. This is really...
Who else is on that list?
This live stream...
I mean, you have to get 3 pages deep to get below 6 figures on the donations.
That's crazy. Well, folks, if you're just tuning in, they cut the live stream because of the tort reform bill that we were covering all day for 6 hours. They cut the live stream. My only suspicion is so you guys can't watch it because they realized this is not going well. I mean, they were being straight exposed by Jack Walker and Jim Perdue, and it wasn't going well for them.
I would say not. I mean, I think that, but I mean, I don't even think, listen, the only people watching this are probably people in our world.
Right.
I bet the people in the tort reform world don't even give a damn. Like those
No.
on that side, they're probably not even watching.
They know it's going to pass.
They know
Why
it's
would
going to
they
pass.
watch?
They know, you know. I mean, I don't know if this bill in this form will pass. I mean,
I hope not.
It's ridiculous. Well, I think we better file all of our lawsuits now.
Yeah, that's right, because the bill will take effect in September 1st, moving forward. So yeah, if you wanted less litigation, this is not a way to do it because now we'll file every case. Not, I mean, to the extent we weren't already, but
yeah.
Now I don't see any benefit. What a sad day. Well, I mean, I don't know what we do. Do we shut down the stream? Chat, let us know if we should shut down the stream. That's kind of my thought.
I'm missing.
At least we got a cookie out of it.
We did get a cookie out of it. Oh, I probably owe you some money for lunch.
No, you're good.
You sure?
This is for the good of the people. This is for the good of the people. Because everyone in the chat was like, when do we get to hear another person?
Just tired of hearing your voice over and over
Yeah.
and over and over.
Florida versus Donna Adelson. Ooh, a murder conspiracy out of Florida. Ooh, Sarah dropping the T in the chat. Thanks for sharing, Sarah. Getting
We
a
got
lot.
somebody said never stop streaming, Jim.
Well, we can.
You know, maybe they cut the video off when people start bringing their clients and the amputees in there. But like, this is what you're saying, is that they'll never, I mean, what is the value? You know, I think it's, look, I get that people have that idea of, well, how do you value this? How do you value that? But, you know, that's what our system is based on.
Yeah, you're not valuing it alone. There's 11 other people in the room with you.
There's 11 other people. There, and you know, this is why we started this country. You know, life, liberty, and the pursuit of happiness. What does that mean? What does life, liberty, and the pursuit of happiness mean?
You don't get happiness if there's insurance companies anymore.
Well, that's exactly.
You're not going to have life. Well, you do get life. Your life is valued at $250,000. You don't get liberty because the insurance companies through BlackRock are going to own all the residential homes.
That's true. Man.
That is how deep this goes, brother.
Yeah. That's what we, because that'll make housing more affordable for people. Is that BlackRock own all the homes?
It's working out so far. Look,
There's our guy, Lee Parsons.
If they're not going to live stream the video, then everybody else has to look at this guy's face.
Yeah,
for the
let's pull this up.
Look at the rest of this guy's face for the rest of the day. There he is. There's our boy.
So that's Lee Parsley.
That's the guy we were watching testify.
I mean, what's his background? Let me look this guy up.
Yeah, what is his? Look him up.
Let's look.
His hair is the same. His Crypt Keeper face has gotten worse. We're continuing to refresh the Senate page, folks. If it goes back live,
I bet
they're on a break. They're on a break. You see, there's the head of the Senate State Affairs Committee.
I got some bad news for you.
Huh?
He's a Texas Tech law grad.
Are you kidding me?
I can't make this up, man.
So he's not an idiot. He's not an idiot. He is smart. He's probably.
It doesn't say what his. I'm looking at his LinkedIn. So from January 2017 to present, he's general counsel for Texans for lawsuit reform. But he doesn't. It doesn't show what else his background. What else he did? He probably was not
Eat
a very
babies.
You know that he was not a talented lawyer.
No.
Otherwise, he would.
What's his salary? He's got to tell us.
He was an appellate lawyer.
We have some doctors now appearing in the Senate. They're on a break because that's the guy we were just watching. The guy in the middle.
Do we miss Parsley slipping an envelope to somebody or?
Oh no, he's.
Oh, the doctor with their lab coats.
He's.
Doctors,
Let's switch back to the live stream so that people
Just so
can
you-
see what we're talking about here.
Yeah, show them the lab coats. This is great.
You know what happened? You know why these doctors are there, dude? One of these old geezers in the Texas Senate had a heart attack.
Is that,
yeah.
Look at that picture time.
I had a question. If there's anybody in the chat that works at the legislature, how do we get on the floor? Can we just walk down there? Do you think you have to have a badge? We can testify. You have to register as a witness, but you can only do at the state capitol. So you can testify, but I want to be on the floor, like walking around the
Well,
floor.
can you? Yeah, I mean, this is open government, right?
Surely they don't allow people to just waltz around down there. You got to have some kind of badge or something. What are they telling him?
You know,
he's like, look, you'll be fine on the reimbursement rates. You'll be fine.
By the way, these doctors have no idea what reimbursement rates are. Have you ever deposed a doctor about?
Oh yeah, not about
signed affidavits, counter affidavits.
No.
Hey, let's talk about. You've heard of Make Cost Contain, right?
Mm-mm.
So Make Cost Contain's a company based out of Dallas that they're basically the.
Meg Healthcare.
Is that what it is?
The
message from the governor. The secretary will read the message.
Wait a second.
To the Senate of the...
Oh, wait, this is the message. I saw the YouTube channel. I saw Jim and E.T.
Jim and A-Tom were on the YouTube channel. So
and damn, spitting facts. And I hate them.
They were talking about my little incident.
They talked about me hot wheeling. And they don't like my $11 million payout. Let's see what this is. Folks, if you're in the chat, the governor is sending a message to us.
89th Legislature regular session, I ask the advice, consent, and confirmation of the Senate with respect to the following appointments. To be members of the Texas Military Preparedness Commission, Michael L.
Oh, come on!
What is this crap?
You know what? This is code. This is code. This is code. It's not always what it seems.
Mike Boyd.
I have played Call of Duty, so military experience.
First of all, Gary W. Bradford, Corpus Christi, Todd M. Fox,
Todd Fox. Wasn't that your alias?
That was Rusty Shackelford.
Rusty Shackelford.
To be members of the University of Texas System Board of Regents.
Damn it. Well.
All right, this is just.
Dallas, Jody Lee Giles.
So Make Cost Contain.
Yeah.
You want to hear about Make Cost Contain?
Dallas.
I'm surprised you haven't dealt with them in any of your cases. Oh, they're whores. No, so Make Cost Contain is a insurance industry.
Oh no!
Like expert.
No.
I don't know a polite way to say it, but they're the ones who hook up the defense doctors to the lawyers for the cases.
And you've deposed one of these folks?
So I had a case where they submitted. It was in federal courts in the Northern District of Texas where they don't do affidavits.
Mm-hmm.
So they had expert reports saying
you could take your seats.
this is what the reimbursement rate should be. We deposed them. They said they have no idea. They just were basically given these things by Make Cost Contain. They signed it. And a judge in the Northern District of Texas, what do you think? A federal judge who is not a liberal by any means, what do you think he did, Jim?
Granted them.
He granted our motion to strike.
Good.
And there's a published opinion about how awful, it's like these guys, it's not scientific, it's not reliable, because they don't even know.
Wow.
So
good for you, man.
And so they do reasonableness and necessity, where they just have a doctor rubber stamp. And then they also have doctors, like in my case a couple weeks ago, I deposed one who was, did a medical record review and, hey, it was hurt for 6 to 12 weeks, he should be fine. So, that Make Cost Contain has all those, they have the Medicare rates, and they say this is what's reasonable.
Well, they're not going to be necessary anymore.
I don't think they're necessary now.
Well, the defense,
so much.
the defense won't need to hire them because the bill will say, we'll go by what's in the database.
Right. Which totally.
There's Royce West right there.
What is that?
Senator of Dallas. I don't know what Senate resolutions do.
I think it's just a cool thing to frame.
Oh.
You get it and you frame it in your office.
We need a Senate resolution that this podcast shut down the live stream of tort reform on March 31st, 2025. Huh.
Yeah, this is about Vietnam. This is about veterans.
Well, I guess we're done.
I mean, is this just the Judicial Committee here? Or
No,
all
this is the
just
Senate
whole
floor. Or this is the House floor.
Are you sure? I think it's because this is Senate resolution, right? SR.
I don't know who's I mean, I don't know what they're voting on. I don't know if this is an announcement. There's the lady we were just watching.
Oh, right. Do we know, is she a Democrat or Republican?
I don't know. I don't know her name. I thought her questions were good.
Yeah, I thought she had thoughtful questions about, these things.
Oh, okay. Andre the lawyer is giving us, he said that, my video must not have picked it up. He said that they said during the middle of the testimony, we're going to need to take a recess.
Okay.
So that must be what happened. I am still of the belief that they cut the feed and took the recess because of the fire they felt all the way from up here in Dallas in the storage closet.
This is almost like the nail salon law office from a TV show that we won't.
Nail salon law office. Better Call Saul? Oh, see, I've never seen that show. I need to watch. Everybody tells me it's great. I've never seen it.
Yeah, you should watch because you're gonna be like.
I heard on Bob Simon's podcast that is the most accurate lawyer show.
It's pretty, especially about starting your own firm and going solo. Like it hits home. Like I know other older lawyers who.
Yeah.
I mean, it started when I started my own firm too. So it was like.
Okay. I'm gonna. What? Is it over now? No more new seasons.
No more new seasons.
How many seasons did it go?
5 or 6, maybe. Did you ever watch Breaking Bad?
No, I tried to get into it. I thought it was boring.
It's a good. It took me a while, but it's a good show.
That's what I hear. I could never make it past the first season.
It's nothing like The Wire, which
is your favorite show?
Which I talk about all the time.
Because you lived it.
I lived it. I lived in the streets of Baltimore.
You are Omar. Basically. They wrote the show about you.
They filmed the scene down the street from my house. Right outside my
Really?
neighborhood. Yeah. One scene.
That's awesome.
Speaking of Baltimore, I'm missing the Orioles game right now. If anybody cares about Orioles baseball.
If anybody...
Probably nobody here does. That's okay.
JG videos, oh, that's good. All right, I need a break. We got to take a break. Let these babies charge. I'll keep monitoring the stream. I will keep it running in the background, but got to do some form of work today, although informing the public is a job itself. Probably the better job. Until then, we will tune back in.
We'll take a little break. Thanks
for everybody who's listening. We'll keep the stream up for a little while. Any final words from ET?
Well, I mean, we're gonna be back, so check.
We might not today. If they don't, I mean, it's already 2:33. I don't know if they'll come back on.
This is obviously my first time doing a live stream because I need to figure out.
Don't you have a Twitch?
No, I don't even know.
God damn.
Is that like gamers? They stream on Twitch? No, I don't have a Twitch. Me sitting there playing GTA.
ET may never appear on this stream again. No, just kidding.
Thanks, Jimmy.
Thanks for your time. Thanks for coming down. We'll keep it up. We might rejoin here if they pick back up. But until then, we're going to take a break and keep the stream up. Bye, guys.
Senator, thank you for the resolution, Senator Hancock. I was a kid watching this war on TV. I'm sure like you were, and many of us, stepfather was a World War II vet, 60s, early 70s. We're watching the news coverage. It was our first nationally broadcast war on a day-to-day basis. One of the reasons it made it so unique and so difficult. There's two things I would want to express in expressing support for your resolution. Just tell you a quick story. I know I want to be quick, but respectful. After the first Gulf War, 7th Corps deployed out of Europe to go to the Middle East. And 7th Corps is 5 divisions, so you're looking at about 160 to 180,000 people total that came out of Europe to go take on Saddam. I won't get into that, but we didn't get to come home to the United States. We went back to 7th Army to continue to stand along the Fulda Gap. We landed at Rhein Main Air Force Base, got off of that 141, and there were Vietnam veterans that were living in Germany, that were married to local nationals and retired, or maybe they were civil service, but there was a Vietnam vet in a wheelchair and another Vietnam vet that was standing there, and both in relatively good health, other than, for what we could see in the wheelchair. And they were welcoming all of us home. Even though we were in Germany, not the United States, but you could see the tears in their eyes as they're welcoming us back, not just because of the success, but you could see how much in their hearts they longed for the welcome that they were giving us back to Germany that they had never gotten, coming about a way, we could name all the places, but I know Chewy can. Because what hurts the Vietnam veteran's heart, and I won't speak for Chewy, but I think he would agree with me, that when you subordinate yourself to government, as Christ subordinated himself to the Father, took on the mission that was given him to bear that cross, and the members of the United States Armed Forces that bore the cross of going to Vietnam to fight for a freedom of a people we didn't know. What hurt most wasn't the sting of battle or the mud of jungle. It was coming back home to a country that instead of having to shower away that sting of battle or the smell of jungle, they tried to shower away the contempt of their fellow American citizens of the service they had just rendered in a very unpopular war. That's what hurts most Vietnam veterans' hearts, is that they had paid, in some cases, the ultimate price, in other cases, very difficult price, physically, emotionally, mentally. And to not have that suffering and sacrifice recognized is the most hurtful thing to our Vietnam veterans. And that's why whenever we're in session, and while you're Chair of Veterans Affairs, we'll do this every session to recognize all of those veterans that paid such a terrible price. I very much appreciate it. God bless you, Senator Hossa, and all your comrades and colleagues that served with you, that you knew and that you didn't know. It's an honor to be among you in the Senate chamber today. Thank you, Mr. President and members.
Chair recognizes Senator Hughes to speak on the resolution.
Thank you, Mr. President. Members, I rise only to thank Senator Hancock for the resolution and Senator Hossa and Senator Birdwell for their remarks and what do we say about their service. My point in rising is to, at the appropriate time, move that we add all members' names to the resolution.
Is there objection to the motion? Chair recognizes Senator Hagenbuch to speak on the resolution.
Thank you, Mr. President. I'll just be brief. The others have already said it. I just want to say myself, Senator Hossa, and to all Vietnam veterans, thank you for answering the call to your country. Welcome home.
Chair recognizes Senator Hancock to close on the resolution.
Yes, thank you, members, and thank you, Senator Hughes, for adding all members' names, because unlike when you came home, Chewy, this entire floor supports our veterans. And regardless of the commands that are being given, we all should recognize the heroes of those that are willing especially to enlist, to lay down their lives for the safety and the protection of those of us that have not had the privilege to serve. And so we thank you. With that, I move adoption.
Would all those in favor of the resolution please rise? Resolution's adopted. Members, take your seats for a memorial resolution. The chair lays out the following resolution. The secretary will read the resolution.
Senate Resolution 356 by Eckhart et al. Whereas the Senate of the State of Texas honors and commemorates the life of Carol Stewart Keaton, a highly esteemed Texan and a pioneering public servant who died on March 26, 2025 at the age of 85. And whereas born September 13, 1939, Carol Keaton was the second child and only daughter of Madge Anna Stewart and W. Page Keaton, legendary dean of the University of Texas School of Law. Enthusiastic and driven from an early age, Carol attended the University of Texas in the early 1960s, which helped to lay the foundation for her distinguished career of public service and a lifelong dedication to her community and state. And whereas Carol broke barriers in Texas politics and government throughout her career, and in 1972, she became the first woman elected president of the Austin Independent School District Board of Trustees. She went on to become the first woman to serve as mayor of Austin in 1977 and committed her efforts to fostering the growth and development of the city, and she remains the only woman to have held the office. And whereas in 1994, Carol Keaton became the first woman elected to the Texas Railroad Commission. And in 1998, she earned the similar distinction of being the first woman elected Texas Comptroller of Public Accounts. She served in this capacity from 1999 to 2007, during which time she demonstrated a robust commitment to fiscal responsibility and good governance, as well as a dedication to economic transparency and a principle-driven work ethic. Whereas a powerful voice for Texans, Carol made an impact that extended well beyond her official duties, particularly on issues of education and government efficiency. Her influence resonated across party lines, and her snappy delivery and personal aphorisms endeared her to many and served to highlight her sharp wit and her keen insight into the challenges faced by everyday Texans. And whereas while her professional accomplishments were remarkable, Carol found the greatest reward in her role as a mother and grandmother. She raised her 4 sons with care and devotion and instilled in them the value of hard work and the same diligence and intrepidity that defined her civic service. She treasured time spent with her grandchildren, who were a source of much pride and joy to her, and she was a model of grace and resilience to her loved ones. And whereas a woman of strength, perseverance, and generosity, Carol leaves behind a distinguished legacy of service shaped by her notable achievements and her spirit of determination. She will continue to be a source of inspiration to others long into the future, and her memory will be dearly cherished by her loving family members and by the many people who were privileged to know her and to share in her life. Now, therefore, be it resolved that the Senate of the State of Texas, 89th Legislature, hereby extends sincere condolences to the family of Carol Stewart Keaton, and be it further resolved that when the Texas Senate adjourns this day, it do so in memory of Carol Keaton.
Chair recognizes Senator Eckhart to speak on the resolution.
Thank you, Mr. President. I had the distinct honor of knowing Mayor Keaton, Controller Keaton. She was a force, an absolute force to be reckoned with. I rise today to recognize this trailblazing leader from our community here in Austin. The resolution already details her many accomplishments, but Keaton was truly one tough grandma. She was one tough woman before she was ever a mother. She was one tough mom. She was one tough mayor. She was a tough first woman to preside over the Austin School Board from 69 to 77. She was one tough woman on the Texas State Board of Insurance in 1983. She also spent time in the Texas Railroad Commission and aspired to higher office, making a run for the halls of Congress and for the governor of Texas. She was just indefatigable in her desire to serve. And not just serve for her burnishment of her reputation, but for all women, for all Texans, and to serve as a team. I can't tell you how many times people who worked in the controller's office, whether they were Republicans or Democrats, just lauded her as an employer and as a person who would raise them up in their careers. Regardless of where she lent her services, whether as a Democrat or a Republican or as an independent, because she had been all three. Keaton was deeply committed to her community, and it wasn't just about looking good. It was about doing good. During her tenure as the Austin ISD Board of Trustees, she was an early advocate for the desegregation of every Austin school, ensuring equal access to educational attainment and achievement. And even after her time in public office, Keaton continued to advocate for the Austin community through her work with Austinites for Action, an organization which helped to pass a proposition improving access to health care in Travis County. The dedication she showed in her political career mirrored the dedication she showed to her children in her personal life. Keaton was a single mother of 4 sons while she did all of this. She wasn't always single, but she was often single, as she did all of these incredible jobs, dancing backwards in heels, raising 4 boys, but always led with her values. While she was first in many aspects of her career, her greatest personal priority was her family. She's survived by her 4 sons, Brad, Scott, Mark, and Dudley McClellan, as well as 9 grandchildren, blessing this one tough grandma. Thank you so much for recognizing her today.
Chair recognizes Dean Zaffarini.
Thank you, Mr. President. Mr. President and members, thank you for taking the time to honor this wonderful woman, Carol Keaton. And thank you, Senator Eckhart, for sponsoring this resolution, calling attention to her. She will be missed by so many. She is not only a person who will be known to be the first in many, many, many categories, some of which were listed today, but in many more, because she was indeed, as Senator Eckhart pointed out, a trailblazer. She was known for being so smart, she was known for being so knowledgeable, but she was also known for being so kind and so funny. She was hilarious. In fact, I remember in 2003, when she was elected a distinguished alumna of the University of Texas at Austin, she acknowledged that she was known for talking so quickly. Nobody could talk faster than Carol Keaton, nobody. And she said her favorite childhood memories were of her mother allowing her to lick the beaters while the mixmaster was still on. She loved telling stories like that about herself. Governor Rick Perry at the time roasted her, and he said she was known as one tough grandma, but she was really one tough monogram. And he teased her in so many ways. And she was loved so much across party lines because of her kindness, because she reached out to people. Here she is being honored. She, a Republican, being honored by 2 Democratic women. So you know that she worked across party lines. And she always remembered that she began as a school board president and as the mayor of the city of Austin, and loved to quote a mayor from Canada who said, "Whatever women do, we must do twice as well as men to be thought half as good." But then she added, "Luckily, this is not difficult." Thank you, Mr. President and members, and thank you, Senator Eckhart.
Chair recognizes Senator Eckhart to close on the resolution.
Thank you, members, and I vote adoption of this resolution in memory of Carol Stewart Keaton, a phenomenal woman.
Would all those in favor of the resolution please rise? The resolution is adopted. Dean Zaffarini.
I move that all members' names be added to the resolution.
Is there objection? Hearing none, motion is adopted. Chair lays out the following resolutions. The secretary will read the resolutions.
Senate Resolution 220 by Hinojosa of Nueces. Senate Resolution 221 by Hinojosa of Nueces. Senate Resolution 341 by Zaffarini and Schwartner. Senate Resolution 342 by Hinojosa of Nueces. Senate Resolution 343 by Hughes. Senate Resolution 344 by Hancock. Senate Resolution 347 by Paxton, and Senate Resolution 348 by Middleton.
Members, this is a voice vote. All in favor, say aye. All opposed, say no. The ayes have it. Resolutions are adopted. Members, if there is no objection, would like to postpone the further reading and referral of bills to the end of today's calendar. Hearing no objection, so ordered. Members, we will soon begin our calendar for the day. The following motion in writing, the secretary will read the motion.
Motion in writing. Mr. President, I move suspension of Senate Rule 5.14, the intent calendar rule, in order to move the intent calendar deadline to 5:00 p.m. today. I further move that the rule be suspended to allow the Secretary of the Senate to make the calendar available as soon as practical. Motion by Zaffarini.
Is there objection to the motion? Hearing none, the motion is adopted. Chair recognizes Dean Zaffarini for a recognition.
Thank you, Mr. President. Mr. President and members, on behalf of Senator Jose Menendez, I rise to recognize the student parliament from Churchill High School in his district. Members, Churchill High School's parliamentary sponsor, Wendy Charlton, has brought 28 of her students to learn about the Texas Capitol and legislative process. Today, we are recognizing the leadership team of Churchill High School Student Parliament, Prime Minister Noah Guajardo, Speaker of the House Josh Snow, and Parliamentarian Mary Paracle. He also would like to thank these students for their dedication and drive to supporting their community. All of the students here today are elected individuals ranging from the 10th grade to the 12th grade and represent their student body. These students are dedicated individuals who strive to promote a safe and positive environment in their school. They volunteer their extra time to support their school and surrounding communities by hosting on and off campus events. Each and every one of them has the great potential to make a significant impact on the communities in which they live. Thank you to Wendy Charlton for her commitment to educating these young individuals and for bringing this group to the Texas Capitol so they can learn more about the legislative process. Senator Menendez certainly hopes that each of you will continue to serve their community and make an impact on those in which you serve. Welcome to the Texas Capitol. Please rise and be welcomed and thanked for your service on behalf of Senator Menendez and the Texas Senate. Thank you, Mr. President and members.
Senator Hancock, you're recognized for a motion to suspend the regular order of business on Senate Bill 924.
Yes, thank you, Mr. President. I move to suspend the regular order of business and take up and consider Senate Bill 924 at this time, relating to entities that provide cable services or video services. Members, a cable franchise fee is an annual fee charged by local governments to a private cable television company as compensation for occupying the right-of-way for its cable lines. Well, times have changed, and so this has changed a little bit. Telecommunications providers that installs these lines in a city's right-of-way pays this for the right-of-way, simply the right-of-way to come across and have that cable line provided. Many municipalities across the country are now suing satellite TV and video streaming providers to each pay a separate cable franchise fee. This means customers could pay 5% more on each of their video streaming bills, even though the video streaming does not require additional cable lines. As you know, technology now allows you to stream across a single line that is paying for this right-of-way fee, multiple applications that you can download to your TV. So with technology changes, what we're finding is municipalities are seeking to raise local revenues on the back of these providers and hiding the transparency of revenue. There's no opposition to local entities raising revenue, just not on the backs and hiding behind these providers that you may have streaming onto your TV. So Senate Bill 924 would add clarifying language to prohibit municipalities from charging the cable franchise fee to a satellite and streaming service that is using the lines already available that are paying the fees. And with that, I move suspension.
Senator Hancock moves suspension of the regular order of business on Senate Bill 924. There is objection. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Creighton, Eckhart, Flores, Gutierrez, Hagan, Boo Hall, Hancock, Hinojosa, Nueces.
There being 22 ayes and 8 nays, the rules are suspended. Chair lays out on second reading Senate Bill 924. The Secretary will read the caption.
Senate Bill 924 relating to entities that provide cable services or video services.
Senator Hancock, you're recognized for a motion.
Thank you, Mr. President. I move passage to engrossment.
Senator Hancock moves passage to engrossment. There is objection. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Creighton, Eckhart, Flores, Gutierrez, Hagan, Hall, Hancock.
There being 22 ayes and 8 nays, the bill is passed to engrossment. Senator Hancock will hold there. Senator Hancock, you're recognized for a motion to suspend the constitutional 3-day rule.
Thank you, Mr. President. I move and suspend the rule that bills be read on 3 several days.
Senator Hancock moves suspension of the 3-day rule. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Creighton, Eckhart, Flores, Gutierrez, Hagan, Hall.
There being 24 ayes and 6 nays, the rules are suspended. Chair lays out on third reading and final passage of Senate Bill 924. The Secretary will read the caption.
Senate Bill 924 relating to entities that provide cable services or video services.
Senator Hancock, you're recognized for a motion.
Thank you, Mr. President. I move final passage Senate Bill 924.
Senator Hancock moves final passage of Senate Bill 924. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Creighton, Eckhart, Flores, Gutierrez, Hagan, Hall, Hancock.
There being 23 ayes and 7 nays, the bill is finally passed. Senator Hancock, congratulations.
Senator Hinojosa, Adam. Senator Zaffarini, you're recognized. Suspend the regular order of business, Senate Bill 1697.
Thank you, Mr. President. Mr. President and members, I move to suspend the Senate's regular order of business in order to take up and consider at this time Senate Bill 1697 relating to a consumer guide to home solar energy devices. Members, this is a companion to a bill by Representative Vandiver in the House. Generally, this bill would require the Public Utility Commission to publish a solar panel consumer guide on its website and to require utilities to maintain a link to each published version on their websites for at least 12 months after the guide is published. Mr. President, I move suspension.
Any objection? Hearing none. Rules are suspended. Chair lays out in second reading Senate Bill 1697. Secretary will read the caption.
Senate Bill 1697 relating to a customer guide to home solar energy devices.
You're recognized on passage to engrossment.
Thank you, Mr. President. I move passage to engrossment.
Any objection? Hearing none. Bill passed to engrossment. You're recognized. Suspend the constitutional 3-day rule.
Thank you, Mr. President. I move to suspend the constitutional rule that bills be heard on 3 several days.
Secretary will call the roll.
Alvarado, Betancourt.
29 ayes, 1 nay. The rule is suspended. Chair lays out in third reading and final passage. Senate Bill 1697. Secretary, read the caption.
Senate Bill 1697 relating to a customer guide to home solar energy devices.
You're recognized on final passage.
Thank you, Mr. President. I move final passage.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell.
29 ayes, 1 nay. The bill is finally passed. You know, Senator, you find a way to select bills that just come through here where everything's quiet. That's how you get to 100 every session. Yes.
It's
I think you look
hard.
for all of those bills. It's just going to glide on through.
Working hard, Mr. President.
Working
that's
hard.
All.
Senator Sparks, you're recognized. Suspend the regular order of business and committee substitute for Senate Bill 1038.
Thank you, Mr. President. Members, I move at this time to suspend the regular order of business in order to take up and consider the committee substitute to Senate Bill 1038. Each year, Texas loses an estimated $5 billion in taxpayer funds to fraud, waste, and abuse within the public health system. The statute governing the administrative enforcement of violations against the Medicaid program has remained largely unchanged since 1987, while the criminal and civil statutes have been updated and strengthened many times. The committee substitute for Senate Bill 1038 will align the administrative enforcement statute with the related criminal and civil statutes. Additionally, the committee substitute addresses several concerns from stakeholders. These include, first, clarifying that it is only a violation if a person knowingly submits a claim that they know to be a lie or an admission. Second, extending the timeline for a provider to request a hearing from 10 days to 30 days. And lastly, requiring that a brief summary of the facts, a statement of the amount of the recommended remedy, and a description of the administrative and judicial due process remedies be made available to a provider charged with committing a violation of this law. This proposal represents a critical step in the ongoing fight against Medicaid fraud, waste, and abuse. By updating statute, we can create a more effective and efficient system that protects taxpayer dollars, enhances program integrity, and ensures Medicaid funds reach the Texans who need them the most.
The motion is to suspend the regular order of business. Secretary will call the roll.
Alvarado, Bettencourt, Boardwell,
25
Blanco.
ayes, 5 nays. Rules are suspended. Chair lays out second reading. Committee substitute for Senate Bill 1038. Secretary, read the caption.
Committee substitute, Senate Bill 1038, relating to administrative remedies for certain fraud and abuse violations under Medicaid.
You recognize passage to engrossment.
Thank you, Mr. President. I move passage to engrossment.
Secretary will call the roll when ready.
Alvarado, Bettencourt, Boardwell.
25 ayes, 5 nays. The bill passed to engrossment. You recognize suspend the constitutional 3-day rule.
Thank you, Mr. President. Mr. President, so moved.
Secretary will call the roll.
Alvarado, Bettencourt, Boardwell.
25 ayes, 5 nays. The rule is suspended. Chair lays out third reading, final passage. Committee substitute for Senate Bill 1038. Secretary, read the caption.
Committee substitute, Senate Bill 1038, relating to administrative remedies for certain fraud and abuse violations under Medicaid.
You recognize on final.
Thank you, Mr. President. I move final passage of the committee substitute to Senate Bill 1038.
Secretary will call the roll when ready.
Alvarado, Bettencourt, Boardwell, Blanco.
25 ayes, 5 nays. Bill's finally passed. Thank you.
Thank you, Mr. President.
Much easier
Thank
than
you,
last
members.
session, right?
Thank you, sir.
Senator West, you're recognized for a motion to suspend the regular order of business on committee substitute for Senate Bill 1527.
Thank you very much, Mr. President and members. At this time, I move to suspend the regular order of business, take up and consider Senate Bill 1527. Members, Senate Bill 1527 is the City of Dallas Police and Fire Pension Fund bill. You know, before 2017, the statute governing the pension fund allowed unsustainable benefits to be approved by the pension board. As a result of this near failure in 2017, the state legislature passed House Bill 3158 to save the pension fund from collapsing and gave the pension fund and the City of Dallas until 2025 to come up with a plan. The plan basically said that if the only way that there would be a cost of living adjustment is that the fund was 70% sound. Well, members, in 2025, the fund, instead of becoming sound, is becoming more on the crux of collapsing. 32% funding sustainability at this point. As a result of that, the City of Dallas and its taxpayers contributed a significant amount to the plan to finance the benefits of this fund. Dallas City Council is committed to public safety and to fully funding the pension fund within 30 years as required by law, and demonstrated its commitment to the fund when it passed the Restoration Act back in September of 2024. Over the next 30 years, the city of Dallas will be putting in about $11 billion in order to make certain that this particular fund becomes sound. Move suspension of the regular order of business.
Senator Scrivener, for what purpose?
To ask questions of the author.
Senator West, do you yield?
Absolutely. Ready for.
Thank you. Senator, I apologize. First, I want to applaud you for your work you've done regarding the Dallas Police and Firefighters pension back in 2017, which kept it, and I remember those discussions as was discussed on the Senate Finance dais, and they were contentious and heated, and unfortunately there continues to be problems with that pension. Can you please explain exactly how much money the citizens of the city of Dallas will be putting towards stabilizing the pension fund for the police and firefighters of Dallas under your bill?
What the city has done over these last few years is sit down with the pension fund, with the members of the city administration, and come up with a plan. They'll be putting together like $3.2 billion. Right now, DFC has a $3.2 billion unfunded liability. And what's going to happen is that the city is going to be putting up about $10 billion over the next few years in order to make certain it becomes actuarially sound.
$10 billion, or I thought it was $600 million.
I'm sorry, you're right, it's $600 million.
$600 million for a $3.2 billion deficit.
A $3.5 billion over 30 years, and it's requiring about $11 billion in contributions over 30 years based on their new model that was put together.
But the extra amount that the city of Dallas is putting in is $600 million on top of their normal contribution. This is an accelerated contribution, essentially.
That's what the city decided, yes.
Right, to make sure that they stabilize the pension. Now, can you please explain if there's any additional contribution by the current police or firefighters, or any shared sacrifice on the part of the actual pensioners that are receiving the pension?
What I would explain to you is this, is that the city, working with its city leadership, has decided to structure a plan that will put additional monies in from the city, and then a stepped-up plan to make certain that some of the retirees get extra dollars.
Okay, but again, going back to
I'd answer your question, no.
The pensioners that are receiving money from the pension currently are the current police or firefighters that are paying into it through a salary deduction. Will either one of those two groups have an increased contribution, a shared sacrifice to help stabilize the pension?
Not at this time.
Not at this time, okay. Again, I feel for where you are, Senator. You represent a large urban city, and you obviously need qualified and experienced firefighters and policemen. And I think it is difficult. Would you agree with me that it's difficult for city councils to not vote for a bailout of the pension for city firemen and city policemen?
I think it's difficult to come up with a strategy to address this issue that doesn't put the state of Texas on the hook.
Right.
I think it's real important that these types of problems be solved at a local level. And let me finish. Let me answer the question. And so I think decisions concerning those, as attested by the vote that we got out of the Finance Committee, should be left to local cities.
You're heading exactly where I was about to go. And members, I think you should hear this, because this has to do with a large pension in the state of Texas that is a municipal pension.
Can you have a little order, please?
This is a large municipal pension of city firemen and city policemen. And the city is going to be put on the hook for this to the tune of $600 million that is going to be paid for, as you said, Senator, by the people of Dallas over many years by increased, either less services in certain areas or potentially a raised enhanced tax rate. But your comment was very precise and the one that I am most concerned about. This does not concern my district, but if we were to have this happen across the state, the first place these large pensions that are in trouble will turn is the state, and they will look to the state to backstop them because they are part of the state. Right now, the backstop is the city, but longer term and even in a larger perspective, I am concerned that the state will be on the hook for large pensions that are not being properly managed, as you and I both would say that the current pension in Dallas is not being properly managed. Would you agree with that? Would you say that we're going to be on the hook?
I'm reminded of what Senator Huffman did with the Houston Pension Fund and made certain that the decisions to make certain that fund becomes actuarially sound was handled there in Houston. And by the way, the city's plan will increase the city's contribution by over $3.5 billion over 30 years, requiring some $10.9 billion in contributions from the city over those 30 years based on the new plan that's been put in place, rather than $7.4 billion over 30 years.
If they make their investment returns as projected, that's...
Right, and that's exactly right. And I stood on the Senate floor in meetings with the city, the police, and everyone else, and said that I recommended a change in administration. We changed the governance. I recommend a change in administration. I understand that they fired the administrators and then turned right back around and hired them back. And some of the same assets that was a drag on the pension fund still are in the pension fund. Now you remember in front of the committee, we had the chair of the board and the administrators, and they said they didn't want to just have a fire sale. And that's why we're still in the situation we are in right now.
I heard your strong leadership on it on the dais in finance, and I remember actually the issues in your leadership back in 2017. And that's why today I'm going to respectfully be voting no, because my concerns are greater than just this being a local issue. I think it has broader, longer-term concern regarding the state having to backstop municipal pensions that are very lucrative and very generous to the pensioners, and that when they get in trouble, they come first to the state to try to extract more from the city, and if that doesn't work, they look to the state to backstop them in totality. And I am concerned that we need to make a very clear, and I think there's a bill that constitutionally mandates that the state cannot step in. I think Senator Huffman has authored that constitutional amendment, and I hope you're going to be voting for that. I think you are, as I am. And I am concerned about the long-term viability of all pensions, municipal as well as state pensions, in the sense of overpromising and having taxpayers on the hook for those promises, not dissimilar to Social Security on the national level.
I understand.
All right. Thank you, Senator.
Senator West moves suspension of the regular order of business on Committee Substitute 1527. There is objection. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Creighton.
26 ayes and 4 nays. The rules are suspended. The chair lays out on second reading Committee Substitute Senate Bill 1527. Secretary, read the caption.
Committee Substitute Senate Bill 1527, relating to the administration of contributions to and benefits under the public retirement systems for police and firefighters in certain municipalities.
Senator West to recognize for a motion.
Move passage to engrossment.
Senator West moves passage to engrossment. There is objection. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Creighton.
26 ayes, 4 nays. The bill is passed to engrossment. Senator West, you recognize for a motion to suspend the constitutional 3-day rule.
Move passage of the 3-day rule. Suspension of the 3-day rule.
Senator West moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook.
There will be 26 ayes and 4 nays. The rules are suspended. Chair lays out on third reading and final passage of committee substitute for Senate Bill 1527. The Secretary will read the caption.
Committee substitute Senate Bill 1527 relating the administration of contributions to and benefits under the public retirement systems for police and firefighters in certain municipalities.
Senator West, you recognized for a motion.
I move final passage of committee substitute Senate Bill 1527.
Senator West moves final passage of committee substitute Senate Bill 1527. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Craig.
26 ayes, 4 nays. The bill is finally passed. Congratulations, Senator West. Senator Huffman, you're recognized for a motion to suspend the regular order of business on SJR 57.
Thank you, Mr. President and members. At this time, I move to suspend the regular order of business, take up and consider SJR 57. Members, unfortunately, many of Texas's local pension plans are struggling to address serious funding shortfalls. According to the latest calculation by the Pension Review Board, 21 local pensions have amortization periods of more than 30 years, which means they could not pay off their unfunded liabilities within a standard 30-year period. The unfunded liability of these 21 systems is over $6.4 billion. SJR 57 amends the Texas Constitution with voter approval to make absolutely clear that the state is not liable for any debts or other obligations of a local retirement system. Although the Attorney General clarified in an opinion from 2016 that the state is not on the hook for local pension debt, questions continue to arise about the state's liability for local pension problems in some of our municipality. SJR 57 prohibits the legislature from appropriating funds to a local retirement system to pay off any debts or obligations. With that, I move to suspend the regular order of business.
Senator Hinojosa of Hidalgo, for what purpose?
Will the senator yield for questions?
Senator Huffman will yield.
Yes.
Senator Huffman, on this issues and decisions that are made with local pensions, they're not made by the state, are they?
Correct, they are not.
They're made by local public officials.
Correct.
And those are usually made in negotiations with either police associations or other employees.
Correct, and none of them are designed to include state resources or state obligations. However, we do know that many times local municipalities or counties can come to the state asking for help with specific problems, and this is just to preclude that from ever happening by putting it in the Constitution, or unless the Constitution was amended again, of course.
And of course, one of the biggest risks that the nation actually faces liability is that many pensions they're not actually sound throughout the United States.
Right, that it is a nationwide problem. Though we have worked to correct that at the state level, we still have a ways to go, but the local levels are not quite there.
Well, instances where they commit
upheld a when you're gone.
That's correct. Thank you, Senator.
Senator Schwarber, for what purpose?
No.
Ask questions of the author. Senator Huffman, do you yield?
Yes.
Whoa.
Thank you, Mr. Chairman, or Mr. President. And
You hear us? You fuckers.
I think this bill is
Don't talk to our viewers that
I don't think it's on there.
the body
obviously a strong supporter of it. Just for clarification, say you have a whole group of municipalities because of
it's registering something.
A severe economic downturn, market downturn, and you have
They hear us. You just
in trouble. Big pitches.
can't believe you would talk to our supporters that way.
Barely. See, I don't think it's coming through.
Something's coming through.
The Capitol and get the 150 members of the House and the Senate to reverse what we do today, passing this out if this were to become law or become a constitutional amendment passed by the people of Texas, or the people of Texas still would have to also ratify any change that they would do. So there is
Can you hear us now? We're talking.
The voters ratifying that.
There is a way
Talking shit.
We're talking a lot of shit over here.
A lot of shit, Sarah.
To bail out if necessary, but it would require multiple steps. And
All right.
All right.
Maybe I need to put this up a little closer.
Oh, you know what it could be? It could be.
Get the volume too high on this.
No.
Well, that's
What about now,
low.
Sarah?
As we know, most of the recipients
It
of
could
the
be this.
pensions are
Is it picking up the
I don't know.
speaker?
Suck it. Introduce yourselves again. You suck it. All right, I think we're back from a short break. I want to talk about SCN. I don't know, what does that mean? See if this is moving though? I don't think it...
Is that not us? When we talk, it moves? Uh-oh.
Oh, Scientology. Yeah, hold on. Let me see if it's picking up on Jackson. We can talk about Scientology.
All right, so I guess, where do I begin with Scientology? Probably have some things I can't talk about, client stuff, but I was in the courtroom back in 2013. It was a month after I got licensed. There was a hearing on whether or not David Miscavige was going to be allowed to be deposed. And the judge comes up there and he says, I find a colorable basis to take the deposition of David Miscavige, which said, so to give you a little context, this was in Comal County, Texas. So just, if y'all aren't familiar, it's a county north of Bexar County, which is where San Antonio is. This is when I was practicing in San Antonio.
Give me that microphone.
Is it coming? Hold on a second. I gotta.
Still picking up with that.
We have to do a little technical. We got some technical difficulties here, but we're working on it. So, Comal County, the city. We're in New Braunfels, it's just north of 2013. Comal County. Judge, I won't. Y'all can probably look this up. I won't say names of people. But the judge said that we could take David Miscavige. He said his name wrong. Can y'all still hear me? We're still kind of working out some microphone issues.
Huh.
Are we still coming in? Okay, all right. So they can hear me.
It's not as loud though. I don't know if it's picking up on another...
Is it because, I've got this closer to my face this time. So...
David Miscavige.
Okay, we got the emoji. They got the ear. Okay. So, to put it in context, my firm, it was a commercial litigation firm. We probably had about 20 lawyers. And in these Scientology cases, sounds like before, what does that mean? Like not good or good? Give us some feedback here.
Sounds like before. I think she means like prior to today. That's
okay.
Good.
Okay. So there was our firm, and there were technically two other firms on our side, and there were two solo lawyers, good guys down in San Antonio, still friendly with them. And on the other side, we were suing a bunch of Scientology entities. So like half the courtroom in the gallery was filled with these lawyers. They were paying a lot of money to their lawyers, if you can imagine.
All right. What happened?
So the main hearing was, what Scientology was saying was that David Miscavige had nothing to do with any of the allegations of harassment and various things that were going on in the lives of our client. And our client was married to a guy who was a former high-up member of the Church of Scientology, and then he left. So after we got the order saying we could depose David Miscavige, they filed, and I think we probably have mostly law people here, they filed what's called a petition for writ of mandamus. And that's in a discovery dispute. You can ask the appellate court to make a decision about whether or not the judge has made the right call on allowing, deposition or certain discovery. Well, they were saying that it was what's called an apex deposition, and that's an apex deposition would be taking the deposition of a high-ranking officer in a company, and case law probably goes back to the 80s where they said that was harassment, and you had to show that there was a need that other people in the company couldn't answer before you go all the way up to the top. Our position was, we're not taking his deposition because he's an officer or the CEO or whatever they wanted to call him. Although you'll hear that some people refer to him as the Pope in the next, during this hearing. But, we were saying that he was, in fact, responsible for it. Like, he was calling the shots, and that's just the way it was. We had affidavits, all that stuff from people who used to be in the church who left, who were also high-ranking members. Anyway, David Miscavige had a lawyer named Lamont Jefferson, who was his trial counsel. And at the time, Lamont was at the firm called Haynes & Boone. And he was a very well-known lawyer. Lamont's brother is Wallace Jefferson, who earlier in 2013, in the summer of 2013, Wallace Jefferson retired as the Chief Justice of the Texas Supreme Court. First African-American, I believe, on the Texas Supreme Court. Certainly the first African-American Chief Judge. Somebody knows a little bit more. Yeah. What
does Sarah say? He's the chairman of the board of RTC, but he's also an individual.
So I'm going to have to know, what do you know about Religious Technology Center? So you're knowing stuff. There's
Sarah
stuff
knows all.
Sarah, all right, Sarah. So that was Religious Technology Center was one of the parties. And that's what their argument was, hey, he's the chairman of the board of RTC. He's not involved in CSI, Church of Scientology International. So Lamont Jefferson represented RTC and RTC and Miscavige. Which lawyer was that? Who was appointed by Trump? Was it Wallace Jefferson? Was Wallace Jefferson appointed to something?
I don't know who that is.
So I'll explain to you Wallace Jefferson. So Lamont Jefferson was trial counsel. Wallace Jefferson was formerly the Chief Justice of the Texas Supreme Court. He retired that year. And probably one of his first appellate cases after retiring from the bench was this mandamus. And our Court of Appeals in that case was actually the Austin Court of Appeals, not the San Antonio Court of Appeals. And they said that it was an improper apex deposition. I still believe that was the wrong decision, because
Sounds like it.
the guy was involved. Like, we're not saying that we're trying to depose him because we just want to get after the top of the company. I mean, he's the guy who's in charge of everything, calling the shots.
He tells everybody what to do.
It's not like AT&T CEO that he probably doesn't know what's going on with these handhold covers, for example. I don't know anything about that, but
never heard of it.
Sorry, I'm just reading the comments here, the live chat. Okay, the ones that create the. Oh, I see. So, where was I going with this? Oh, and they filed an anti-slap motion. That was the first.
Oh shit!
That was in 2013.
With fees on that thing.
Dude, 2013 was the year they past that. So Scientology, actually, they usually, not to overuse this, but delay, deny, defend. They don't just delay, deny, defend. They go after lawyers. In this case, they file motions to disqualify us. A lot of that was done before I graduated law school in 2013. Took the bar exam that summer. So a lot of this was happening before I was even at the firm. So they filed the anti-SLAPP. It was the first time they could do it in Texas. So they changed, because it just passed.
Right.
So they changed their tactic by, instead of denying it, they said, yeah, we did all of this stuff, but it was in relation to our First Amendment rights. So that also, the anti-SLAPP statute also has an interlocutory appeal.
Mm-hmm.
So they filed an appeal of that, which stayed the proceedings. We won that. I was up.
Really?
I went to watch the oral arguments with our partner at the time, who was a.
Do you win fees for beating an anti-SLAPP?
I don't know if we got fees on that. I'm sure I would have remembered then. By the way, I was there. I did a lot of the initial stuff on the briefs that went up to the one partner, that went up to the next partner. So, I was probably more involved in it than maybe some associates at some firms, but I would be typically. But, I wasn't talking to the media, that's for sure. I was like a 6-month lawyer. But I could still remember one of the partners screaming in my ear in the phone. I could hear him down the hall and in my ear, because about what time the objections to something had to be filed that day. And a legal assistant threw a hissy fit because she didn't want to stay around because it was like Valentine's Day or something, and we needed to get something filed. So from that point on, I learned how to use eFile Texas, so I didn't have to rely on anybody anymore. So, there was, I left the firm before that whole thing resolved. It resolved into, there's some, probably some things I won't get into about how it resolved.
Do you know how the case settled? Is there a confidentiality? I guess you wouldn't know, you weren't there. You left before the settlement was reached, right?
I don't think it was ever settled. Well, so I don't know. I know the case is no longer on file, and it was dismissed.
So they lost, or Scientology won.
In some, well, again.
Oh, shit. It's not on. Oh, wait, we're good.
I'm just looking at the.
They must have won something.
Again, because I don't have firsthand knowledge, I'm not going to speculate.
Can we find on the docket? Or was it sealed?
If there are things on no, probably not sealed. That would be it's too hard to seal stuff. Unless TLR wants to come in there and change the Texas rules of civil procedure on how it's sealed.
76A.
Yeah, exactly. That's basically what they're doing here, right? It's just changing the whole rules of evidence. So I had a trial 2 weeks ago, and for those of you, again, who are listening and don't maybe not know, most people here seem like are legal folk and know some things. So when you sue somebody in court, especially in a personal injury case, but probably other types of cases where there might be insurance, it's just the litigants versus each other individually. You can't mention insurance. That's not allowed to be spoken.
Except health insurance now.
Right, so collateral source comes in now. But at the end of my trial, I talked to some of the jurors, and they were worried that this poor old lady would have to pay this judgment. They wondered, actually, one of the only question, there were 2 questions that came out of the jury. One of them doesn't count because they had just asked if they all have to sign it or not. But
interesting.
Another question was, is there insurance?
How do people not know that?
So, but look, that's what they think. They think like, or they come up with, remember, jurors fill in the gaps.
Yeah, that's right.
They fill in the gaps that you can't give them information on. So, I was out there talking to some of the jurors with the opposing counsel, defense lawyer, and they couldn't believe that you're not allowed to talk about insurance. Because again, this is afterwards, so we can tell them everything. Right. And I made some comment, I was like, well, who do you think makes the rules? And the defense lawyer's like, oh man, these are the, this is the rules of evidence, man. And I'm like, yeah, and
Drafted by
insurance companies, and that's what the jurors were on my side. They're like, yeah, totally. They're like, yeah, we know who. So that's another story. That's another trial advocacy. You've got to figure that one out. If it's a big company, they're not so worried about, who's going to have to pay the bill. Although they might if the defense lawyers can seed, put seeds of this is going to raise all the prices in.
Yeah, if they could say that during the trial. Dude, it's freaking almost 4 o'clock. What time does the Senate close every day?
I don't know. I'm surprised they're there right now, actually. I mean, I don't think they're going to get to talking about...
I guess it's left pending, right? If they don't...
If it's left pending, does that mean it doesn't go to vote?
The hours...
Okay, so if it's tabled, it doesn't go to a vote.
Happened to Medicare?
So, all right. So the science. There is some other interesting, and again, what I know, there was another case that my firm had been involved in before I might not have even been in law school yet, and it involves that person who was supposed to take over after L. Ron Hubbard.
Tom Cruise.
So basically, my understanding is that there was essentially a coup. That was Miscavige was like 20-something, like early 20s, and L. Ron Hubbard was on his deathbed, and basically staged a coup with the Church of Scientology. Which, yeah. So, what is it? Pat Broker? Is that how you say his name? So, I need to find there's an article somewhere, because there was a case that was resolved confidentially that involves that story of forcing Broker out of the church.
Holy crap, hold on, pause. There were 60 registered witnesses to testify today against
60
on or against SB 30. Just read on Twitter.
That's a lot.
60 witnesses today just for the Senate.
So maybe they'll table it.
Sorry, keep going.
So, okay, so Miscavige had him follow for the rest of his life. That is true. And there was a lawsuit about that, about those guys who were paid to follow Broker. There's an article somewhere, I think it might be on Underground Bunker, that talks all about that. And talks about the lawsuit. It's a little
What's
bit
Underground Bunker?
It was like a journalistic website that was dedicated to essentially exposing Church Scientology. Miscavige made a few mistakes with the folks that he hired to follow him, and again, like I don't know if there's going to be a assassin show up at my house now for talking about this. Again, there's stuff
out
online.
of the 6 people watching right now, it's possible.
5.
Damn it! Senate Bill 875.
But it sounds like at least one person in our viewership knows a lot of these stories. So yeah, my firm had. There you go.
Okay, so I got you.
So, I mean, we had people. All right, so you probably know the name Mike Rinder. Mike Rinder was somebody who was support. He signed declarations. I'm trying to think of some other guy. I mean, Mike Rinder was a big one. I mean, he was like their big spokesperson.
Yeah. He's dead now.
Is he? Do you follow the Scientology stuff?
No, I just Googled his name.
Oh,
It says
okay.
He's dead at 69.
Okay.
I recognize his face from the documentary.
So yeah, Rinder was he was helpful. I mean, a lot of these guys really kind of stuck their necks out there to help us in that case. You know.
Oh wow, that's awesome.
Yeah, I won't get into too much about the partners who I work for at that firm, but very difficult dealing with them. But I will say he didn't back down.
It's badass.
You know, he probably needed to treat his associates better, but that's another story. Come on, drop. Yes. So I'm also watching the Orioles right now. So. It was the first game in Camden Yards of the season. They played a 4-game series in Toronto, split the series. Camden Yards is the most full it's going to be until maybe October if they make it.
Yeah. I always like the Orioles mascot.
Dude, I should have worn my hat.
Yeah.
Oh man! Oh, nice. Sorry, I'm sorry, everybody. I'm looking at baseball things. I shouldn't be yelling in the mic.
Because the Senate will not cover this frickin' hearing.
Is it not? Are they not having the hearing?
Not yet. I mean, they haven't adjourned this bull crap.
So it's not like in another room or anything?
No, it's not in another room. I know that. Because that's what I've been checking on the other.
Good. I'd let them waste their time then.
Yeah, I guess it is good for us. Check detail items.
So my case, I will say what the case name was. I won't say who anybody is. Well, I can say what the case name. It was public record.
It is public record.
The case was Rathbun versus Church of Scientology International et al., including RTC and Miscavige and some private investigators.
David Miscavige.
Yes, I know that name. She was the plaintiff. And 2 of the 5 appellate briefs I've worked on in my career were in that case.
Somebody on a website which will not be named. Venting on social media may be cathartic in regard to this bill. May be cathartic, but it's non-productive and counterproductive.
Huh. Who was that?
Somebody who's not watching our YouTube, I'll tell you that.
Or are they watching our YouTube?
No.
They're talking about us. Oh. It's him. I like him very much.
Not anymore.
Why are people, oh man, the O's got to run. We got somebody who wants to hear your pronunciation of Miscavige.
David Miscavige. That's how that guy,
Rinder?
who helped you.
Rinder?
Rinder pronounces
Is that a South African accent?
In that documentary with Leah Reimer or whatever her name was. David Miscavige.
So, but my favorite pronunciation was actually the judge who said David Miscavige.
Miscavige, yeah, Miscavige.
I'm sure you had a big old dip into. He's like, I find a colorable basis. I don't think he did. I don't remember them doing that.
Do you have a platoon?
Spittoon. I find a colorable basis. Take the deposition, David Miscavige.
That's good.
So I'm not. Hold on one second. I still have to also run my law practice, so I've got to respond to a message here.
Well, don't waste your time.
All right. I got to come down to Dallas. I'm just kidding. I'll be happy to have lunch and chat all about it. I mean, what I can. I'm not going to talk about things that are not. I mean, most of the things I know. I'll say I left the firm when the case. I don't know if when it was over. Like that happened after I left the firm. So, I mean, I can, again, tell them things about what happened in the courthouse and things like that. If that's public record, I can talk about.
I have to go pick up the kid from school.
You're going to walk around with your mic? Do you have a question about where your office is?
Who does? Where's your office, Jim? It is at Hillcrest and 635, unless you're with the Church of Scientology coming to kill E.T. Well, our coverage today is sadly going to come to an end.
All right, our coverage is sadly coming to an end here. But Jim, if you want to, lunch and Scientology talk,
hell yeah,
he can help set that up.
If you want to hear more, if you've enjoyed the stream today, let us know in the comments.
Also, I'll give you my plug for I'm a plaintiff's attorney, personal injury out of Denton, Texas, Tepperman Law, PLLC. Represent folks just like Jim does, dog bites, 18-wheeler cases. I've tried an 18-wheeler case. I've tried
True justice.
True justice.
Just like the bill we're going to be left pending.
That's right.
Over and out. Thank y'all for tuning in.
I had a good time, everybody.
Bye-bye.
Jim, thanks for having me.
Hey, thanks for coming, man. This is